It does. Okay. Oh, look at this. This is glorious. Okay, now Towel Friends on the first stream. The second stream is live. Okay, so all you have to do is hop over. We are going to overtime towel mode. Now I have to end the first stream, so hold on. This is going to be a very delicate exercise for Towel, but I'm going to figure it out. So I go over to this stream. Now Towel Friends on the first stream. God bless you, Towel Friends. God bless you, Towel Friends. We are switching over now. Come join us. I am a towel. All right, here we go. I'm clicking the button. So this stream is ending. We're going to travel over to the other channel. Here's the link one more time. Go teleport little towels. I'm clicking the button in, let's see, we'll do it at the 7:50 exactly. Okay, ready? Now, I'll see you at the other stream. That was a wild experience. This stream is now ending. Well, I'm talking to two streams at once, so the people who are on the other stream, don't worry. But if your stream is about to end, it is a very delicate process. Okay, the first stream is over, so if you are still watching, you have made it to the new stream. We did it! Overtime Towel. Oh, goodness, ladies and gentlemen. Welcome. Hello, Nekabee. Those of you just tuning in, we are actually just shifting from stream 1. We are now on stream 2. We have never pulled this off before. It's a towel miracle. This is great and amazing. So, no, you're here. You are at the right stream. If you are in the chat right now, you are at the right place. You made it. If the stream is still going, you did it. Good job, everyone. Thank you for Flying Air Towel. We literally just did a mid-stream towel refueling. You don't understand. We transitioned planes mid-air. Thank you for cooperating with your fellow passengers on Air Towel. You have all made it. I did not break the space-time continuum. I'm thrilled to announce that everything seems to be okay. This is better than finding out, ladies and gentlemen, that that the cake was not actually a lie. Now, I do have one piece of information I have to tell you, which is I actually have to open up the stream that we're watching. So I'm going to do that because that's the only way your new comments are going to show up on the new feed. Now, Towel Friends over on the X, you didn't have to do anything. X lets you go for hours and hours. But YouTube, I have to switch the stream or it will cap the recording. Now, listen, ladies and gentlemen, I'm thrilled. We have all made it through. I'm thrilled to announce that Air Towel has landed successfully, and we are about ready to get back into talking about Rachael, Rollins, Josh, Levy, Dustin, Chao. Now, if you've missed it, we are going to jump back into reading a DOJ OIG report about how Rachael Rollins, Josh Levy, and I believe a man named Dustin Chao basically weaponized the United States Attorney's Office against people they didn't like. And then, in the context of a pretextual probe into the Suffolk DA Kevin Hayden, who Rollins didn't like because while she was U.S. Attorney, Rollins tried to help her ally, Ricardo Arroyo, win the seat for Suffolk DA against Kevin Hayden in a primary because Arroyo was more aligned with Rollins' style of prosecution, which was soft on crime, and she apparently hated police, which is very clear now from this OIG report. She really didn't like cops. And except for the MBTA cops, and even then she was willing to throw them under the bus to help Arroyo. And really more to get Hayden. But then, ladies and gentlemen, this report really shows that Rollins wasn't just willing to weaponize her office to help Arroyo win. When Arroyo lost, or when it looked like Arroyo, I think when Arroyo did lose, or when he looked like he was going to lose, Rollins tried to open up because stuff came out about Arroyo having been accused of sexual assault and other things. It was very serious right before the election. So Rollins then opened a probe into Hayden, but Rollins couldn't do it herself because she kept getting told by ethics officers that she needed to recuse herself. So she had Levy try to do it for her. But clearly they got caught. Now it's Josh Levy. Now what's even more wild, ladies and gentlemen, is we just read a part of the report. We're actually going to go back and read this part again, and that's where we're going to start off this stream. We're picking up in the report where a law professor, who I believe was Daniel Medved from Northeastern, emails Rollins and says, hey, you should open a probe into the Suffolk DA. And weirdly, right around then, apparently Rollins agreed to go to a book signing for Medved. later, a few months later, which she wasn't able to do because ethics officers stopped her. Now, what's really interesting about this, ladies and gentlemen, is it looks like Rollins might have done that with Michael Morrissey in the probe into John O'Keefe's death as well. And that's why David Yannetti, Karen Reed, and Alan Jackson in November of 2022 were able to walk into Levy's office, because Levy was really operating in Rollins' interest, and Rollins wanted to get Michael Morrissey due to a grudge that traced back to Rollins' time as Suffolk DA, when Morrissey commented publicly on how Rollins was soft on crime, and then also Rollins wanted to prevent youthful offenders under the age of 25 from getting life sentences, and Morrissey commented on that as well, which pissed Rollins off. So Rollins had a long-standing grudge. Dustin Chao had a grudge against Morrissey because Dustin Chao, his wife in 2015, got passed over for a promotion in the Norfolk DA's office and had a grudge about that. And so Chao apparently went around at the time saying he was going to do whatever it took to burn down the Norfolk DA's reputation. Now, what makes it really weird is that law professor we're about to hear about, Daniel Medved, in 2019 or so, maybe a little later, had filed an ethics complaint against Dustin Chao. It could have been even more recent, related to Chao's time in New York as a prosecutor. So why is Medved simultaneously helping Rollins go after Kevin Hayden while having filed an ethics complaint against Dustin Chao, who's working in Rollins' office for the public integrity section while Rollins was U.S. attorney? Does it all make sense, ladies and gentlemen? I saw that Karen did start probation today. But yes, so now if you can see the chart up on your screen, that is my towel chart. Rachael Rollins at the top, Michael Morrissey at the top, investigation of John's death, pretextual, goes nowhere, but they stumble onto this state police unit, Tully, Proctor, Buchanan, John Fanning, whatever. Who's that other guy? I don't think Garino did nothing wrong. He seems all right. Nick, whoever you are, wherever you are, I've never met you, you're all right. Kate Peter knows about this stuff, needs to protect the narrative, in my opinion, so she's their little person. All right? She's their little Oompa Loompa man on that side. She can be the Oompa Loompa of that side. But, ladies and gentlemen, the investigation of John O'Keefe's death over the summer of 2023 doesn't uncover anything bad about that, the federal probe, but it does uncover, I believe, Sandra Birchmore's murder cover-up. Now, Sandra Birchmore on February 1st, 2021 at 9:23 p.m. was allegedly murdered by former Stoughton police officer Matthew Farwell. Sandra's body, unfortunately, was discovered on February 4th by 2021 by the Canton police. Now, in the 48 hours after Sandra's body was discovered on February 4th, 2021, the Canton police uncovered evidence that Matthew Farwell was the man at Sandra's apartment at 9:23 p.m. on video, which was exactly when she was murdered. Then they found out from people at Sandra's school that Farwell had been talking about taking care of the problem because Sandra was pregnant with a baby that she told Farwell was his, and she was refusing to get rid of it, to not carry it to term. That was the term in the text, get rid of it. But it turns out just a few months ago that the baby wasn't actually Farwell's. It's possible there was a ring of cops abusing young girls in Stoughton. That will a ring of Stoughton cops abusing young girls. That will come out later in the story. But anyway, so February 4th to February 6th, 2021, the Canton Police uncover a substantial amount of evidence, which you can find laid out in the Canton Police Department audit, I believe on page 78, maybe into 79. So anyway, the Canton Police in those 48 hours uncover a litany of evidence indicating Farwell killed Sandra Birchmore. On February 6th, the state police, because all murders are in the original jurisdiction of the state police, take over the investigation. The state police that investigate the Sandra Birchmore's death is the same unit that was detailed to the MSP and investigated Karen for John's death. Now, the unit involved, is the person who does the investigation of Farwell is a guy named John Fanning. John Fanning used to work in Stoughton, where Matthew Farwell was working. At the time, he was in an underage relationship with or he was involved with Sandra when she was an underage girl. Now, also a person who used to work in Stoughton, I believe, was Yuri Buchanan, who also works on this MSP unit that investigated Farwell and Karen for John's death. In turn, somehow the MSP unit, despite all this evidence from the Canton PD, writes a report in 2021 or 2022 indicating that Sandra died as a result of self-harm. Now, fast forward to the summer of 2023, so fast forward to November of 2022, no one had done anything about Sandra Birchmore's death, but Karen walks into Josh Levy's office, probably as a favor for David Yannetti from Rachael Rollins, because Rollins didn't like Morrissey, and yet Yannetti's spinning this yarn about John's death and all this, but but the feds look into it starting in the summer of 2023, May, June, July 2023. It goes nowhere, but you can see this prosecution style. Like, they want to get you. Like, Levy wants to get you. He'll get you. Like, he'll find a way to get you. And so they probably stumble onto Birchmore. The Birchmore cover-up, the probe starts in August of 2023. That's why the Reed investigators are freaking out that whole time about the federal probe, because they knew it wasn't about the Reed case. It was, and John's death. It was probably about something else, and it was really about the cover-up of Sandra Birchmore's murder. And that's why I think Matthew Farwell is probably going to have to cooperate, which means there's probably more indictments coming, which means that's going to become the big story, because there was a cover-up. It just wasn't about the investigation of Karen and John's related to John's death. It was actually a cover-up of Sandra Birchmore's murder, because there was a very big incentive, I believe, for the Stoughton police and the people in the orbit of Stoughton police to cover up this ring of cops that was abusing young girls. It wasn't just about Matthew Farwell. It was about all the cops that were related to that situation, and probably a ring of girls who were being abused, some victims, I imagine, who are still alive. In short, ladies and gentlemen, there was something there, and that's the only reason Rollins probably only got in trouble for the Hayden thing, because unlike with Hayden, where there was nothing there at all, at least with the John O'Keefe and Karen Reed probe, Levy and whoever could spin it as, yeah, well, Rollins wanted to get Morrissey, and Chao wanted to get Morrissey, but we stumbled onto the cover-up of Sandra's death, and that's enough. So, yeah, that's what I think happened. Does it all make sense, ladies and gentlemen? Rollins is up here on the left. This is Rollins. Rachael Rollins accused 4 other DAs of misogyny for inserting themselves into Suffolk County DA business. They say this isn't the case. So, and I can make her picture larger, but that's her. See? Right up there in the top left. And I got this whole thing, ladies and gentlemen, and that's why we're going back. We're going to start actually a little bit higher up when the law professor comes into this. So we're going to start right here, okay? And this is August of 2022, I think. So this is right before this all goes down. So get ready. I have a wonderful way to do this. The only thing I have to do, towel friends, is get your new comments up. I'm sorry they weren't up on the screen. One second. Here it is. Look at that, towel friends. Now, let me just scroll your comments so I can show. Hold on. Is this the right one? Nope. I'm going to get rid of this one. Hold on. Going to get rid of that one. All right. Now, you have your new towel comments up on the screen. There we go, towel friends. I'm sorry it took me a second to get that going. So all your wonderful comments while I was on my spiel there didn't actually show on the screen, but I have a towel backup plan. Ready? So this is all your comments. Look, you all did make it. Hello, towel friends. The towel miracle. The towel plane has landed. No layover at all. No time to spoke. Iran has apparently agreed to the ceasefire, but Israel apparently has not, I heard. But we need to get that confirmed. Hello, towel friends. Yeah, like what ceasefire? And then Karen is apparently on probation after today. Interesting. Very interesting. All right. I told you where Rachael Rollins fits in. All right. Let's see. Hello. Oh, look at all these towel friends. We're doing a special nighttime stream. Primetime towel, ladies and gentlemen. We're calling it Primetime Towel. Very rarely to get Primetime Towel. This is a unique special opportunity to chat with the towel friends, to hang out. There's more of you watching now that were watching on the other stream, I guess because it sent out a new notification. But you know what that means, towel friends. I have our written version of the document we're going to read. I have the spoken word document. We have our towel friends. I'm excited. You're excited. Have you considered that I am indeed a towel? All right, let's get on it. I got to get back to where we were in the document. Hold
the first
on.
assistant's email to
Hold on.
assistant.
No. We got to go backwards. There's going to be a little bit of reading that occurs here. Hold on.
24 subsequent to agreeing to participate in the law professor's book event, and while the ORG investigation was ongoing, Rollins told us that she was acquainted with the law professor before he sent her this letter. Rollins told us that she did not.
All right, you ready, ladies and gentlemen? Get comfortable. Get your towel snacks. You can call me Thomas Jefferson Towel. I am playing the role, ladies and gentlemen. I am playing the role of towel congressperson. In our mock simulation, I have a towel gavel. We are listening to Chao be presented a 161-page report by the DOJ OIG in our mock simulation. I am banging my gavel. We shall come into session. Madam Clerk, you may indeed begin your reading. It's actually, yes, it's Madam Clerk. We have a female
3 August
reader.
16 to 17, Rollins receives letter from a law professor calling for federal investigation into Hayden, and Rollins consults Earza about her recusal from such an investigation on the 16th of August. A Boston area law school professor, emailed a letter directly to Rollins requesting that the MAR-USAO commence an investigation into potential improprieties committed by prosecutors in the Suffolk D.S. office. Referencing the Globe reporting, the letter stated that recent media accounts revealed troubling information that could potentially indicate public corruption and / or other illegal activity committed by Hayden and his first assistant DA. The letter attached a timeline of facts reported in the Globe regarding the donations that the former transit officer and his attorney made to Hayden's campaign and the alleged statements of Hayden's first assistant DA to the former transit officer's attorney that the former transit officer was no longer under investigation, which the law professor said he had not independently verified. The law professor ended his letter to Rollins with, "Please feel free to reveal this letter to the public and / or media if you would like to do so." When we asked the law professor what prompted him to send his letter, the law professor stated that one focus of his scholarship is prosecutorial accountability, and he found the allegations against Hayden concerning. The law professor stated that he was also concerned that no other DA officers would seriously look into these allegations, and he, therefore, wrote to the U.S. attorney hoping his letter would prompt an investigation to determine what actually happened. The law professor, who referred to Rollins as a friend in emails we reviewed, told us that he did not speak with Rollins about the issues raised in the letter before he sent it. Rollins told us that she was acquainted with the law professor before he sent her this letter. According to Rollins, the law professor is a progressive who had written articles in defense of her and her policies when she was Suffolk DA, and she estimated that they have contact every 3 or 4 months. The personal email communications Rollins provided us indicate that on the 15th of August, the day before the law professor sent his letter requesting an investigation, the law professor sent Rollins an email seeking to confirm her attendance at an event on the 21st of September, 2022, promoting his new book, which Rollins confirmed by email the same day. The emails between them did not mention the law professor's intention to send her a letter requesting an investigation. 24 Rollins told us that she did not recall the law professor giving her advance notice of the letter and that she can affirmatively say that she did not solicit any letter from him. She said that she would leave open a slim possibility that he called her to complain, as people sometimes do, and that she told him to write her a letter, as she sometimes does, but she said she had no memory of that happening here. Call detail records of Rollins's personal cell phone, DOJ cell phones, and desk phone do not show any calls between the law professor and Rollins during this time period, and Rollins's attorney represented to the OIG that her personal cell phone did not contain any text or instant messages with the law professor during this time period. Rollins told us that her reaction to the law professor's letter was that she felt compelled to contact the Earza General Counsel a second time to discuss what to do. According to Rollins, it was significant to her that someone was now asking her office to open an investigation. She said that she felt she needed help from Earza at this time to make sure that she did not taint any future investigation. When we asked her whether she expected the department to recuse her from any investigation of Hayden, she said that she assumed she would be recused. On the evening of the 16th of August, Rollins forwarded the law professor's letter to the Earza General Counsel stating, "I just received this letter. We will not respond until you and I have a discussion. Sound good?" Rollins and the Earza General Counsel ultimately spoke around 2 p.m. on the 17th of August. The Earza General Counsel told us that Rollins sought his advice on recusal because she recognized the appearance of a potential conflict of interest. According to the Earza General Counsel, he advised her that he thought her entire office should be recused from any matter involving Hayden, and Rollins agreed. According to Rollins, she told the Earza General Counsel, "I don't like being recused from things, but if you think I need to be, I understand that." Rollins also stated that the Earza General Counsel asked her to have her first assistant send his office a written request for an office-wide recusal to begin the recusal process. The executive officer told the OIG that at some point in August, after receiving the law professor's letter but before the MAR-USAO received a formal recusal memorandum, Rollins asked the executive officer if the executive officer had received any media inquiries about the law professor's letter. According to the executive officer, she told Rollins that there had been no media inquiries, and Rollins expressed surprise at that fact. 24 Subsequent to agreeing to participate in the law professor's book event, and while the OIG investigation was ongoing, Rollins sought ethics advice about her attendance at the book event and ultimately did not attend after ethics advisors in the MA USAO expressed concerns. 4 August 17 to 18, discussions.
You understand what happened there, right? The professor, they couldn't prove it, but the professor clearly was like, I'll write this letter for you if you come to my book event. And then she was like, okay. And then she wasn't even able to go in the end because they caught her. That's crazy. And if you're just tuning in, a great request from and amazing support from our super towel, Havid Yad, who's literally flying on air towel, watching us live in the air. Ladies and gentlemen, if you're just tuning in, we are reading the May 2023 DOJ OIG report into Rachael Rollins, and Josh Levy's also involved, and Dustin Chao. And if you're wondering why we're reading it, it's actually a great opportunity as we're looking at this for me to bring up a post I made a little bit earlier today. And Rachael Rollins actually started this. I didn't see the post until earlier today. Rachael Rollins started this by making a post on Twitter. You can see it right here. Without Turtle Boy, this was on June 18th of this year. Does anyone know or care about the KR trial? His relentless reporting in the face of repeatedly being told by law enforcement that he was wrong and there was nothing to see here cracked this case wide open. That should not be lost in all of the reporting. Yeah, so that's wrong on a number of levels. One, there was nothing to the John O'Keefe case. It's closed. The only reason I think Karen got off was because of a manipulated jury. That's a topic for the other day. You want to investigate something, Rachael Rollins, write a letter to Leah Foley about that. Maybe I should write a letter to Leah Foley about that. Anyway, so I had some questions for her. Now, by the way, did you know that Rachael Rollins, the former U.S. attorney, and Turtle Boy had a relationship that dated back, strangely, not a physical relationship, a using each other relationship that dated back all the way to 2020 or so? And you might say, why would Rachael Rollins, a progressive, soft on crime person, be friends with Turtle Boy? Well, it's weird. Turtle Boy likes and doesn't like cops. It's weird. It's very weird. But anyway, back in the day, the reason why Rachael Rollins needed Turtle Boy's help when he wasn't much of an anybody is that Turtle Boy knew this woman named Rachael Campbell, who was a Republican spoiler candidate in the election involving Ed Markey, the senator from Massachusetts, and Joe Kennedy Jr. for Markey's Senate seat. It was a primary in 2020. Now, it was weird because Rachael Rollins was talking to Turtle Boy directly at the time and coordinating with him so that Turtle Boy would send Rachael Campbell, who was a Republican spoiler candidate, to Joe Kennedy Jr. primary events so that Markey would win the primary. Now, I don't think it was just about helping Markey, and you might say, why? Well, a few reasons. One, if you take a look at this OIG report, we're going to come back to page 37 of 61. But if you go to the very top, the first thing Rollins did, which isn't as very much as, it's not as interesting for our purposes, but in terms of the amount of what she was doing to influence the Suffolk DA race using her official position and things like that. That is what we were really analyzing and getting recapped on. But did you know the very first part of the report, ladies and gentlemen, which is very much at the beginning of the summary? How weird does this sound? Tell me if it might have actually been the Biden White House who was the beneficiary. And you might be saying to yourself, why would the Biden White House care about a Senate race between Ed Markey and Joe Kennedy Jr.? Well, Joe Kennedy Jr. was representing the 4th Congressional District in Massachusetts at the time, which I think is the seat currently held by Jake Auchinclosh. Now, JFK, when he ran for president, went from the then 10th Congressional District in Massachusetts, which was, I think, he had his headquarters down Oak Square in Brighton near Lake Street down there, near BC, of course. Now, JFK wins that. Then he goes to the Senate seat, JFK's Senate seat that Markey currently holds, and JFK runs for president. Joe Kennedy Jr., if he had won that Senate seat to get foreign policy experience, which you get in the Senate, he would have, I think, primaried Biden in 2024, which probably would have been better for the Democrats than the Biden-Kamala Harris catastrophe, but that's neither here nor there. Now, you want to know what's weird? Rollins attended a Democratic primary event, a Democratic fundraising event while she was USAO that got her in trouble. Now, would you like to find out who exactly she went to attend an event for? How about Dr. Jill Biden? Ladies and gentlemen, do you think Rollins did indeed and you can read it right here, ladies and gentlemen. The report describes, this is only the first part. The report describes an investigation by the DOJ OIG that began with allegations concerning the presence of U.S. Attorney for the District of Massachusetts, Rachael Rollins, at a Democratic Party fundraiser featuring First Lady Dr. Jill Biden on July 14, 2022. Available information indicated that Rollins arrived at a private home in Andover where the fundraiser is being held, driven in a government vehicle by a subordinate employee of the Massachusetts U.S. Attorney's Office. She violated the Hatch Act, limits federal political employees, and she posted a tweet that she had approval to be there. That's why the OIG opened the investigation. Now, for our purposes, that part that was covered in the news, it's not that interesting for what we're going to read tonight. But you know what's really interesting? Rollins knows the Bidens, which means that they put her in that USAO office, I think, because she helped Ed Markey prevent Joe Kennedy Jr. from winning that Senate seat and thus insulated Biden from a primary challenge. People think Biden was like this aloof guy. No, he's a politician. He knew what he was doing, and I think he put Rollins in the USAO for a reason, and I think Turtle Boy knew this the whole time, which is just ridiculous. Why would you involve Turtle Boy in anything? Not to mention something that politically sensitive unless he didn't realize what he was involved with. Compartmentalization. But anyway, so you can see here that eventually this leads to the OIG received information that Rollins may have used her position as U.S. Attorney to disclose non-public sensitive DOJ information to a Herald reporter and a Globe reporter about potential DOJ investigations of then Suffolk County DA, interim DA, now the Suffolk DA, Kevin Hayden, before the September 6, 2022 Democratic Party primary election for Suffolk DA, in which Hayden was a candidate, and that Rollins may have done so to ensure that her desired candidate, Ricardo Arroyo, defeated Hayden in the primary. Arroyo ended up losing because he got charged. He got reports of him being involved in allegations of sexual assault came out. So if you're wondering, why did I have these questions for Rachael Rollins, it's that history. So here's where this is all started today. Please start. Hold on. Oh yeah. So the X stream has started, Harvard Yard. You don't need to worry. The X stream is still going. It is live. We are live on X, and all the people who were watching before didn't have to go to a new stream. Thank you so much for your support, though, my friend. You know you are a super towel. But here were the questions I had for Rachael Rollins as a result of her making that post about Turtle Boy. Hi, former U.S. Attorney Rollins. Can you confirm you spoke with Turtle Boy directly during the Senate primary between Senator Markey and Joe Kennedy for the purposes of sending Rayla Campbell to Kennedy events to help Senator Markey? Also, did you get forced out for launching a pretextual federal probe into Kevin Hayden after Hayden beat your ally Ricardo Arroyo in the Suffolk DA primary? Read that OIG report from May of 2023 here. Furthermore, is it true you had a grudge going back years against the Norfolk DA because he commented publicly on your soft-on-crime approach as Suffolk DA and your quest to take life sentences without parole off the table for offenders under 2? Well, it was actually 25. I hope there's no murder offenders under 2. It's actually impossible. I don't think you can even be charged with the crime if you're under a certain age. Although, to be fair, the SJC did vindicate you on that point, the second point recently. That's true. The SJC did vindicate her, but it's an aside from the fact that she had tension with Morrissey over those two issues prior to the Reid probe or any of this. Also, is it true Dustin Chao, who worked for you in the public integrity section during the time in question, had a grudge against the Norfolk DA dating back to 2015 because Chao's wife was passed over for a promotion in the Norfolk DA's office? Also, was the real result of the federal probe into John O'Keefe's death the discovery that, although the investigation of John's death was clean, the same MSP unit who investigated Karen may have also covered up Sandra Birchmore's murder? Were you aware of any pink slips or voucher payments made to Aidan Kearney after you left office in 2023 or 2024? Is that why Karen Reed and her lawyers were able to walk into the offices of then first U.S. Assistant Attorney Josh Levy in November of 2022, while Rollins was U.S. Attorney, and get Levy to run the playbook by opening a pretextual federal probe into the Norfolk DA in the context of the Reid case due to existing probes into the state police on matters unrelated to the Reid case? Is this what I really stumbled onto during my reporting that, due to my own extensive network of connections, has somewhat shaken the political and civil service establishment? Image 1, the history of tension between the Norfolk DA and the U.S. Attorney dating back to at least 2015, but actually going all the way back to 1990s when Whitey Bulger was trying to target troopers via John Conley, who worked for the then Norfolk DA William Bill Delahunt, recently deceased. May he rest in peace. The Rachael Rollins playbook is image 2, to launch pretextual federal probes and then leak them to target political enemies. That's what we're going to learn about right now. Image 3, the overview of connections between Aidan Kearney and Karen Reed's lawyers, Alan Jackson and David Yannetti, that explain why DY and AJ wanted to use Aidan to plant fake stories in the press for the purposes of lying to the court in Reed's case about their own leaks, such as to poison the jury pool ahead of trial. Read the search warrant for Karen Reed's phone that led to those discoveries here. Image 4, the text messages leaked by Aidan Kearney confirming Karen Reed had a direct relationship with acting U.S. Attorney for the District of Massachusetts, Josh Levy, and that Levy asked Reed in the fall of 2023 to keep that relationship hidden from the press. So, this is the primary source document that shows this was from the Reed case. I predicate this, I think this was filed by the Norfolk DA. I think it was a letter that was sent to like the U.S. the office that we're going to learn about that Rollins had to deal with recusing herself about. This was a letter from Morrissey to that office. But you can tell, like, the office will deal with like its own shit internally, the DOJ's recusal office. But if you're like trying to write asking them to recuse and you're outside their office, they'll just kind of be like, screw you, even though Morrissey was right. I predicate the following information with the fact that it has been the policy of the Norfolk DA's office during my 12-year tenure as DA to maintain a close working relationship with the U.S. Attorney's Office for Massachusetts. Notable in that relationship was the cooperation of the Norfolk DA's office in the prosecution of a 35-year-old murder case that was committed in Sharon, Mass., which involved the Whitey Bulger gang in U.S. v. Fleming. That was the case where Brennan was Bulger's defense lawyer. The Norfolk DA's office had statutory jurisdiction to pursue the case, but in the interest of cooperation, acceded to the request of the U.S. Attorney's Office at the time in 2015 to allow federal prosecutors to proceed with the case. As a result of that agreement, the Norfolk DA's office and MSP assigned to the Norfolk DA's office worked closely with the U.S. Attorney's Office on the case. During this period, AUSA Dustin Chao, without nexus to that prosecution, asked a Massachusetts State Police detective involved in the matter if he had any kind of damaging information on the DA, first assistant, or the Norfolk DA's office. Tully. Well, was Tully a detective back then? He might not have been. I wonder who it was. This sua sponte question was not without context. Laura G. Chao, Dustin's wife, had been an employee of the Norfolk DA's office prior to the case mentioned above. Not long into her tenure, it became apparent to her supervisors that she required more seasoning and legal experience if she was to succeed in a superior court role. She was offered the chance to gain more trial experience in the district court without any loss of compensation. Instead, she resigned. I now understand what that means. Instead, she resigned and filed an ethics violation complaint with the Mass Board of Bar Overseers against the first assistant in the Norfolk DA's office. The complaint before the board was summarily dismissed in short order. Laura G. Chao was instead cited for a violation of her ethical obligation to provide accurate address information for her practice. Long after separation, she was misrepresenting her address as the Norfolk DA's office. No shit, huh? No shit. That runs deep. That runs way deeper than I thought. And then this is the overview of the Rollins report we're about to listen to. We're literally listening to those pages. And then this is the Turtle Boy search warrant affidavit. Now, I'll just read this for you. This talks a little bit about the events over spring of and summer of 2023. So 55, a check, this is from the search warrant from Karen Reed's cell phone. A check of the text messages from Natalie, that was Natalie from the Karen Reed case. Phone reveals several instances where it appears Kearney communicated directly with attorneys Alan Jackson and David Yannetti. The first being on April 22nd, 2023. Natalie sends Turtle Boy a message, "Did you talk to AJ today?" And Kearney responded, "Just saw his text, going to call him in a bit." On May 2nd, Natalie sent Kearney the message, calling as a lawyer, ask Yannetti about it. On May 5th, Natalie sent Kearney the message, this is from Karen, "Tell Turtle Boy from me, be strong, Aidan. Get down for a day, but wake up and keep fighting tomorrow. Please call Alan and spitball your issues with him if you want to, and nothing gives you a shot in the arm like talking with AJ. Now, if you're wondering what's that about, I think Aiden was facing a wiretapping investigation at the time involving a victim out of Rhode Island named Natalie Haskins or something. And the FBI, right after Karen says that to Aiden, Karen says, you got to call Alan about your problems. Aiden then says, yeah, I just did. A few weeks later, the FBI just randomly intervenes in that case, and it was a field agent from the Worcester field office of the FBI, Samuel Weiner, who intervened on Aiden's behalf in that case. It was very weird. Now, here's where this search warrant for Karen Reed's phone continues. If you're wondering, what was Aiden doing over the summer of 2023? What were Karen's lawyers doing? So, a special prosecutor convened a grand jury to investigate the intimidation of witnesses in Commonwealth v. Reed. A grand jury summons was issued to Verizon requesting cell records for 2 of Kearney's cell phones ending 9017 and 6909. The subscriber for these accounts is Aiden Kearney. A check of those phone records revealed 189 calls between those phone numbers and the phone number Natalie provided to investigators for Karen Reed, and that ends 0835. The duration of phone calls between Kearney and Reed totaled in excess of 40 hours. These conversations are in addition to the communications Reed and Kearney allegedly have on the Signal app. The first entry to communication between Kearney and Reed's is May 7, 2023. The frequency and duration of the calls increased greatly beginning in the end of June. The communication continued throughout the fall and winter of 2023, and the last entry of those phones communicating occurred on December 21st, 2023. A check of the phone records from Kearney's phone revealed communication with cell phones associated with David Yannetti and Alan Jackson. A phone number ending in 5339 was checked through LexisNexis, a commercially available database, and was associated with David Yannetti. The 5359 phone number communicates with Kearney's phone, 2 phones 29 times, including 9 times from April 20th to May 2nd. A phone number ending in 0555 was checked through LexisNexis and associated with Alan Jackson. The 0555 phone number communicates with Kearney's 2 phones 29 times, including 3 times from April 20th to May 1st. On October 10, 2023, Aiden Kearney was arrested pursuant to several arrest warrants issued out of Stoughton District Court. He was arraigned in Stoughton District Court on the same date, which was widely reported by local media. On October 12, 2023, Natalie received a call on a cell phone from a number ending 460, which is the main office number for Workman, Jackson, and Quinn, the California law firm of Alan Jackson. Natalie stated she did not answer the call, nor did she return the call. She stated she had never spoken to Alan Jackson, David Yannetti, or any other attorney representing Karen in Commonwealth v. Reed prior to October 12th or since. They knew she was the middleman. On December 20th, 2023, this timeline's very interesting. The Norfolk County Grand Jury returned indictments charging Aiden Kearney with 9 counts of intimidation of a witness, 5 counts of illegal picketing, and 3 counts of conspiracy to intimidate. In December 2023, so it was right after that, I communicated and interviewed a witness relative to ongoing conspiracy to intimidate witnesses in the Commonwealth. This is Lindsay Gattani. I interviewed Lindsay at her residence with another investigator. Now, they withheld her name here, but I'm not sure in hindsight if that was to protect her or to protect them. Lindsay Gattani stated she met Aiden Kearney in September of 2023 after exchanging messages on Facebook Messenger. Lindsay Gattani stated she would communicate with 2 of Aiden's Facebook profiles, Clarence Woods Emerson and Aiden Kearney. Lindsay Gattani states she then began communicating with him using the phone number ending 9017. Kearney and Lindsay Gattani met in person following a Commonwealth v. Reed court date and went to her apartment. After that meeting, Lindsay and Aiden began having a romantic relationship, with Kearney staying over her apartment Friday nights. In the beginning of their relationship, Kearney stated he was close with Karen Reed's family. He would later state to Lindsay that he speaks with Karen Reed every day. Lindsay showed me, the detective, a screenshot that Kearney allegedly sent her showing multiple calls on a certain day that showed Karen Reed signal audio in the call log. Kearney told Lindsay that there was an intermediary between Kearney and Reed, a woman by the name of Natalie. Kearney stated Natalie and Reed were angry with each other. Kearney stated to Lindsay that he then began talking to Karen directly. Lindsay stated Kearney and Reed communicate using the Signal app because it is encrypted. Lindsay stated she does not communicate with Aiden using the Signal app. Lindsay stated Kearney runs everything by Karen, meaning all of the blog posts and social media content is approved by Reed prior to Kearney publishing. Kearney described Reed as difficult, controlling, and gets irritated with him. Lindsay stated Kearney showed her material related to the investigation of the homicide of John O'Keefe, including I think it was the cruiser footage from before it was leaked on social media. It was either one or the other. That one of those details is wrong. On December 1st, 2023, Kearney posted a live YouTube video entitled Karen Reed Case, Jen McCabe 911 Tape Breakdown. The audio is in fact a voicemail recovered by investigators from John O'Keefe's phone that captured Jen McCabe calling 911 from a different phone, reporting finding John O'Keefe unresponsive. O'Keefe's phone was recovered by first responders on 1/29/2022. It's reasonable to assume only the Commonwealth and Reed's attorneys had that audio file. Lindsay described one instance where Karen controlled what Aiden would publish. Aiden wanted to release the Canton police cruiser footage he had obtained from Reed. Kearney asked Reed if he could publish the video on his Turtle Boy platform. Lindsay stated Reed said no to the request. Kearney was frustrated and contacted one of Reed's defense attorneys, Alan Jackson. Jackson approved the release of the video. Reed later found out about Kearney going to Jackson and was angry. During a November 28, 2023 YouTube Live, Kearney discussed the existence of video for cameras affixed to the Canton PD cruiser who responded to the scene, including the names of the officers whose cruisers has video, 2-hour, 18-minute mark. Lindsay stated different sources of financial benefit for Kearney and his partners. Lindsay stated Kearney is doing well with donations. Kearney had alluded to the fact that he did not pay for a Lexus SUV he recently acquired. Kearney made a statement similar to, quote, if my frugal mother, she's now passed away, rest her soul, ever found out I paid for the Lexus, she would be mad. And even if I didn't pay for it, what's wrong with that? A check of RMV records revealed the Lexus was purchased in the end of June of 2023. Further records revealed the vehicle was paid in full using a personal check. Lindsay stated she was told by Kearney that Reed's attorneys were, quote, working with the U.S. Attorney's Office, specifically acting U.S. Attorney for the District of Massachusetts, Josh Levy. Kearney would talk a lot about the federal grand jury and Levy with with Lindsay. Now, this gets even better. Wait till I show you this. You think that's intense? Oh, you know exactly what's coming next. You know exactly what's coming next. This page actually continues, and there's something really, really weird that happens, right? Hold on. Got to get the KR search warrant. We are extra long into towel mode today. We are on extra towel duty, ladies and gentlemen. We are on extra towel duty. So I have to bring up, because the next paragraph of this search warrant, and I do have the end of it, and we are going back to the Rachael Rollins document, but I want to just open up this PDF here, so give me 1 second. Yes, I would like to open the PDF in the app. Thank you. All right, so this is the actual search warrant that I was just reading. So there you go. You can see it. There it is. Now we got to go down to paragraph 79 here, all right? And if we go down to paragraph 79 where we had just left off, right? Kearney would talk a lot about the federal grand jury with Lindsay. Lindsay stated Karen Reed was interviewed by federal law enforcement. Lindsay also shared other comments Kearney learned from Reed that are corroborated by other information known to the affiant. How much do you want to bet that in that meeting in December of 2023, Brian Tully found out that Tully and the Norfolk DA were the target of the probe, and he was like, we can't be because it's not about John's death. Oh my God, it's about Sandra. Now, I don't think Lindsay realized what she found out. I don't think even Aiden really realized what he knew, but it was a big deal. Now, here's what's interesting. Lindsay was served with a summons to appear before the grand jury on December 22nd of 2023. Now, how weird is this, right? It's very obvious. We just saw up there that Aiden was indicted on December 20th of 2023. So why would Lindsay be getting a grand jury summons that we now know is real? The grand jury happened on December 22nd. Oh, they opened a new grand jury into Karen and Aiden, and Lindsay was one of the witnesses, and that's why so many people have been tormenting Lindsay for so long, because she's the one who actually has the key to unlock the fact that Aiden, beyond Natalie, Lindsay's the one who has the key to unlock the fact that Aiden and Karen were conspiring with the help of the DOJ to subvert a state criminal prosecution. So they just tried to destroy Lindsay's reputation and make her feel terrible and isolate her, and it's not going to work, though. I promise you, like I told you, I'm committed to that woman. If you are up against Lindsay Catani, you are up against me. You will lose. Bring it. So Lindsay was served with a summons to appear before the grand jury on December 22nd, 2023. Kearney learned Lindsay was served with the summons, and they agreed to meet at her apartment on the night of December 23rd. By the way, it's really weird that Kate Peter went to Lindsay's apartment to do an interview with the Netflix documentary in that conference room and wouldn't let Lindsay be part of it. I'm going to blame Gretchen Voss, and I will forever denote in my brain that it was Gretchen Voss's fault if an interview runs in that Netflix documentary where Kate Peter talks about Lindsay's story in that freaking conference room. God bless America. I think Gretchen's a little more devious than she lets on. I like it. I think she's smart. I don't think she's a little doe. She's a little puppet master. Love you, Gretchen. During this meeting, Kearney told Lindsay to tell the grand jury she did not remember anything, delete evidence from her phone, and told her he would hire her an attorney if she cooperated with him. And what was the punishment if she didn't, Aiden? You'd ruin her life? Kearney later was alleged to have assaulted Jane. That charge was not bound over, which led to Medfield police charging Kearney with assault and battery on a family household member and witness intimidation. He also got charged later with illegal interception of an oral communication because he apparently recorded Lindsay without her consent and then submitted an edited recording into the court record with her consent to record in the audio without knowing that there was an unedited version out there that didn't have her consent. That was the real version, so he screwed himself. So then he ends, based upon the foregoing fact, there's probable cause to believe that Karen Reed committed a violation of MGL 268-13B, witness interference to Matt McCabe, Jen McCabe, Brian Albert, Chris Albert, Colin Albert, Juliana Nagel, Michael Proctor, and Elizabeth Proctor. So you can see they were going for Karen on WI. They're going to get her on WI eventually if Aiden cooperates. Do you see what I'm saying? They got her. They were trying to get her. You turn into these streams, and you just get all this interesting stuff. Did you like my impassioned soliloquy about Lindsay Catani? Eventually, I don't care. You realize it doesn't matter what it takes. Reporting you to the bar council, getting people investigated for abusing the criminal court system as a form of witness intimidation. Do you realize I clearly have, I'm not part of the government, but people listen to this. Not just that, since people listen, if I call them, they're like, oh my God, you're Grant Smith Ellis. And I'm like, yeah. And by the way, what the fuck? And if I just say what the fuck about one thing to a person in a very high office, they're going to be like, Grant, why didn't you come to me about this earlier? And I'm going to be like, you don't understand. I'm a very humble little towel. I only came to you because this got completely out of control. And if I do that about you or something you're doing, the whole fucking system is just going to rain fucking hell down on you, and you're not even going to see it coming. And fuck you if you did that to Lindsay. Fuck yourself. Can rot in prison with the rest of them. All right, we're going back to this U.S. Attorney overview of Rachael Rollins. Did you see I got a little bit impassioned there? Don't fuck with Lindsay Catani. You will not understand. All of a sudden, the system will just rain fucking hell down on you, and you won't know where it's coming from. Tao's got friends, motherfucker. get a little impassioned about that. Sorry about that. I don't mean to cuss. I have towel friends, and I cuss occasionally, but only about Lindsay in a very benevolent, loving way. I promise. I get a little vengeful righteously. What do you mean? I know no one. I know nothing. I've never talked to the government. What is the government? I am a towel. Taterbug, you know what they say? Some people have high friends in high places. Towel has high friends in places. All right, we're going back to the Rachael Rollins OIG report because it ties into everything I just said. I have a kitchen towel that says I love Jesus, but I cuss a little. Yes, I love it. Taterbug, we get matching kitchen towels every time I look at it. I'll be like, oh my God, that's a towel. And then be like, wait a minute, Taterbug has that towel. And then I'll be like, oh my God, this is the greatest thing ever. Now, have I sufficiently explicated the overlapping concentric social circles of influence which have come to permeate the domestic justice system and that have literally driven Towel to decide that I'm going to be Thomas Jefferson Towel and that in turn we are going to put Towel in office? Just send me in there. You have to elect me, because if we put Towel in any of these government departments, they're going to try to dampen Towel's light. You don't understand. There will be a bureaucracy. I'll be like Winston Smith in 1984. They will drive me crazy until I accept 2 + 2 = 5, and I'll be like, fuck you, 2 + 2 does not equal 5, and eventually they'll just shoot me in the back of the head because I won't agree with them. They'll shoot me in the back of the head. If I agree with them anyway, don't send me into that government. But if you elect me, then I can do oversight of the government. Yes, I'm awake past my bedtime. This is Towel. We're calling this Late Night with Towel, Unfiltered Towel. I'm a Towel. But we're going to listen to this OIG report with Rollins because we're halfway through it, and I've now explicated the overlapping concentric social circles of influence which have come to define the domestic political arena. Now, the reason why this exists, just to give you a little background, I think that there's a bit of an aristocracy in America that hides in plain sight and does shit like this. I hate it. It's a disgrace to the country. Just because most people are trying to get by and feed their families and whatever doesn't mean that if you become the U.S. attorney or if you're really powerful, you should fuck around with our democracy. I don't care if you're a Republican, Democrat, or a towel. You cannot do that. It's not allowed. This is America. So, with that said, I think this happens because if you look at Harvard finals clubs, have you ever heard of these things at Harvard? Porcellian is one of them. Hasty Pudding. There's a few others. But one of their club, I think Porcellian's clubhouse is at 1123 Mass Ave or something. These are very pretentious places at Harvard, all right? They don't really have frats. They do, but the real thing you want to be in is the finals clubs. Now, the finals clubs, there's 8 of them. They each have 8 members that join from when 8 rising sophomores can join each year. So that means each club has 8, 16, 24 members. There's 8 total clubs, 24 2 times 8, 160, 4 times 8, 32, 192 or something roughly in there, members of these 8 clubs at any one time. But it's not just the exclusivity. Presidents have been denied from these clubs. It's the fact, ladies and gentlemen, that it's the form. Remember the Hegelian form we talked about earlier? Ignore the content of the clubs. Ignore their pretentiousness. Ignore the fact that when you are a member of these clubs, you can't look out the window because you're not allowed to rest your eyes on commoners. You have to sit in a chair and look at a mirror that looks out the window. They are ridiculous. Fuck yourselves. But anyway, they have 8 of these clubs, and the inner circle of these clubs, there's an inner circle club. I think it masquerades as a frat, but it's not really a frat. It's called Delta Kappa Epsilon. And I've done some relatively esoteric research at the Harvard Archives, and I came across this very excellent scholarly treatise that enumerated the rise of these esoteric finals clubs. Porcellian started because they hung a pig out a window and all this other stuff. But the bicycle room at 1123 Mass Ave is the only place where non-members can go. I know a lot about this. But the DKE, Delta Kappa Epsilon, is not really a frat at Harvard. It's actually an inner circle, I believe, social club that consists primarily of the leadership of the other finals clubs, okay? All 8 finals clubs have a president. the president of those 8 finals clubs, they each belong to another inner circle finals club. Now, that is, I think, a symbiotic microcosm of the larger structural dynamics of soft power in the real world. Okay, that's how soft power functions. It's these overlapping concentric social circles of influence, and what you're seeing in this OIG report is like being in the room. Like, for this level of control, the U.S. Attorney's Office in Massachusetts, this is what it's like to be in the damn room. So that is why I'm going to continue to show you this report, because if you're in that inner circle club, right, you're making decisions that permeate out into other powerful clubs, and then your decisions, you're the trendsetters, you're the elite, that's filtering out into the commoners. Now, the commoners at Harvard are students who would just blow the rest of us away. So imagine if you're the thought leaders among the thought leaders, right? That is how soft power functions, overlapping concentric social circles of influence. I think I can fix the government. Someone call me Thomas Jefferson Towel. And yeah, it's a little skull and bonesy, but skull and bones is the Yale manifestation. What you really want to study is Porcellian at Harvard. Look up 1123 Mass Ave. Look up that clubhouse. That's some shit. I'm sure they'd love to talk to me, but still, fuck your world. Fuck that. I'm not an aristocrat. I'm a fucking Thomas Jefferson style Democratic Republican, and you're never going to take it away from me. You will never make me part of your world. It won't happen. It's not happening. Don't even bother. I'll come to your social functions. I will explicate James Joyce's Finnegan's Wake just to flex on you, and then I will leave because fuck yourself. Anyway, sorry, late night towel. Content warning, ladies and gentlemen. Content warning for late night towel. This is a content warning. Content warning for late night towel. Yes, content warning for late night towel. I apparently like
USAO and is about
all
refusal.
right, hold on. So now we're going to August 7th. We're going back into this Rachael Rollins, and we're just going to listen. You tuned in because we were going to listen to this report. I gave you all the background. I gave you all the context. I'm still talking. We had to start a second stream because I'm still talking. You don't understand. So, all right, so we're going to start with the part about Josh Levy. So it actually is initial internal MA USAO discussion about possible DOJ investigation. All right, so we're going to start back on page 31 because I want to talk about Josh Levy. Josh Levy, have you considered? Oh, that's actually a little bit further down. We're going to start. Oh, it's even better. We're going to start on page. Wait till the Josh Levy part. It gets really, really, really good. We're going to start on. Hold on, what's that? Page 20? Yeah, we're going to start on page, where is it? Where is it? Hold on. I'm going to get us there. We're going to start on, yeah, we might have to listen to, hold on. Where does this, August 17th and 18th? I just don't want to go past the Levy part. No, yeah, we got to go a little bit backwards. Hold on. We got to go just a little bit backwards because we are not missing that Josh Levy part. It's explosive. All right, so we're going back to internal MA-USAO discussions about possible DOJ investigation.
24
right.
Subsequent to agreeing to participate in the Law Professor's Book event, and while the OIG investigation was, Rollins told us that she was acquainted with the law. 23 as noted above, Rollins signed an ethics agreement prior to becoming U.S. Attorney. 23 as noted above, Rollins signed an ethics agreement prior. The executive officer stated that she and Rollins had some back and forth, and then Rollins said, W.L. This provision of the ethics agreement led to Rollins being recused from numerous matters involving the Suffolk D.S. office, where she agreed to comply with the commitment. 21 the first 21 on August the 6th. One internal MA-USAO discussions about possible DOJ investigation and Rollins's likely recusal according to the MA-USAO first.
Remember, the first USAO assistant, the first assistant here is Josh Levy. That Josh Levy that we just talked about. And the Rachael Rollins is his boss. Rollins was using Levy as her henchman, kind of. When Rollins was worried about like an ethics thing or a recusal, she would send in Levy, and he would say, "Oh, the office can investigate it, just not Rollins," right?
Assistant U.S. Attorney, first assistant, sometime after the Globe's reporting on the transit police misconduct matter, he and Rollins discussed whether the information in the Globe warranted the MAUSAO opening a civil rights investigation into the transit officers' alleged misconduct or a separate public corruption investigation into the possible quid pro quo involving Hayden and his first assistant DA. The first assistant told us that he did not recall when this conversation occurred, including whether it was before or after Rollins first reached out to the EAR's General Counsel on the 10th of August, described below. The first assistant said that he also did not recall whether Rollins first raised the information in the Globe articles to him or whether he raised them with her. In either case, according to the first assistant, he and Rollins discussed that he should seek guidance from EARS about what role, if any, the MAUSAO should play in either a civil rights investigation of the transit officers or a public corruption investigation of Hayden and his first assistant DA. The first assistant said that because the potential investigations concerned an office Rollins used to lead, he believed Rollins recognized right away that there was going to be a recusal issue. 21 on August 6, 2021, after her nomination as U.S. Attorney, Rollins signed a nominee statement, where she agreed to comply with the commitments outlined in her ethics agreement. Rollins's ethics agreement contained the following provision. Cont D. Assistant stated that he conveyed to Rollins that he did not think she could be involved in either potential investigation but that he hoped the MAUSAO could still be involved in the civil rights matter. The first assistant told us that during his discussion with Rollins about the Globe article, she did not tell him that she had been in contact with any of the reporters in relation to the story. Rollins told us that she did not recall her conversation with the first assistant, but that either she or the first assistant may have circulated one or more of the Globe articles for discussion. Rollins told us that with respect to investigating Hayden, her opinion was that somebody should absolutely look into the allegations but that she was not sure whether she expressed that opinion to the first assistant or anyone else at the time. Rollins told us that the outcome of any such inquiry was irrelevant to her, she just believed it was important that there be an inquiry by someone with investigative authority, which she believed was either the MAUSAO or the Massachusetts Attorney General. The first assistant told us that his initial assessment was that he was not interested in bringing a possible quid pro quo case against Hayden and his first assistant DA and that he was more interested in the potential civil rights case against the transit police officers. According to the first assistant, Rollins appeared to him to be open to both potential cases and more open to the notion that Hayden might have done something dirty. The first assistant told us that after his initial discussion with Rollins about the information in the Globe article, he intentionally limited his communications with Rollins on that subject. The first assistant explained that he assumed Rollins would be recused from any resulting investigations, and, for that reason, he did not want her opinions to influence how he handled the investigations going forward. Upon confirmation, Miss Rollins will resign from her position as Suffolk County District Attorney. For a period of 1 year after her resignation, she will have a covered relationship. Under the impartiality regulation at 5 CFR 2635.502 with the Suffolk County District Attorney's Office. Pursuant to 5 CFR 2635.502, d, Ms. Rollins will seek written authorization to participate in particular matters involving specific parties in which she knows the Suffolk County District Attorney's Office is a party or represents a party. However, during her appointment to the position of United States Attorney, Ms. Rollins will not participate personally and substantially in any particular matter involving specific parties in which she previously participated in her capacity as Suffolk County District Attorney. This provision of the ethics agreement led to Rollins being recused from numerous matters involving the Suffolk D.S. office. The EARS General Counsel told us that he recalled discussing Rollins's displeasure with the number of recusals very early on in her tenure and specifically highlighting this language in her ethics agreement during their conversation. Rollins told the OIG that she had lots of ethics meetings early in her tenure dealing with recusal issues and described these meetings as intense and consuming hours of her time. On August 9th, the first assistant emailed the MAUSAO's Public Corruption Unit Chief and asked him whether the possible quid pro quo reported in the first Globe article was something his unit would be interested in.
And guess who that was? Probably Dustin Chao.
The first assistant could not recall the precise sequences of events but told us that he might have contacted the Public Corruption Unit Chief independently of Rollins because the first assistant knew that Rollins would almost certainly be recused from any investigation of Hayden. The first assistant stated that he wanted to know early on whether the Public Corruption Unit Chief had any interest in the allegations because, if the unit chief had no interest in pursuing the allegations, there would be no need to go through the recusal process. The August 9th email led to a discussion a few days later between the Public Corruption Unit Chief and his supervisor, the chief of the MAUSAO's Criminal Division, Criminal Chief, about whether to open a public corruption case against Hayden and his first assistant DA based on the information in the Globe articles. They both told us that during this discussion they were of the same mind that the possible quid pro quo reported in the Globe was not worth investigating. The criminal chief also told us that he consulted with a supervisor at the Federal Bureau of Investigation who also didn't have an appetite for opening an investigation. Email communications reflect that the criminal chief planned to discuss this issue with the first assistant on the 17th of August. The criminal chief told us that he did not specifically recall this conversation with the first assistant, but that he would have conveyed his and the Public Corruption Unit chief's assessment that the possible quid pro quo was not worth pursuing. The criminal chief said that he would have also conveyed to the first assistant that they planned to reach out to DOJ's Civil Rights Division for an assessment of the potential civil rights case against the transit police officers. The first assistant told us that he recalled the criminal chief telling him that there was not much interest in investigating the possible quid pro quo. The first assistant said that he believed he agreed with this initial assessment. The first assistant told us that he did not recall discussing this assessment with Rollins. As noted above, the first assistant said he intentionally tried to limit his discussions with Rollins given the likelihood of her recusal. The MAUSAO executive officer told us that Rollins raised the Globe stories during a morning leadership call and asked what the office was doing about it. The executive officer stated that she told Rollins the MAUSAO was not taking any action and, in fact, could not take any action due to department rules prohibiting overt actions in the run-up to an election. According to the executive officer, Rollins asked what rules the executive officer was referring to, and the executive officer replied that she did not know the details, so Rollins should ask the public corruption prosecutors in the office. The executive officer stated that she and Rollins had some back and forth, and then Rollins said, I mean, if there's something there, I mean, what do you mean? I would expect they'd be cutting subpoenas next week. The executive officer told us that she then explained to Rollins that things typically did not move that fast and that also there was an important rule about not intervening in elections. The executive officer said that she told Rollins that Rollins could certainly send the Globe articles to the public corruption prosecutors, but the executive officer added that she thought the prosecutors would not take action until after the election. The executive officer said that she and Rollins kind of left it at that and the issue did not resurface until the office received the law professor's letter, discussed below. To the 10th of August.
Listen, this policy in the DOJ about not interfering in elections is incredibly important. We gotta, listen, I don't know how we can have people investigating public corruption and interested in the outcome of elections. This is a very broken system. I mean, yes, God bless this executive officer. I think I know who this was, because I kind of remember something happened with the Curaleaf story or something. I don't remember exact. It was really scary, actually. I think I have some idea what happened with that story. I still don't really want to talk about it because I haven't. Until I get permission to talk about it, I don't really want to talk about it. But something happened where I needed to talk to the U.S. Attorney's Office way back in the day. I want to say like the spring of 2022. And I had to talk to them. It was completely unrelated. It was actually a very serious national security thing. And not that I know anything about it. This is hypothetical. And anyway, I remember emailing with their press officer, and earlier in this document it said the executive officer was the press officer. So I kind of think I know who this is. God bless this person. Whoever you are, I think it was a woman. Yeah, it's a she. So I think I'm right. Like, that's how I knew above when they said first U.S. Assistant Attorney and didn't name him. I was like, that's Josh Levy. And then they said he. God bless that person. That person single-handedly, I think, exposed Rachael Rollins. I mean, because clearly you can read between the lines. The executive officer cooperated with the OIG, and it seems like the executive officer kind of tried to put a stop to this. It didn't really put a stop to it. You'll see Rollins goes on to do it anyway. But God bless that person. We need civil servants like that.
Rollins speaks with EA's general counsel about the Globe story and her potential conflict of interest late in the evening on the 10th of August. Rollins emailed the EA's general counsel a link to the 10th of August Globe article reporting the MBTA Transit Police's call for a special prosecutor and asked if he had time for a call the next day. Shortly after emailing the EA's general counsel, Rollins forwarded the email to the first assistant, who responded by asking Rollins whether the recusal issue prompted her to reach out to the general counsel. Call detail records indicate that on the 11th of August, the EA's general counsel and Rollins had an approximately 4-minute phone call that afternoon. 22 This call was the first of 2 calls between the EA's general counsel and Rollins after the Globe articles, according to call detail records and email communications. Rollins told us that she generally remembered reaching out to the EASA General Counsel because she predicted that the issues raised in the Globe articles, specifically, the questionable behavior of the former transit police officers and the possible quid pro quo involving Hayden, were going to bubble up into something really big. Rollins told us that she had a faint recollection of the transit police misconduct matter from her time as Suffolk DA and wanted to make sure that the EASA General Counsel was aware of her potential conflict of interest. She said that she also wanted the EASA General Counsel to know that she was removing herself from any involvement, but that she did not want this to fall through the cracks, if what is alleged actually happened. The EASA General Counsel told us he did not specifically recall this initial conversation with Rollins. Rollins also told us that she did not recall whether she and the EASA General Counsel specifically discussed whether she should be recused from any potential investigations resulting from the issues reported in the Globe. However, she said that she thought at the time that her office might do something in response to the news reporting, and she knew that there was no way EASA would let her become involved. 23 When we 22 call detail records indicate that on the 11th of August, Rollins called the MBTA Transit Police Chief, and the call lasted for 68 seconds. When we asked Rollins why she called the chief, she told us that she did not recall the reason, including whether she wanted to discuss his office's call for a special prosecutor, as reported in the 10th of August Globe article she forwarded to the EASA General Counsel. 23 As noted above, Rollins signed an ethics agreement prior to becoming U.S. Attorney which, among other provisions, prohibited her from participating in matters in which the Suffolk D.S. office was a party until January 2023, at the earliest. Asked why she decided to contact the EASA General Counsel directly, rather than through her ethics advisors as other recusal issues were handled, Rollins told us that she did not remember the reason, but this seemed like something she should just go directly to the EASA General Counsel to discuss. Rollins told us that she did not recall whether she told the EASA General Counsel about her relationship to Arroyo. The EASA General Counsel told us that Rollins never mentioned to him that she had had communications with Arroyo or with any Globe reporters about the issues reported in the Globe articles. 3 August 16.
So this next professor they mentioned, I found this earlier. I think this is a guy named Daniel Medved. Now, what's weird is Daniel Medved had actually filed a ethics complaint against, and it's right, you can see right here, against Dustin Chao, who was the head of the public integrity section. I think he was the head of it. He's even mentioned in the document, I'm pretty sure. Here's Daniel Medved, all right? Daniel S. Medved. Medvew. He's a distinguished professor of law and criminal justice at Northeastern. And the reason he comes up here is that he's an ally of Rollins. All right. Now, even though he filed an ethics complaint against a person working for Rollins, he's Rollins' ally, and it's definitely him because he's mentioned in the Globe articles that are mentioned in this OIG report. Now, watch what this section describes. It basically describes a situation where Rollins needed like a letter to her to spark an investigation. So the law professor sends Rollins a letter. Rollins pretends she doesn't know why the professor said it and then tries to use the letter as grounds to start an investigation. And weirdly, Rollins agrees to go to like some book signing event, which would be a big deal, the U.S. attorney at your book signing, for this professor. She doesn't end up going because the DOJ catches her. But just look at this paragraph. This is some shit.
To 17, Rollins receives letter from a law professor calling for federal investigation into Hayden, and Rollins consults EASA about her recusal from such an investigation on the 16th of August. A Boston area law school law professor, emailed a letter directly to Rollins requesting that the MAR USAO commence an investigation into potential improprieties committed by prosecutors in the Suffolk D.S. office. Referencing the Globe reporting, the letter stated that recent media accounts revealed troubling information that could potentially indicate public corruption and / or other illegal activity committed by Hayden and his first assistant DA. The letter attached a timeline of facts reported in the Globe regarding the donations that the former transit officer and his attorney made to Hayden's campaign and the alleged statements of Hayden's first assistant DA to the former transit officer's attorney that the former transit officer was no longer under investigation, which the law professor said he had not independently verified. The law professor ended his letter to Rollins with, "Please feel free to reveal this letter to the public and / or media if you would like to do so." When we asked the law professor what prompted him to send his letter, the law professor stated that one focus of his scholarship is prosecutorial accountability, and he found the allegations against Hayden concerning. The law professor stated that he was also concerned that no other DA officers would seriously look into these allegations, and he, therefore, wrote to the U.S. attorney hoping his letter would prompt an investigation to determine what actually happened. The law professor, who referred to Rollins as a friend in emails we reviewed, told us that he did not speak with Rollins about the issues raised in the letter before he sent it. Rollins told us that she was acquainted with the law professor before he sent her this letter. According to Rollins, the law professor is a progressive who had written articles in defense of her and her policies when she was Suffolk DA, and she estimated that they have contact every 3 or 4 months. The personal email communications Rollins provided us indicate that on the 15th of August, the day before the law professor sent his letter requesting an investigation, the law professor sent Rollins an email seeking to confirm her attendance at an event on the 21st of September, 2022, promoting his new book, which Rollins confirmed by email the same day. The emails between them did not...
I mean, it's a quid pro quo. You get it, right? Like, so he sends on August 15th, he sends the email, will you go to my book event? She confirms. The next day he sends the letter helping her out.
Mention the law professor's intention to send her a letter requesting an investigation. 24 Rollins told us that she did not recall the law professor giving her advance notice of the letter and that she can affirmatively say that she did not solicit any letter from him. She said that she would leave open a slim possibility that he called her to complain, as people sometimes do, and that she told him to write her a letter, as she sometimes does, but she said she had no memory of that happening here. Call detail records of Rollins's personal cell phone, DOJ cell phones, and desk phone do not show any calls between the law professor and Rollins during this time period, and Rollins's attorney represented to the OIG that her personal cell phone did not contain any text or instant messages with the law professor during this time period. Rollins told us that her reaction to the law professor's letter was that she felt compelled to contact the IRSA General Counsel a second...
They did it in person, basically. That's what you read between the lines there.
...time to discuss what to do. According to Rollins, it was significant to her that someone was now asking her office to open an investigation. She said that she felt she needed help from IRSA at this time to make sure that she did not taint any future investigation. When we asked her whether she expected the department to recuse her from any investigation of Hayden, she said that she assumed she would be recused. On the evening of the 16th of August, Rollins forwarded the law professor's letter to the IRSA General Counsel stating, "I just received this letter. We will not respond until you and I have a discussion. Sound good?" Rollins and the IRSA General Counsel ultimately spoke around 2 p.m. on the 17th of August. The IRSA General Counsel told us that Rollins sought his advice on recusal because she recognized the appearance of a potential conflict of interest. According to the IRSA General Counsel, he advised her that he thought her entire office should be recused from any matter involving Hayden, and Rollins agreed. According to Rollins, she told the IRSA General Counsel, "I don't like being recused from things, but if you think I need to be, I understand that." Rollins also stated that the IRSA General Counsel asked her to have her first assistant send his office a written request for an office-wide recusal to begin the recusal process. The executive officer told the OIG that at some point in August, after receiving the law professor's letter but before the MAR-USAO received a formal recusal memorandum, Rollins asked the executive officer if the executive officer had received any media inquiries about the law professor's letter. According to the executive officer, she told Rollins that there had been no media inquiries, and Rollins expressed surprise at that fact. 24 Subsequent to agreeing to participate in the law professor's book event, and while the OIG investigation was ongoing, Rollins sought ethics advice about her attendance at the book event and ultimately did not attend after ethics advisors in the MAR-USAO expressed concerns. For August 17 to 18, discussions between MAR-USAO and IRSA about recusal from a potential Hayden investigation following Rollins's phone call with the IRSA General Counsel, Rollins asked the MAR-USAO first assistant to begin the formal recusal process on the Hayden matter. The first assistant then reached out to IRSA's General Counsel's office, GCO, for further guidance on a recusal in the Hayden matter and the potential civil rights matter involving the transit police officers. Specifically, on the 17th of August at 5:34 p.m., the first assistant emailed the IRSA General Counsel seeking guidance on the recusal process and attached the law professor's letter to his email, stating, "Hope all is well. I understand U.S. Attorney Rollins discussed with you the attached letter requesting an investigation."
This is Josh Levy. You'd never see this kind of stuff. This is Josh Levy writing an email trying to get around Rollins having to be recused because he still wants the office to be able to investigate Hayden for her. Notice a pattern? They did this to Morrissey too. The difference is with Morrissey they found something. With Birchmore, at least with his troopers. With Hayden they found nothing. It went nowhere.
Of corruption allegations that have been reported in the media involving the current Suffolk County District Attorney. Rollins asked me to follow up with you to seek guidance on implementing the office-wide recusal you have recommended for the allegations raised in the law professor's letter. I would also like to get your advice on how we should handle the separate matter of any inquiry into the underlying traffic stop by the MBTA officer that precipitated the alleged events discussed in the law professor's letter. Our office was taking preliminary steps to determine whether the events involving the traffic stop might give rise to a constitutional claim against the former transit officer. My working assumption was that U.S. Attorney Rollins would be recused from any investigation of the MBTA officer matter since the incident happened in 2021 when Rollins was the Suffolk County District Attorney, but that our office as a whole would not be recused from this matter. This is, as you know, how we are handling other matters from which U.S. Attorney Rollins is recused, and I am not recused also. Happy to discuss live if that is easier.
Levy was totally being a lackey for Rollins here. Totally. He called her Rachael at one point, I'm pretty sure. That's why the OIG changed it to Rollins.
Thanks. The following morning, the IRSA General Counsel forwarded the first assistant's email to an IRSA Assistant General Counsel, AGC. In that email, the IRSA General Counsel described the first assistant's request for a U.S. attorney-only recusal on the transit police misconduct matter as fairly straightforward since Rollins's ethics pledge and agreement require her recusal and noted that Rollins understands and agrees to this U.S. attorney-only recusal. The IRSA General Counsel then directed the AGC to the first assistant's email and the law professor's letter for information on the other matter. The IRSA General Counsel added, "If you need any other facts you can pull them up easily since this is apparently a big deal in Boston right now." The AGC emailed the first assistant on the 18th of August at 1:06 p.m. stating that the standard response time for recusal matters is 5 to 10 business days, but to please let him know if there is an urgent matter he should be aware of. The first assistant replied to the AGC on Friday, the 19th of August, at 8:16 a.m. stating that this matter was not urgent and asked the AGC if he needed any additional information. The AGC responded at 8:41 a.m. The only question I have at this time is whether there is a current investigation into the Suffolk County this office and / or the acting and first though. Just so you know, I have a few residual matters from my previous duty day that I am trying to complete, but I will turn to these recusals as soon as I am finished. That said, it will be next week before I have a chance to focus on them. The AGC told us that he had a subsequent telephone conversation with the first assistant on the 23rd of August, and the AGC's recollection was that he was told the MAUSAO did not have an investigation open at that time. The AGC told us that he advised the first assistant on this the 23rd of August call that GCO was planning to submit a request to the Office of the Deputy Attorney General for an office-wide recusal on the potential Hayden investigation and a U.S. attorney-only recusal on the potential civil rights investigation. 5. Rollins seeks to have MAUSAO send a response letter to the law professor in addition to beginning the recusal process. Rollins wanted the office to send a response letter to the law professor. According to the MAUSAO first assistant, Rollins stated that it was the professional thing to do because, as public servants, they had a duty to respond to the letter. When we asked Rollins whether she remembered any discussions with her team about whether to respond in some fashion to the law professor, she said that she may have said that. She told us that she did not remember what happened in this instance but that generally she believes it is important for her office to respond to letters, even if only to say thank you for your letter. The first assistant told us that although he was aware that Rollins knew the law professor, he did not know the law professor, and he was concerned that any MAUSAO response to the law professor could make its way to the media and be used to further an agenda that may not be what the MAUSAO would want. In particular, the first assistant stated that he did not think the MAUSAO should respond to the letter because any response could be used to suggest that the MAUSAO was looking into the allegations against Hayden. The first assistant stated that he ultimately advised Rollins to backburner any potential law professor response until the MAUSAO, in consultation with IRSA, determined what role, if any, the MAUSAO would have in a potential Hayden investigation. Separately, the Public Corruption Unit Chief and Criminal Chief discussed the law professor's letter, and, according to Public
we got to go back because I was saying
the Public Corruption Unit Chief and Criminal Chief discussed the when we asked Rollins.
Hold on, we have to go back because I was saying thank you to just me for being a super towel, and I missed a very important part. But I not that that's a bad thing. I want to listen to it again. Just me, you're a super towel. I'm giving you fluffy super towel hugs. Let's listen to that part again.
She remembered any discussions with her team about...
if you're just tuning in, we're watching the Rachael Rollins, we're listening to the Rachael Rollins OIG report. If you're interested in how that John O'Keefe probe started and why it might have been fake, but then why even that fake probe was covered up, even though Rollins probably did it just to get Morrissey because they found the Sandra Birchmore cover-up. Let's look at this. I've never seen such an intimate look inside the U.S. Attorney's Office in Boston. This is fascinating.
to respond in some fashion to the law professor, she said that she may have said that. She told us that she did not remember what happened in this instance, but that generally she believes it is important for her office to respond to letters, even if only to say thank you for your letter. The first assistant told us that although he was aware that Rollins knew the law professor, he did not know the law professor, and he was concerned that any MAUSAO response to the law professor could make its way to the media and be used to further an agenda that may not be what the MAUSAO would want.
Very interesting. Josh Levy, first assistant is Josh Levy here. He's very media savvy.
In particular, the first assistant stated that he did not think the MAUSAO should respond to the letter because any response could be used to suggest that the MAUSAO was looking into the allegations against Hayden. The first assistant stated that he ultimately advised Rollins to backburner any potential law professor response until the MAUSAO, in consultation with IRSA, determined what role, if any, the MAUSAO would have in a potential Hayden investigation. Separately, the Public Corruption Unit Chief and Criminal Chief discussed the law professor's letter, and, according to the Public Corruption Unit Chief, he told the Criminal Chief that he had no intention of responding to the letter. The Public Corruption Unit Chief told us that he believed at the time that it would be foolish to engage with someone who appeared to want his letter publicized because the Public Corruption Unit Chief had been trained as a prosecutor not to take actions to influence an election.
Hold on. We have to pause here. That was Dustin Chao who cut off Medved's attempt to help Rollins. I wonder if Rollins hated Chao by the end. Okay, hold on. When did this complaint get submitted with Medved attached to it? Hold on. Why would people ever write a letter without a date? That's the part I don't understand. Hold on, though. Let me see here. Let me see if I put the date in my post. Why is there no date? Hold on. I have to look up. This could be incredibly important. Oh my God, it was filed in 10 of 2023. Oh, I figured it out. Professor, I figured it out. Ladies and gentlemen, I figured it out. Chao cut off Medved and Rollins' efforts here. Look at this. This is incredible. It's incredible. Oh my God, and that's why Medved in 2023, is that when this was filed? Oh, that's incredible. Oh my God. Oh, this is incredible. Rollins came to hate Chao, and Medved joined the ethics complaint against Chao after this. And it was because Chao cut it off. Oh my word. What a story. No shit. This is wow. Hey, remember when you tell this, all you people out there? I figured it out. Somebody tell the globe. No shit. You really would have to know what you were reading to understand what this is. And then to understand, first of all, to even know about this ethics complaint against Chao. But then to know that Medved might have joined it because Chao cut off him and Rollins' plan. Oh, it's glorious, ladies and gentlemen. Oh, it's putting together the puzzle. I'm so pleased we did this. I knew it. This document is only a gold mine for like 5 people in the whole world. There's only a few people, because you either have to be involved in this, or you'd have to have studied it so well that you could just read between the lines. And I totally can here. I know they try to hide people's names. I knew every single person just by how they were referencing them. Medved, I had to Google a little bit, but I was able to put it together. And the timeline, Medved made an ethics complaint against Chao after Chao was the one who intervened because Oh my God, I wonder if Chao and Levy took out Rollins over this. Oh, that's brutal. That's brutal. And then that's why Medved hated Chao, well, for multiple reasons, but mostly because Chao hurt his buddy there in Rollins. Oh, that's brutal power politics. Oh, just brutal. I hate it, but it's brilliant. It's also interconnected. This is what Richard Nixon was talking about when he was talking about the liberal intelligentsia. They're too smart for their own good. Why do we give these people positions of power? This is a terrible idea. I'm not muted. I'm here. Thanks for being here, Tower friends. But yeah, this is huge. The implications of this are that Rollins and Levy, well, Rollins with Levy's help, maybe he was like a begrudging pawn, or eventually he just made his power play. Rollins and Levy were trying to get Hayden, right? And they had to get around this recusal issue. But then the public integrity section, led by Chao, didn't really want to go along with it. And so Chao was the one who wouldn't let Rollins respond to Medved's letter. And Rollins wanted, I see why this was happening. Rollins wanted Levy and Chao to respond to Medved's letter so that Medved could leak the response so that people would think Hayden was being investigated. Levy saw it and was like, I'm not doing this shit. And then Chao was like, I'm not doing this shit. And then I think both Levy and Chao might have turned on Rollins. And then once Chao was out, once Rollins was out, and Medved must have knew before this OIG report even came out, because I think he was interviewed by the OIG. He must have knew that they took her out over this, and rightfully so, in my opinion. And so he was like, fuck you, Dustin Chao. And then he joined an ethics complaint against him. Oh, my God. I mean, it's not like the most explosive story in the world, but for a journalist covering this, holy shit. That's some shit. Yeah, I am a towel, Ange. It's great to see you, my dear friend. And you're doing good with your operational security, Ange. I love to see you protecting your name there, doing all sorts of good things. Look at all the towel friends learning. But this is some shit. I got to listen to this part again. I think some of them are listening to this. Hello, Professor. This is some crazy shit. What were you all doing up there? This is ridiculous. All right. Hold on. All right, let's go back to this now. I want to start that part. Hold on, I want to start that part. We're going to go just a little bit back. Hold on, we're going backwards.
Specific recollection.
We're going backwards.
Separately, the Public Corruption Unit Chief and Criminal Chief discussed the law professor's letter, and, according to the Public Corruption Unit Chief, he told the criminal chief that he had no intention of responding to the letter. Separately, the Public Corruption Unit Chief and Criminal Chief, the first assistant, told us that although he was aware that Rollins knew the law professor, he did not know the law professor, and
the first assistant told us, so Levy cooperated against Rollins.
He was concerned that any USAO response to the law professor could make its way to the media and be used to further an agenda that may not be what the USAO would want. In particular, the first assistant stated that he did not think the USAO should respond to the letter because any response could be used to suggest that the USAO was looking into the allegations against Hayden. The first assistant stated that he ultimately advised Rollins to backburner any potential law professor response until the USAO, in consultation with IRSA, determined what role, if any, the USAO would have in a potential Hayden investigation. Separately, the Public Corruption Unit Chief and Criminal Chief discussed the law professor's letter, and, according to the Public Corruption Unit Chief, he told the criminal chief that he had no intention of responding to the letter. The Public Corruption Unit Chief told us that he believed at the time that it would be foolish to engage with someone who appeared to want his letter publicized because the Public Corruption Unit Chief had been trained as a prosecutor not to take actions to influence an election. The criminal chief told us that he had no specific recollection of a conversation about whether to respond to the law professor's letter, but that his advice would have been not to send a response at all or, at most, to send a non-substantive acknowledgement letter. The first assistant told us that after it became clear that the USAO would be recused from any potential Hayden investigation, Rollins told him again that she wanted to respond to the law professor's letter and began to tell the first assistant what she wanted in the response. The first assistant stated that Rollins really want, a response to go to the law professor and described Rollins as pushing him a little bit on the issue. According to the first assistant, the language Rollins proposed created the impression that there was an investigation into Hayden. The first assistant stated that Rollins also wanted the letter to state that she, Rollins, had sought a recusal. The first assistant told us that he immediately told Rollins that she had been recused, and that he would handle the issue in consultation with others.
He burned her. He saw but what's wild is they fucking did it to Morrissey too, and Levy, the sanctimonious little bastard, in my opinion. Sorry, Josh Levy, you're suing President Trump. I mean, what do you want from me? The sanctimonious little bastard, he's like, look at Rollins doing this to fucking Hayden. How could she? But then when it comes to Morrissey, he's like, fuck it. Run the playbook. What the fuck is this? I need an adult again. Somebody call the Congress.
Rollins told us that she did not recall any conversations in which she advocated sharing with the law professor that she sought recusal, but that, if she had said that, it would have been based on wanting there to be information that something was happening to convey to the law professor.
Look at this. Hold on, look at this again. Look at how hard she pushed and Levy stopped her on the Hayden thing, but look how hard she pushed. We're going to listen to this paragraph again. Rollins was pushing Levy to respond to this letter to the professor in a way that was like designed to make it appear to the public that Hayden was under investigation. Sound familiar? It's just that Levy stopped her. I wonder why Levy doesn't like Morrissey. Someone tell me why Josh Levy doesn't like Michael Morrissey. Or, in the thing that I really hope's not true, please someone tell me that Josh Levy and Karen Reed didn't like each other. That would be fucked up. I don't know. I'm not going to say Karen gets around, but like, people talk, Karen.
Rollins told us that she did not recall any. According to the first assistant, the language Rollins proposed created the impression that there was an investigation into Hayden. The first assistant stated that Rollins also wanted the letter to state that she, Rollins, had sought a recusal. According to the first assistant, the first assistant told us that after it became clear that the USAO would be recused from any potential Hayden investigation, Rollins told him again that she wanted to respond to the law professor's letter and began to tell the first assistant what she wanted in the response. The first assistant stated that Rollins really want, a response to go to the law professor and described Rollins as pushing him a little bit on the issue. According to the first assistant, the language Rollins proposed created the impression that there was an investigation into Hayden. The first assistant stated that Rollins also wanted the letter to state that she, Rollins, had sought a recusal. The first assistant told us that he immediately told Rollins that she had been recused, and that he would handle the issue in consultation with others. Rollins told us that she did not recall any conversations in which she advocated sharing with the law professor that she sought recusal, but that, if she had said that, it would have been based on wanting there to be information that something was happening to convey to the law professor that he did not need to talk to her about it anymore. The USAO executive officer told us that she also had a discussion with Rollins about whether the USAO should respond to the letter. The executive officer said that she told Rollins that she, the executive officer, believed no response was necessary. According to the executive officer, Rollins stated that she knew the law professor and believed the office should send a response. The executive officer stated that she recalled speaking about this potential response letter with Rollins off and on, and maybe also speaking about it with the first assistant. The executive officer told us that the first assistant eventually took the lead in responding to the law professor's letter.
Levy took her out. That's some shit. Wow. All right. I don't know if I want to be involved in the government like that. I'll investigate that stuff for the OIG, but I'm not. Like, that's some shit, man. Like, these people, like, I thought, like, the politics of, like, nonprofits and state government, this is like brutal, and it's very interpersonal. That's what I don't like about it. It's so personal. It's not ideological. It's driven by ideology. Like, they all share similar ideologies, whatever. But it's very like, oh, you fucked with my friend. Oh, you fucked with my friend. Oh, you're not going to do this with the U.S. Attorney's Office. No, but you don't understand. You got to fuck this guy over. He fucked with my friend. No, we're not doing that because of your friend. We're not. That's going to compromise the integrity of the office. Oh, but when Karen Reed walks in, that's a little different. You know, it's just like, what the? It's all very political. And I don't even think Levy and Chao or whatever really cared that Rollins was doing this shit. I think it's that they saw it as an opportunity to move on her, and they were like, I want this woman out. And I can kind of see why they wanted her out. And I think they had so I think the triumvirate, it wasn't a Rollins, Levy, and Chao triumvirate. It was a Levy, Chao, and this executive officer who cooed Rollins. Oh, they didn't just coup her, they freaking coup de grace her. They, like, the OIG helped him out because this was some shit. But these motherfuckers, they took her and they just ended her political career. For over this shit. I've never seen anything more brutal in my entire fucking life. And this was sitting in front of me the whole time. I wouldn't have understood it. I'm glad I didn't read it till now. This was a political execution. I mean, she deserved it in some sense. No wonder she's working at college now or something. I mean, it's cushy, but they politically executed her. Wow. It's all like high school, but on a fucking baller level. Oh my word. At least what I love about it is it's so fucking good. There's nothing like, it's all petty, but there's nothing like, they're so good at it. Like, they know what they're doing. They're actually professional. I don't like anything about it, but they're fucking good at it. So give them credit there.
The first assistant consulted with officials in ears as GCO about a response to the law professor, and GCO ultimately approved his proposed response. That response, which the first assistant sent to the law professor on September the 9th, after the primary election, stated, "Thank you for your the 16th of August, 2022, letter to U.S. Attorney Rachael Rollins. Someone from the Department of Justice will be in touch with you if we need additional information."
So I got to say this, ladies and gentlemen, let me tell you right now, the reason Medved sent that letter and Rollins got so desperate is that Arroyo lost that primary. And the DOJ, she was desperate to help Arroyo because at the last minute, Hayden definitely dropped on Arroyo or the campaign that information about Arroyo being involved in the SA, having been accused of SA. But I'll tell you, ladies and gentlemen, we're about to find out that after Arroyo loses the primary, this is just the start. Rollins freaking goes nuts at Hayden, and she tries to use her office even more. Get ready. This is just getting started. I am so happy we did this.
25/6. August 17 to 19, Rollins and Arroyo exchange encrypted messages about the law professor's letter and an impending negative Globe article about sexual assault allegations against Arroyo between August the 17th and 19th. Rollins had multiple communications with Arroyo by phone and by encrypted messaging that included references to the law professor's letter and a soon-to-be-published story in the Globe concerning sexual assault allegations against Arroyo. On the 17th of August at 11:56 p.m., Arroyo called Rollins, and they spoke for over 35 minutes. We asked Rollins when she first discussed the law professor's letter with Arroyo, noting that Arroyo references the letter in an encrypted message with Rollins 2 days later, which we describe below. Rollins replied, "I don't know if I don't, as I sit here today, recall discussing the letter with Arroyo." Rollins later stated while she did not recall if she discussed the letter with Arroyo, she never gave Ricardo Arroyo a copy of that letter. On the 19th of August, Rollins and Arroyo began communicating with each other by encrypted messaging rather than text messaging. 26 Rollins told us that Arroyo was the one who made this change, and Rollins stated that she did not recall Arroyo commenting on the reason for the change. Using this new platform...
Hey, Murder by Maestro, remind you of Arca a little bit? Hold on. What do we have questions about? Hold on, I'll check the chat. What do we have questions about? Hold on. Yeah, no, so hold on. Just so folks understand, Aiden used to write negative articles about Rachael, but they were talking behind the scenes. That was cover. His articles about her. Hold on. What is the What is the question that we have? Weird. Yeah, no, I don't know why. You should. It could be a YouTube thing, but just let me know if there's anything going on. I'm going to go back to listening to the document. I'm going to try to keep an eye on your comments. But yes, it's very, very clear here that this has a lot of parallels to the shady shit that was going on with Arca. Like they switched to Signal, and she was like, yeah, I don't remember why, like, I don't know why we would change to Signal. Like, you think the OIG is going to be like, oh, yeah, it's cool. Of course, you switch to Signal or encrypted apps because you're doing something weird. The other thing is, I just noticed, when you become like U.S. attorney or a prosecutor, the people who investigate you have more power than you, like the OIG. They can like get your encrypted messages, your apps. This is some shit. Rollins had to lawyer up for this. This is some shit. I'm glad we're here for this together, Chao friends. All right. So I'm going to... All right, here we go.
On the 19th of August, Rollins and Arroyo exchanged the following encrypted messages. 12:43 p.m., Arroyo, the law professor, sent the request to Globe. 12:43 p.m., Arroyo, and Globe asked if there was any indication us attorney's office would take it up. 12:43 p.m., Arroyo, FYI. 12:43 p.m., Arroyo, they are interested. 7:20 p.m., Rollins, unidentifiable emoji. 7:21 p.m., Rollins, any movement for you. 7:21 p.m., Arroyo, we are still pushing. 25 This response was in accordance with Justice Manual 1-7.410, which states, in part, receipt of a request to open an investigation may be publicly acknowledged, but care should be taken to avoid implying that the referral will lead to an investigation.
So this is talking about the response they sent to Medved up earlier. But those, so this is up here. It's footnote 25, that letter after the primary to Medved, just saying there would be nothing. But then the other thing you got to keep in mind, these texts between Arroyo and Rollins were on an encrypted app, and of course the Globe, so Medved sent the request to the Globe. This was at the right before the primary when Arroyo was about to face the sexual assault stuff. This is what they tried to use because the stuff came out about Arroyo. They were going to try to use this on Hayden. Rollins really did abuse her office. This is really bad, and you can see here in the encrypted messages, Medved sends the stuff to the Globe. Now the Globe wants to know from Medved if there's any indication that the U.S. Attorney's Office would take it up. So you see what's happening? Medved sends it to the Globe. Globe sends to Medved, says to Medved, is there a open investigation? Medved says to Arroyo, okay, Arroyo, the Globe's interested, even though Medved and Arroyo are both working for Rollins. So Medved says to Arroyo, can Rollins confirm a federal investigation? Arroyo then says over to Rollins, this is what Medved said. Rollins doesn't get back to him and confirm a federal probe, but do you see how this whole structure was working? Now we're down here on footnote 25, which was about something else, and now we're going to read footnote 26 about the encrypted apps that they were using.
There is a distinction between reviewing a request and opening an investigation. 26 The encrypted messaging service they used is an app for smartphones that allows users to send messages, images, audio, or video over the internet. The service is very similar to text messaging. The encrypted messaging service advertises itself as a way to message privately and adds, your privacy is our priority. After the initial encrypted message...
Hold on, let me see. Is it Signal? Hold on, let me see. Encrypted app with slogan, your privacy is our priority. Hold on. Oh, wow. Wow. They weren't using Signal. The only apps that use this specific phrase, the phrase your privacy is our priority, it's only used by these companies. Whisper, they might have been using Whisper, which is a blockchain-based messenger app that emphasizes security and anonymity. We have to find out if Whisper talks about messaging privately. But if they were using Whisper, that's like ultimate. Now, might not have been Whisper because they were stored. Now, it could have been a dual messenger app, which is like a WhatsApp sort of add-on. It could have been Wire. And this Wire is a secure messaging app for individuals and businesses that states your privacy is always our priority. So that's not necessarily the same one. There's something called Private App, which uses it. And then there's something called Imperial Eagle, which provides encrypted infrastructure and security services with the slogan, your privacy is our priority. So it looks like Whisper is the most likely culprit. So it's beyond Signal. And you want to know what's interesting? You can't really even put Signal on government devices. So it makes me wonder, did Rollins and Arroyo know something about Signal being compromised? I thought Signal was compromised by Pegasus spyware a long time ago. So Signal, I just don't trust. When Alan Jackson was using Signal, I was like, bruh. Come on. Come on. What are you, in 2017? I don't even know if Signal was around back then, but come on. If Pegasus can hack it, every state can hack it. Come on. So, therefore, I think they're using something that's more than Signal. I think that they're using something that's it does seem to be Whisper. Now, that tells me a lot. It tells me that the people who are in the fucking know that look at search warrants from feds think that app is better than Signal. You see how I'm reading between the lines? If you're Rollins, you're reading fucking federal subpoenas all day. You're reading federal search warrants. You're a U.S. attorney. So you know exactly what the feds have the ability to search. Therefore, the reason the feds aren't saying the name of this app, the OIG, is they know whatever app she was using is probably the one of the few apps that are impenetrable for even high level DOJ operations. I bet we have everything cracked. Not the US. I bet the US has everything cracked from Signal to WhatsApp. Everything is monitored in real time. But I bet there are some very unique services, probably all with very specialized end-to-end encryption where the user is the only one who actually can do the decryption. And even then, I bet only some of them are actually impenetrable by the government. And that's if they're not monitoring you on the backbone and all that other stuff. But and maybe you could even encrypt it in a way that could, when on-ramping to the backbone, salt it in such a way. Obviously, numbers stations do that. But the point is, this is not Signal. They are using an app that the government, I think Rollins probably knew couldn't be accessed. Hello, Mandy Strong. You came in for a Super Towel late-night stream. It's going to be hard to catch you up, but we're learning about how Rachael Rollins weaponized the office of U.S. Attorney in Boston related to the Suffolk DA Kevin Hayden. And fascinatingly, in the context of this weaponization, it seems that we found out that Josh Levy and maybe Dustin Chao and then this unnamed executive officer of the U.S. Attorney's Office in 2022 took out Rachael Rollins and then put Josh Levy in the post. So it is some crazy stuff. And then in return, one of a professor who was trying to help Rollins. So what was going on is Rollins was trying to help a Boston city councilor named Ricardo Arroyo win a primary for Rollins' old Suffolk DA seat against a candidate who was more moderate. They were both Democrats, this guy named Kevin Hayden and Rollins' ally Ricardo Arroyo. There was an October surprise. It was actually an August surprise that came out in the primary, came out a few weeks before the September 2022 primary between Hayden and Arroyo. That August 2019 article, August 19, 2022 article about Arroyo involved allegations of SA. Now, that in turn ruined Arroyo's chances of winning the primary. So Rollins, who was then U.S. Attorney, very powerful position in Massachusetts, used her office in an attempt to help Arroyo get out of this big trouble he was in because he was going to lose the primary. Rollins wanted Arroyo in there to keep up her legacy of progressive soft on crime prosecution. and she was trying like hell to get an investigation, or at least like get the media to think there was a federal probe of Hayden, the Suffolk DA that was trying to run against Rollins' ally. So Rollins created basically a federal probe, and then Rollins tried to get this professor that she knew, and it was really weird. She apparently agreed to go to a book signing for him, and then in return he wrote a letter to her office, to Rollins, suggesting that the Hayden be investigated, trying to look independent, really doing it as a favor to Rollins. Rollins then used a letter from the professor, Medved, and went around trying to get the rest of the U.S. Attorney's Office to investigate Hayden. And not just that, but to reply to Medved's letter in a way that would allow Medved to leak it to the Globe to hurt Hayden in a lead up to the primary. Because obviously Rollins was trying to interfere in the election to help Arroyo win. Well, that all went south because Josh Levy and another guy named Dustin Chao, who was the head of the Public Integrity Section, didn't want Rollins to do this, and they clearly went to the DOJ OIG. And then this faction, these three people, the executive officer, Josh Levy, who was then the first U.S. assistant attorney in Boston, and Dustin Chao, the head of the Public Integrity Unit, then came together in a triumvirate and took out Rachael Rollins. And what's interesting, though, is that Medved, the professor who wrote the letter, then was friendly with Rollins. After Rollins gets taken out, like a year later, Medved joins an ethics complaint against Dustin Chao. Take a bow, towel. Take a bow. You did it. Good job, little buddy. I'm proud of you. You put it all together. I'm not exactly sure you're happy with the results. I don't necessarily love this about our system.
From the encrypted messaging
but by
service
God,
that stated, messages or
towels.
calls are end-to-end
Oh,
encrypted.
sorry if that was playing.
No one outside of this chat, not even this service, can read or listen to them.
Hold on. I'm gonna continue playing the encrypted service footnote. So we're gonna start it from the beginning. Hold on.
26. The encrypted messaging service they used is an app for smartphones that allows users to send messages, images, audio, or video over the internet. The service is very similar to text messaging. The encrypted messaging service advertises itself as a way to message privately and adds, "Your privacy is our priority." After the initial encrypted message from Arroyo, Rollins received a message from the encrypted messaging service that stated, "Messages and calls are end-to-end encrypted. No one outside of this chat, not even this service, can read or listen to them." Tap to learn more. 8:02 p.m. Arroyo, they are in hold right now. 8:02 p.m. Arroyo, call me when you're sick, alone I can update you. 27. Based on this exchange and other messages, Arroyo's statement that they are in hold right now appears to be referring to the impending Globe story about closed sexual assault investigations involving Arroyo. As noted earlier in Section 2. On the 23rd of August, the Globe reported that Arroyo had twice been investigated by the Boston Police Department for sexual assault, once in 2005 and again in 2007. 28. When we asked Rollins whether, in her conversations with Arroyo leading up to this encrypted message exchange, she had talked to him about the fact that her office may open an investigation into Hayden, she responded, "I don't believe that I said that." She added that she did not believe that it was novel to think that the U.S. attorney might look into it. 7. August the 19th and 20th, Rollins and Globe reporter exchange text messages about law professor's letter, and Rollins urges reporter to keep digging. After Rollins's call with Arroyo on the 17th of August, and minutes before their 19th of August message exchange above, the Globe reporter reached out to Rollins asking about the law professor's letter and whether the USAO intended to open an investigation. Rollins told the Globe reporter that her office may be issuing a public statement about that. Specifically, on the 19th of August at 12:01 p.m., the Globe reporter sent a text message to Rollins stating, "I have a letter the law professor sent you earlier this week about the handling of the transit police officer's case. The law professor was calling for you to launch an investigation. I'll reach out to the USAO executive officer, but just curious if you're going to." 29. Rollins responded the following day at 2:43 p.m. 27. Call detail records do not reflect that Rollins called Arroyo close in time to this message exchange, as he requested. 28. See Suffolk. The candidate Ricardo Arroyo was twice investigated in possible sexual assaults. He says he was never informed the Boston Globe the 23rd of August, 2022, bostonglobe.com/2022/08/23/metro/Suffolk candidate Ricardo Arroyo was twice investigated possible sexual assaults. He says he was never informed #text equals in %20 the %202005 %20 case %2c %20 the recording %20 to %20 the %20 police %20 records, accessed April 5, 2023. Among other things, the story notes Arroyo stated that he had never been told about the allegations until last week. 29 The law professor told the ORG that he shared his letter to Rollins with the Globe as an FYI. The law professor stated that he has a close relationship with a number of Globe reporters, including this particular Globe reporter. According to the law professor, the Globe was not interested in the letter at the time because no investigation or other steps had been taken. I think we may be issuing a brief statement.
Okay, so just so folks understand, Medved just totally blew himself as a source for the Globe. Like, I'll tell you, like, I can't. First of all, Medved got definitely interviewed by the OIG because it just says there, the law professor told the OIG. Medved was pissed at Chao. Oh my God, Medved got pulled into this and had to be interviewed. That's why he filed that. I bet that's why he filed the ethics complaint. Oh boy, that was hiding under the surface. And holy shit, every newspaper in the city has an interest in just being quiet about this if he's one of their sources. I'm a little towel. Look at me being a little towel. Oh, what lies beneath, ladies and gentlemen. Look at what Rollins did when she couldn't get, literally, this is fucked up. When she couldn't get the DOJ when Levy and Chao stopped her from releasing a response to Medved's letter that would allow her to influence the primary, she was like, fuck it. And she just went straight to the fucking Globe reporter and was like, fuck it. Yeah, we might be. Like, you fuck. No wonder they fucking burned her at the stake. That's so fucked up. That's fucked.
About that next week. I will let you know. We asked Rollins about what she meant when she told the Globe reporter the USAO may be issuing a brief statement about that next week. Rollins replied, "We may be issuing a statement about receiving a public letter, now that the Globe knows, about a letter that was sent that I didn't give, the Globe reporter. I will let you know, is what I'm assuming that I'm talking about. But I didn't tell the Globe reporter about the law professor's letter." Rollins also stated that she did not know whether the USAO had started working on some kind of public statement when she told the Globe reporter that the USAO may be issuing a brief statement about that next week.
She got desperate. You see, she got desperate. The Globe wasn't going to do what she wanted. She got desperate. And, hey, what's up, D-Nice? Oh, yeah, we're having a special Super Towel long stream because I'm reading for the first time the actual OIG report about Levy, Rollins, and Chao. It's the most interesting thing in the world. This is as good as Black Mass, if not better. This is the greatest thing I've ever read. It put everything together for me. I've never had this much energy. You don't understand. I may as well be a Super Towel. We're staying up. Get ready. It's late night with Towel. I should probably eat again because I don't normally stay up this late, so I'm going to get dinner. You all hang out. We're listening to this. This is the greatest thing I've ever seen. I should get a coffee, too. Maybe I'll get one delivered. You think someone will bring me Dunkin' Donuts? I think I can get that. I think one of the apps will bring me Dunkin' Donuts. Okay, well, I have a plan. You focus. I'm going to get a coffee and a sandwich. Oh, I'm going to get a sandwich and a coffee. I'm an excitable towel, and we're going to keep listening to this. The DOJ is probably like, what the fuck? Why do people listen to this? Why is it him that figured this out? This is ridiculous. He thinks he's a towel. Well, you know what? You're all fucking ridiculous. Do you see this fucking petty shit? I'm allowed to be a towel.
In the same text chain on the 19th of August, Rollins offered the Globe reporter additional negative information about the Suffolk D.S. office and encouraged him to keep digging. On a separate note, Hayden's first assistant DA defended violent or corrupt police. Hayden's first assistant DA calls defense ATTY and says no interest in pursuing the former transit officer case. Entire special prosecution team leaves, who handles all of the police corruption cases. The entire team leaves, they do not replace anyone in that dedicated, important unit until you start sniffing around. Keep digging. Emphasis in original. Rollins then sent the Globe reporter another text message offering him further questions he should ask Hayden. If they claim they had no idea, ask Hayden if he met with me before taking office. If he read any of the binders we had created for him. If he did any exit interviews with staff that were fleeing in droves. He didn't. You can't be willfully blind and claim you never saw something.
That's why she hated him. He wouldn't march to her tune. Oh, she hated Hayden. Because, he was I'm my own guy. Hayden was appointed by a Republican governor, Charlie Baker. And he wouldn't march to Rollins' tune, and he didn't have to. Yes, and you can see why she was possessive. It was her. She was elected. He wasn't. He went on to be elected. But at that time, she was leaving office. It was her office. Oh, this is... I finally get it. Oh, this is the greatest thing I've ever read. I want to call this DOJ OIG and just be like, you can be on the Supreme Court with Hank Brennan. So and Boston Globe, we got to have a talk. We got to have a sit-down talk. I love you, dear. All right, hold on. Let's have this talk right now. I love you dearly, Boston Globe. I support you. I love you dearly. What the fuck? It's irresponsible. It's irresponsible just because you're involved not to cover this shit. It's irresponsible. I don't know who the fuck. I don't know what the fuck. I don't know. Jesus. Oh, dear goodness. And same thing with the Herald. It's fucking irresponsible. It's irresponsible. This should have been out there a long fucking time ago. I partially blame both of your institutions. I will be having a conversation with your managers. I'm not really sure which, let's just say I have lots of options. I'm going to be having some conversations. I'm very deeply, first of all, I'm not even going to say first of all. We need to go back to listening to this before I lose faith in the Boston Globe entirely.
Emphasis in original. We asked Rollins if she provided this additional information to the Globe reporter with an expectation that he would write another negative story about Hayden. Rollins responded, "But I wasn't trying to have articles written. I'm just saying, if they are really looking into whether or not there was a quid pro quo happening, and people were looking into this or not, I promise you, this is the level when a different Globe reporter was writing articles about me, that we were getting public records requests for millions of things. It just seemed odd that there was not an inquiry into these things, and that there are ways that people can find out, true or not, whether people were doing it. That's what I did when I responded to him." The 22nd of August, Arroyo asks Rollins about...
She was trying to mislead the OIG. The OIG was like, you were clearly trying to get him to write a story. She was like, no. I just wanted to know why the Globe was doing public records requests on me. And, it was just about... and then they don't even comment on it. They're like, yeah, she's lying. And they you'll find at the end of the report, they accuse her of violating 18 U.S.C. 1001, which is willfully misleading or lying to a government official or law enforcement officer, federal law enforcement officer. So she fucked up. I don't know how she didn't get charged. She should be federally charged. I don't know what the statute of limitations is. Someone call President Trump, charge this woman, in my opinion. Charge her.
Potential federal criminal investigation into Hayden in light of upcoming negative Globe story about Arroyo, and Rollins responds, "I'm working on something." On the 22nd of August, Rollins and Arroyo exchanged numerous encrypted messages about his campaign strategy and the forthcoming Globe story about Arroyo having previously been under investigation for allegations of sexual assault. Rollins gave Arroyo feedback on his draft answers to the Globe reporter's questions and told Arroyo in a text message, "Ask the Globe reporter to call me about the sexual assault suspect question. I will answer off the record." Arroyo replied to Rollins that he would tell the Globe reporter to contact Rollins, and Rollins then suggested that Arroyo tell the Globe reporter to contact some previous DAS as well. Also on the 22nd of August, Rollins sent an encrypted message to Arroyo that included a recent op-ed piece in which a Massachusetts state senator endorsed Kevin Hayden for Suffolk DA. Rollins wrote to Arroyo, "Who is writing something like this for you?" Arroyo's initial reply did not answer Rollins's question and, instead, asked Rollins whether her office would be announcing an investigation of Hayden. As shown below, Rollins responded by advising Arroyo that he needed the law professor to release his letter publicly and that she was working on something. 8:57 p.m. Arroyo, are you all announcing an investigation into the former transit officer situation with Hayden? 8:57 p.m. Arroyo, would be the best thing I can have happen at this moment. 9:02 p.m. Rollins, you need the law professor to release his letter. 9:06 p.m. Arroyo, Rachael, you know what I am dealing with right now with the Globe. 9:06 p.m. Arroyo, sick, not currently calling electeds to write opts. 9:07 p.m. Arroyo, sick, literally fighting a punch meant to end my career. 9:08 p.m. Rollins, understood. Keep fighting and campaigning. I'm working on something. We asked Rollins why she told Arroyo that he needed the law professor to release his letter, which led to the following exchange. OIG attorney, so, my question to you again is, why did you tell Arroyo on the 22nd of August that he needs the law professor to release his letter? MS Rollins, so, he is asking me, I'm sorry, before that, are you announcing an investigation into the former transit officer? I don't answer that, right? Would be the best thing I can have happen at this moment, I don't answer that. I say this is not the same as the state senator, blah blah blah. When are they announcing an endorsement or Globe or what have you? And for me, he has mentioned the law professor's letter to me that I haven't responded to. And this is 6 days after I received the law professor's letter, and I think 3 days after he has mentioned the law professor's letter, but I think, for me, I never released the law professor's letter. Nor would I. OIG attorney, and so my question is why did you tell Mr. Arroyo that he needs the law professor to release his letter? MS Rollins, because I'm not. OIG attorney, to help his campaign and to hurt Mr. Hayden's campaign. MS Rollins, no, not. OIG attorney, by exposing that somebody has asked for a DOJ investigation. MS Rollins, no. Actually, no. OIG attorney, then why, explain. MS Rollins, yeah. OIG attorney, because this is important. Explain to us why it's not that. MS Rollins, I am not going to ever say to Ricardo Arroyo that I am investigating Kevin Hayden, right?
All right, pause. I got to start this again. Sorry. That got very hard to understand because I tried to order my coffee. I need a coffee to understand this, but the coffee isn't here yet. Oh, my goodness. So hold on. We got to try that again. We're going to start with we asked Rollins. So hold on.
9:08 We asked Rollins why she told Arroyo that he needed the law professor to release his letter, which led to the following exchange. OIG attorney, so, my question to you again is, why did you tell Arroyo on the 22nd of August that he needs the law professor to release his letter? MS Rollins, so, he is asking me, I'm sorry, before that, are you announcing an investigation into the former transit officer? I don't answer that, right? Would be the best thing I can have happen at this moment, I don't answer that. I say this is not the same as the state senator, blah blah blah. When are they announcing an endorsement or Globe or what have you? And for me, he has mentioned the law professor's letter to me that I haven't responded to. And this is 6 days after I received the law professor's letter, and I think 3 days after he has mentioned the law professor's letter, but I think, for me, I never released the law professor's letter. Nor would I. OIG attorney, and so my question is why did you tell Mr. Arroyo that he needs the law professor to release his letter? MS Rollins, because I'm not. OIG attorney, to help his campaign and to hurt Mr. Hayden's campaign. MS Rollins, no, not. OIG attorney, by exposing that somebody has asked for a DOJ investigation. MS Rollins, no. Actually, no. OIG attorney, then why, explain. MS Rollins, yeah. OIG attorney, because this is important. Explain to us why it's not that. MS Rollins, I am not going to ever say to Ricardo Arroyo that I am investigating Kevin Hayden, right? I'm not going to do that. And I also had no interest in releasing the law professor's letter, but if Arroyo knows about the law professor's letter, the law professor gave him the letter or somehow he has a copy of that. My point was simply, I'm not doing what you're asking. You have something that has asked our office to do something. You should release it. That's why I said it there, by not answering the other questions. OIG attorney, no, but my question is why did you do that? Ms. Rollins, because I wasn't answering his other questions. I think the law professor's letter lays out that the U.S. Attorney's Office has been asked to do something. We also asked Rollins about her text message to Arroyo that stated, "Understood. Keep fighting and campaigning. I'm working on something." We specifically asked Rollins what she was working on. Rollins replied, "I'm not sure. Like, I think it's innocuous, like, generally speaking, but it's not a specific, I'm indicting somebody." Rollins later reiterated, "I am telling you that nothing I did regarding a letter, that I didn't ask to be written to me, happened before the election. I would never have put a finger on the scale, publicly, regarding an election involving whether it was my office or some other office at all, and I didn't ask the law professor to write me a letter. Like, I feel like these things happen to me, right? They occur and then I can't undo that they are there, but I'm not releasing the law professor's letter. I didn't give the law professor's letter to the media or do anything like that. So, nothing happened before the election." 9. The 23rd of August, The Globe publishes a story about prior sexual assault allegations against Arroyo, and Rollins proposes Arroyo respond by stating that Hayden is likely the subject of multiple criminal investigations. On the 23rd of August, The Globe published a story about prior sexual assault allegations against Arroyo. 30. Shortly thereafter, Arroyo sent an encrypted message to Rollins with a draft statement rebutting the allegations. Arroyo asked Rollins for her feedback on the statement. Rollins proposed numerous, substantive edits to the draft statement, including adding the following language that referenced multiple criminal investigations likely being underway against Hayden. "The extremely recent and very real tactics and unethical actions of this acting and his leadership team have been well documented and substantiated by law enforcement, criminal defense attorneys and the Massachusetts Office of Campaign and Political Finance. Multiple investigations into the acting this likely criminal behavior, from mere months ago, are likely. 30. See Suffolk. The candidate Ricardo Arroyo was twice investigated in possible sexual assaults. He says he was never informed. The Boston Globe, the 23rd of August, 2022, bostonglobe.com/2022/08/23/metro/Suffolk. The candidate Ricardo Arroyo was twice investigated possible sexual assaults. He says he was never informed. #text equals in %20 the %202005 %20 case %2c %20 the recording %20 to %20 the %20 police %20 records. Accessed the 5th of April, 2023. Underway. I am confident that the voters will see his attempted smear campaign as exactly what it is, a desperate attempt by a man about to lose his job. 10 August 24 to 29, discussions between USAO.
Do you understand what that means? She was helping Rollins Arroyo draft his response to allegations he was investigated for SA. Like, what the fuck? It's so political.
About USAO recusals between the 24th of August and the 29th of August, the USAO first assistant had multiple communications with IRSA regarding finalizing the recusals related to the Suffolk DA matters. On the 24th of August at 2:33 p.m., the IRSA AGC who was handling the USAO recusals emailed the first assistant asking if there was a USAO case number for the civil rights investigation of the former transit officer. The first assistant responded to the AGC the following day stating that he was waiting to hear back on this. The first assistant eventually sent the case number to the AGC on Monday, the 29th of August, and asked the AGC if he had a sense of timing on when this gets finalized. The AGC responded at 11:11 a.m., I hope to have these completed and back from the Associate Deputy Attorney General by the middle of the week. As we discuss below, IRSA sent the recusals to USAO later that same week, on Wednesday, the 31st of August, and Thursday, September the 1st. 11 August 28 to 30, Arroyo asks Rollins for update on potential Hayden investigation, and the Globe runs another story about the sexual assault allegations against Arroyo. On Sunday, the 28th of August, Arroyo asked Rollins for an update on a potential federal investigation of Hayden, sending her an encrypted message stating, "What's going on with the investigation into him, and is that moving?" Rollins did not respond to these messages. On the evening of the 30th of August, 1 week before the primary election, the Globe published another article about the sexual assault allegations against Arroyo, describing the...
Oh no, the ceasefire has been rejected? That's not good. Let's keep an eye on it, Diana. Thanks for keeping us updated. My coffee isn't here yet, so give Towel 10 minutes until I get the coffee, but I'm paying attention to this DOJ OIG report, and it's unbelievably explosive.
allegations made by one of Arroyo's alleged victims. 31 Shortly before the story was released, Arroyo called Rollins at 6:10 p.m., and the call went to voicemail. Rollins then sent an encrypted message to Arroyo at 6:24 p.m., stating, "What's up? In meetings? Can't talk." Arroyo told Rollins that the media was about to report that a woman who had alleged that Arroyo had sexually assaulted her was standing by her complaint, and also claimed to have an email from Arroyo about the incident. Rollins responded by expressing surprise about 31C woman who accused Suffolk the candidate Ricardo Arroyo of sexual assault breaks silence. The lies. It makes me sick. The Boston Globe, the 30th of August, 2022, bostonglobe.com/2022/08/30/metro/woman who accused Suffolk the candidate Ricardo Arroyo sexual assault breaks silence lies. It makes me sick. The information. 32 The day after the Globe's article, on the 31st of August, the Globe reported that a number of Massachusetts public officials had withdrawn their prior endorsements of Arroyo. 33 days before the primary, IRSA provides recusal memoranda to USAO, and Rollins contacts the Boston Herald reporter who later authors the 11th of September article about a possible DOJ investigation of Hayden. In this section, we describe the memoranda the USAO received on the 31st of August and the 1st of September, 2022, formally recusing the entire USAO from any investigation of Hayden and his first assistant DA, and formally recusing Rollins only from any civil rights investigation of the former transit officer. We then described how Rollins reached out to a Boston Herald reporter on the 31st of August and September the 1st requesting an off-the-record discussion. The reporter was the author of the 11th of September story published in the Herald that quoted from the IRSA recusal memorandum, discussed the possibility of a federal...
All right, that's enough for me to figure out who it is. September 11th, 2022, Boston Herald, Kevin Hayden. Oh, and I bet they probably linked to it. All right, who is the author? Who is it? Sean Philip Cotter. Hi, Sean. I'm a towel. I'm a little towel. I'm just doing my towel thing. I'm just trying to be a towel. I can't do anything about being a towel. I was born this way. Don't blame me. Blame Flint. Hey, my mom writes for the Herald. What do you want me to do? I'm just a little towel.
Investigation of Hayden, and cited a federal law enforcement source which Rollins later ultimately admitted to the OIG was a reference to her. Shortly after Rollins spoke with the reporter on September the 2nd, the reporter contacted the law professor seeking information from the law professor about his 16th of August letter to Rollins and a potential DOJ investigation of Hayden.
You see why Rollins gave up on the Globe after they ran the Arroyo article? Because that means Rollins knew the Globe was going with Hayden. And so Rollins' only option, remember it was a Democratic-only primary, Rollins' only option to burn Hayden now was to go to the Herald, which is like a Republican paper. Oh, she's such a political player.
We also describe the reporter's efforts on September the 3rd to obtain confirmation or comment from the Suffolk D.S. office and the USAO regarding the existence of a DOJ investigation into the Suffolk DA office's alleged decision not to prosecute the two transit police officers. After having made these inquiries to the USAO and Suffolk D.S. office, the Herald did not run a story before the primary election about any such investigation.
You know what that tells me? Herald was more okay with Hayden than Arroyo. Otherwise, Herald would have ran that. Herald wanted, and remember, newspapers want people to win. They might tell you they don't, but they do. Herald was okay with Hayden, so they held the story. That probably went right up to the top of the Herald, too.
32 On September the 2nd at 6:18 p.m., Arroyo sent an encrypted message to Rollins that included a link to a local television interview in which Arroyo alleged that Hayden's driver was the person who leaked the sexual assault allegations against Arroyo. Rollins replied at 9:37 p.m., "Unreal." Arroyo responded 2 minutes later by sending Rollins a link to his Twitter account. At 11:25 p.m., Rollins sent an encrypted message to Arroyo with a link to a Massachusetts general law provision that allows a majority of the Massachusetts Supreme Judicial Court justices to remove officers, including a district attorney, from their positions. Arroyo immediately responded, "Yeah, I'm filing a complaint." 33C Wu, Warren, Markey, Presley, and others pull their support of Arroyo in Suffolk. This race. The Boston Globe, the 31st of August, 2022.
Wow, hold on. So that was all of Rollins' people. Markey and all that. The whole Democratic establishment was behind Arroyo. Oh, wow.
bostonglobe.com/2022/08/31/metro/Suffolk-race swooples her support Arroyo # text equals %E2 %80 %9 the %20 events %20 of %20 the %20 past longer %20 endorsing %20 in %20 this %20 race. %E2 %80 %9D, access 5 April, 2023. 1 August 31 September 1, MA USAO receives recusal memos from the Office of the Deputy Attorney General regarding the Hayden-related investigations. The MA USAO received 2 recusal memoranda from EASA regarding the information contained in the August 6, 8, and 10 Globe articles. 34 First, on the 31st of August, Rollins and her first assistant received a recusal memorandum from EASA informing them that Associate Deputy Attorney General, ADAG, Bradley Wayne Shiema had approved the recusal of only Rollins, not the entire MA USAO, from the civil rights investigation / matter involving the former transit officer. The memorandum stated that the MA USAO would handle the matter, and the first assistant would supervise it as acting U.S. attorney. Second, on September...
Oh, wow. Levy was moving on her. Levy became acting U.S. attorney for the purposes of that investigation, which went nowhere. Oh, they moved on Rollins. Wow.
The first, Rollins and her first assistant received a formal recusal memorandum from EASA informing them that ADAG Wayne Shiema had approved the recusal of the entire United States Attorney's Office for the District of Massachusetts from the investigation and possible prosecution of Suffolk County, Massachusetts District Attorney and First Assistant District Attorney. According to the recusal memorandum, the matter would be handled by another U.S. Attorney's Office in New England USAO. The email forwarding the recusal memorandum was addressed to the U.S. Attorney for the New England USAO, the New England USAO First Assistant, Rollins, and the MA USAO First Assistant, with copies sent to Wayne Shiema, the EASA General Counsel, 2 GCO supervisors, and the MA USAO Ethics Advisor. Shortly thereafter, the MA USAO Ethics Advisor forwarded the email to the Criminal Chief, his then Deputy Criminal Chief, now Co-Criminal Chief, and the Public Corruption Unit Chief. The MA USAO First Assistant estimated that he knew the formal recusal was coming a couple days before receiving the recusal.
This is Josh Levy, by the way, First Assistant.
Memorandum. The criminal chief involved in the earlier discussions about whether to initiate an investigation into the possible quid pro quo and whether the MA USAO should respond to the law professor's letter told us that he learned from the first assistant that there was going to be an office-wide recusal even before it was formal. The criminal chief said that he was not sure how long before but that the first assistant kept him in the loop on his discussions with GCO. As noted previously, the EASA AGC handling the recusals emailed the first assistant on Monday, the 29th of August, that he hoped to have the recusals completed by the middle of the week. The 34th EASA General Counsel told the OIG that a recusal memorandum is considered a non-public, sensitive DOJ document in instances where, as here, the case is uncharged or the existence of an investigation is unknown. After the case has been charged or the investigation has been publicly confirmed, the General Counsel stated that EASA instructs U.S. Attorneys' offices that the recusal memorandum is intended to be a public document, suitable for filing in court to properly reflect why a U.S. Attorney's office from a different district is now handling a case on behalf of a recused office. The General Counsel also added that the U.S. Attorney's office handling the matter should normally make the decision about when, if at all, the recusal memorandum becomes public.
Which is basically saying
First Assistant
Rollins
told us that he would have passed this information on to Rollins as soon as he was told.
Which is basically saying Rollins should never have leaked that recusal memo.
We asked Rollins if she was updated on the status of the recusal process between her second phone call with the EASA General Counsel on the 17th of August and the receipt of the recusal memorandum on September the 1st. Rollins replied, "Not that I remember." Despite the office-wide recusal on what the recusal memorandum referred to as the investigation and possible prosecution of Hayden and his first assistant DA, the MA USAO did not have an investigation open at the time, and, according to the criminal chief, the office's public corruption unit had not taken any steps towards opening such an investigation. When we asked the criminal chief why a formal recusal was sought under these circumstances, he told us that he did not know why or who made the decision to seek recusal. He explained that, in his experience, normal MA USAO practice was to initiate the recusal process only in instances where the office planned to open an investigation. He said he could not explain why normal practice was not followed in this instance, but that he thought that the law professor's letter may have played a role. The first assistant told us that he helped initiate the approval process, as Rollins and the EA's general counsel discussed, because he thought it was important to obtain GCO's advice on who could be involved in decisions about whether to respond to the law professor's letter and whether ultimately to pursue an investigation or not.
Yeah, I think Levy maybe was willing to go along with this until she got caught.
2 August 31 September 3, Rollins speaks, at her request, with the Herald reporter, and the Herald then contacts the law professor, Ma USAO, and the Suffolk D.S. office about a possible criminal investigation of Hayden on the 31st of August. Rollins initiated what became an off-the-record discussion on September the 2nd with a Boston Herald reporter, the same reporter who, as noted previously, authored the 11th of September Herald article that cited a federal law enforcement source and stated that Rollins and the Ma USAO were recused from a potential DOJ investigation of Hayden and his first assistant DA concerning the information appearing in the August the 6th Globe article. Rollins ultimately admitted during an ORG interview that she was the federal law enforcement source cited in the 11th of September article. As we discuss below, less than an hour after the Herald reporter spoke with Rollins on September the 2nd, the Herald reporter contacted the law professor to discuss his letter to Rollins regarding a possible Hayden prosecution, with the Herald reporter telling the law professor that he heard there might be some movement on that. The following day, as we also describe below, the Herald contacted both the Ma USAO and Suffolk D.S. office seeking comment about information that the Herald had received regarding a possible prosecution of Hayden. Both the Ma USAO and Suffolk DA office's spokesperson responded to the Herald by, among other things, questioning the timing of the allegation given that the primary election was in 3 days. The Herald did not run the story before the primary election but, as we detail later, did publish it on the 11th of September after Rollins provided the Herald with the recusal memorandum. Rollins's text messages and off-the-record discussion with the Herald reporter on the 31st of August at 2:15 p.m., Rollins sent a text message to the Herald reporter stating, "Quick call." The Herald reporter responded that he was busy at the moment but had time for a call later. Rollins then sent a text asking him to call when he was free and added, "All off the record." When the Herald reporter did not call her, Rollins sent another text message to the Herald reporter on September the 1st at 9:45 p.m. asking for a quick call. Call detail records of Rollins's personal cell phone show that the Herald reporter called Rollins shortly thereafter, and the call went to voicemail. Rollins called the Herald reporter the following day, September the 2nd, at 7:43 p.m., and their call lasted for almost 17 minutes. 35 as described more fully in section 2.g.2, when we first asked Rollins on the 6th of December, 2022, whether she had any communications with the Herald reporter about his the 11th of September, 2022 article before it was published, she testified, "I don't believe so, no." She also denied being the federal law enforcement source cited in the article and told us that she did not have any suspicion as to who the source was. After we described the call detail records we obtained, showing that she spoke to the Herald reporter on September the 2nd for approximately 17 minutes and, as we discuss later, on September the 9th for approximately 15 minutes, Rollins testified at different times that she could not recall their conversations or that she did not believe she discussed a possible DOJ investigation of Hayden with the Herald reporter. Then, when we asked Rollins whether she provided the Herald reporter with a copy of the recusal memorandum, Rollins asked for a break from the interview and declined afterward to answer further questions about the Herald article until she had the opportunity to review her records. 1 week before we asked Rollins about the Herald story on December the 6th, the ORG advised Rollins's attorney that we planned to ask Rollins questions about the recusal memorandum that was quoted in the Herald story, and we provided him with a copy of the 11th of September Herald article and access to review the recusal memorandum. During a continuation of the interview on the 15th of December, 2022, when she produced to the ORG her text messages with the Herald reporter detailing their communications, Rollins admitted that she was, in fact, the
Whoa, so this is December of 2022. That investigation into Morrissey started in November of 2022. That was Rollins. She knew she was on her way out. I figured it out. The Reed probe was Rollins was on her way out. She knew she was on her way out. And that was just her trying to fuck Morrissey like she tried to fuck Hayden. Not literally, but screw them over. Wow.
Enforcement source referenced in his 35. Rollins also called the Globe associate editor on September the 1st, and they spoke for over 6 minutes beginning at 11:02 a.m. Rollins told us that she did not recall why she reached out to the Globe associate editor on this date and said that her call to him may have been a butt dial or she may have called him about something unrelated to the matters she eventually discussed with the Herald reporter.
Oh my God! A butt dial! Ladies and gentlemen, we have a butt dial! Oh, ladies and gentlemen, I repeat, I repeat, we have a butt dial. Someone tell Turtle Boy Rachael Rollins claims she butt dialed the associate editor of the Boston Globe. Oh, God, it's even better than I imagined. How is it possible? I love cosmic irony. You don't understand. You don't understand the fact that the word butt dial, who butt dials the associate editor of the Boston Globe? I am having the time of my life right now. Oh, God, I can't believe the word butt dial is in an official OIG report. They put it in scare quotes. Oh, I'm having the best day of my life. My coffee's almost here. All right. We got to keep listening to this because I have to get my coffee when it arrives or I'm not going to be able to keep listening. I have been up since like 4 in the morning. Butt dial. Oh, this is the greatest thing ever.
When we asked Rollins whether she pitched a story to the Globe associate editor about a potential DOJ investigation of Hayden before she connected with the Herald reporter, she told us, "I don't think so. I don't believe I did. But I need to know what happened. On the 1st of September was there an article from, I don't." When we asked Rollins whether, during a continuation of the interview on the 15th of December, 2022, when she produced to the OIG her text messages with the Herald reporter when we asked Rollins whether she pitched a story to the Globe associate editor about a potential DOJ investigation of Hayden before she connected with the Herald reporter, she told 35 as described more fully in section 2.g.2, when we first asked Rollins on the 6th of December, 2022, whether she had any communications with the Herald.
Hold on. Where's the butt dial? Hold on. During a continuation. Hold on. Oh, here we go. So it's right after this. It starts here.
During a continuation of the interview on the 15th of December, 2022, when she produced to the OIG her text messages with the Herald reporter detailing their communications, Rollins admitted that she was, in fact, the federal law enforcement source referenced in his 35. Rollins also called the Globe associate editor on September the 1st, and they spoke for over 6 minutes beginning at 11:02 a.m. Rollins told us that she did not recall why she reached out to the Globe associate editor on this date and said that her call to him may have been a butt dial or she may have called him about something unrelated to the matters she eventually discussed with the Herald reporter. When we asked Rollins whether she pitched a story to the Globe associate editor about a potential DOJ investigation of Hayden before she connected with the Herald reporter, she told us, "I don't think so. I don't believe I did. But I need to know what happened. On the 1st of September was there an article from, I don't believe I did." The 11th of September article, but Rollins told us that she still did not recall why she texted the Herald reporter on the 31st of August and September the 1st seeking a conversation with him off the record and that she still did not recall their conversation on September the 2nd. She told us during another continuation of her interview on the 24th of January, 2023, that she only recalled talking to the Herald reporter about the Suffolk DA matters after the primary election took place on September the 6th. The Herald's requests for comment on a potential Hayden investigation shortly after the Herald reporter talks to Rollins on September the 2nd. On Friday, September the 2nd, at 8:40 p.m. Approximately 40 minutes after the call between Rollins and the Herald reporter ended, the Herald reporter sent a direct message on Twitter to the law professor introducing himself and stating, "I understand you reached out to the DOJ about the Hayden/Transit Police issue, and I've heard there might be some movement on that. Would you be able to give me a call on Saturday, tomorrow?" 36. The law professor told the OIG that, in response to this message, he spoke with the Herald reporter on Saturday, September the 3rd, but he said he did not recall the specifics of what they discussed. He told us that he recalled sending the Herald reporter a copy of his 16th of August letter following the call. The law professor also told us that he knew who the Herald reporter was and followed him on Twitter, but the law professor stated that he did not believe he had ever communicated with the Herald reporter. 36. The law professor told the ORG that, in response, when we asked Rollins whether she pitched a story to the Globe associate editor about a potential DOJ investigation of Hayden before she connected with the Herald reporter, she told us, "I don't think so. I don't believe I did. But I need to know what happened." On the 1st of September was there an article from, I don't believe I did. The 11th of September article, but Rollins told us that she still did not recall why she texted the Herald reporter on the 31st of August and September the 1st seeking a conversation with him off the record, and that she still did not recall their conversation on September the 2nd. She told us during another continuation of her interview on the 24th of January, 2023, that she only recalled talking to the Herald reporter about the Suffolk DA matters after the primary election took place on September the 6th. The Herald's requests for comment on a potential Hayden investigation shortly after the Herald reporter talks to Rollins on September the 2nd. On Friday, September the 2nd, at 8:40 p.m. Approximately 40 minutes after the call between Rollins and the Herald reporter ended, the Herald reporter sent a direct message on Twitter to the law professor introducing himself and stating, "I understand you reached out to the DOJ about the Hayden/Transit Police issue, and I've heard there might be some movement on that. Would you be able to give me a call on Saturday, tomorrow?" 36. The law professor told the ORG that, in response to this message, he spoke with the Herald reporter on Saturday, September the 3rd, but he said he did not recall the specifics of what they discussed. He told us that he recalled sending the Herald reporter a copy of his 16th of August letter following the call. The law professor also told us that he knew who the Herald reporter was and followed him on Twitter, but the law professor stated that he did not believe he had ever communicated with the Herald reporter prior to this contact. When we asked Rollins whether she suggested to the Herald reporter, or the law professor, that the two should talk, Rollins told us, "No, I don't have any recollection of doing that." On September the 3rd, at 12:05 p.m., department call detail records reflect that the Herald reporter called the USAO executive officer. According to the executive officer, the Herald reporter asked about the law professor's letter and stated that he had a law enforcement source who said the USAO or DOJ was investigating Hayden. 37. As we discussed below, Rollins admitted to the ORG that she was the federal law enforcement source referenced in the Herald reporter's article that was published in the Herald on the 11th of September. According to the executive officer, she told the Herald reporter that she could not confirm or deny the existence of any investigation, and she counseled the Herald reporter. 36. The law professor voluntarily produced this message to the ORG. 37. The executive officer had recalled that this discussion happened a week earlier, but call records reflect it occurred on September the 3rd. To use his common sense and be careful that his source was not trying to influence the election. According to the executive officer, the Herald reporter responded with words to the effect of, "I'm glad I called. I feel like you talked me off the ledge."
Holy shit. Bruh. Rollins sent Medved to the Herald reporter. The Herald reporter called the executive officer, who was Rollins' subordinate, who stopped the article from running. Oh, this is better than an episode of House of Cards. This is the greatest thing I've ever seen.
Shortly thereafter, on September the 3rd, at 12:21 p.m., a different Herald reporter emailed the Chief of Communications at the Suffolk D.S. office and stated, in part, "I'm following up on information that there will be an investigation into the Suffolk District Attorney's Office over this decision not to prosecute 2 transit police officers who filed false police reports in a traffic stop. I was looking for a response from this office regarding the investigation, which involves a claim that one of the officer's attorneys, a donor to Kevin Hayden, prompted the not to prosecute." 38. In response, the Suffolk D.S. office told the reporter that the office had not made a prosecutorial decision in the matter. The investigation into the transit police officers was open and active, and suggested that the Herald vet their sources thoroughly because this has the ring of campaign season silliness. 3. The Herald does not run a story prior to the primary election about a possible investigation of Hayden after having made these inquiries to the USAO and Suffolk D.S. office. The Herald did not run a story before the primary election about an investigation into Hayden or the Suffolk D.S. office regarding the transit police stop. As we discussed below, when the Herald reporter reached out to the Suffolk D.S. office on Friday, September the 9th, 3 days after the election, to follow up on this allegation, he noted in his email that the Herald ultimately decided to hold the story that it had reached out about the prior weekend. Arroyo loses primary election and Rollins tells Arroyo that Hayden will regret the day he did this to you. Watch. As noted previously, on September the 6th, Hayden defeated Arroyo in the Democratic primary race for Suffolk DA. The Associated Press called the race for Hayden shortly before midnight. Beginning at 11:22 p.m. that evening, Arroyo sent Rollins a series of encrypted messages updating Rollins on the status of the vote counting and expressing pessimism about his chances for victory. At 11:24 p.m., Arroyo messaged, "Your legacy work deserved better, the county deserved better, and I wish we were able to deliver it." Rollins responded at 11:25 p.m. 38 The OIG obtained this email from the Suffolk D.S. office. "This was just dirty and unethical. Such a piece of shit, illegal, move they did by leaking victims' sick records. They are not above the law. He will regret the day he did this to you. Watch." Arroyo responded, "I hope so. I really need it for my heart because this was literally illegal and harmful f." To which Rollins responded at 11:27 p.m. "And I am proud and grateful that you put your hat in the race. Keep your head up high. You know your truth. And you can file ethics complaints and demand investigations until you get your answers. The truth always comes out." We asked Rollins whether her statements, "He will regret the day he did this to you. Watch," were references to the article that the Herald ultimately published on the 11th of September, and Rollins told us that she was not referring to that. She said that she was referring to her statement to Arroyo 2 minutes later that, "He truth always comes out." Days after the primary, Rollins discloses.
Oh, really, Rachel? Really, Rachel Rollins? Let's see if you actually meant that.
The DOJ recusal memorandum to the Boston Herald as evidence that DOJ is taking steps toward investigating Hayden as described below. 5 days after the primary election, on the 11th of September, 2022, the Herald, quoting a federal law enforcement source, reported that the USAO sought and received a recusal from a possible federal investigation of allegations of political corruption involving Hayden and his principal deputy. 39 According to the article, the federal law enforcement source told the Herald that the potential investigation centered around information that first appeared in the 6th of August, 2022 article in the Globe suggesting that Hayden and his deputy may have decided not to pursue the police misconduct case against the transit police officers in exchange for $225 in political donations from the former transit officer and his attorney.
Oh, hello, just pausing. Someone asked if I'm going to be live in the morning. I think it might be late morning, maybe, D-Nice, maybe after 11 tomorrow. Oh, no, you need a dentist appointment. So it really depends on how long it takes me to get my oil change done. If I get it done by 9 a.m., I'll try to start D-Nice. It might be a little after that, but we'll do our best to keep you company. For now, let's continue.
40 The Herald article
Great to
quoted
see so
from
many
the 1st of
friends.
September, 2022 recusal memorandum, stating, "This is formal notice that Bradley Wayne Shima, Associate Deputy Attorney General, ADAG, has approved the recusal of the entire United States Attorney's Office for the District of Massachusetts from the investigation and possible prosecution of Suffolk County, Massachusetts District Attorney and First Assistant District Attorney." 39 Rachael Rollins request as Feds I Suffolk the Kevin Hayden in MBTA Transit Police Case Boston Herald, the 11th of September, 2022, bostonherald.com/2022/09/11/ Rachael Rollins request as Feds I Suffolk Day Kevin Hayden into Transit Police Case / accessed the 2nd of March, 2023. 40 It was you. Traffic spat turned police cover-up leads to questions for the Hayden. The Boston Globe, the 6th of August, 2022, bostonglobe.com/2022/08/06/metro/ It was your traffic spat turned police cover-up leads questions the Hayden / accessed the 3rd of February, 2023. The article stated that a nearby United States Attorney's Office was likely to handle the investigation. The article also reported that these moves toward a review were prompted, in part, by the law professor's letter requesting a federal investigation. In the discussion that follows, we describe Rollins's disclosures to the Herald after the primary election, including the circumstances leading up to Rollins's texting the Herald reporter photos of the recusal memorandum before he published his article. We also describe the Herald's contacts with the Suffolk D.S. office.
She literally sent him pictures of the recusal memorandum. That's crazy. That's crazy.
And the USAO seeking comment a second time on a potential DOJ investigation. In the discussion that follows, we describe Rollins's disclosures to the Herald after the primary election, including the circumstances leading up to Rollins's texting the Herald reporter photos of the recusal memorandum before he published his article. We also describe the Herald's contacts with the Suffolk D.S. office and the MAR USAO seeking comment a second time on a potential DOJ investigation. We then provide the substance of the 11th of September Herald article in its entirety, as well as describe Rollins's communications with her leadership team pretending not to know how the article was able to quote from the recusal memorandum. Before these topics, we briefly describe Rollins's contact on September the 7th with the Globe associate editor, in which she forwarded someone else's public comment stating that the Globe was responsible for Arroyo's election loss. 1 September the 7th, Rollins sends the Globe associate editor an MBTA Transit Police Twitter post blaming the Boston Globe for Arroyo's defeat on September the 7th at 10:35 a.m. Rollins sent a text message to the Globe associate editor and asked if he had time for a quick call. They spoke on the phone for over 5 minutes beginning at 10:46 a.m. Almost immediately after the conversation concluded, at 10:53 a.m., Rollins sent by text message to the Globe associate editor a Twitter screenshot that included a comment from the official account of the MBTA Transit Police responding to a post that noted Hayden had declared victory in the primary election. Let's keep it real. The Boston Globe defeated Arroyo, not Hayden. Hayden is totally inept and lacks the integrity to serve as though. Interestingly, your paper never challenged Hayden on his lying the Transit Police case. Hayden tried to dump the matter and got caught. 2 September the 9th, Rollins sends photos of the ears a recusal memorandum to the Herald reporter and asks the reporter to keep the source of the leak anonymous for fear of discipline. In what appears to be their first communication since the September the 2nd phone call, the Herald reporter sent a text message to Rollins on September the 9th at 1:17 p.m. asking, "Got time for a quick call today?" Rollins called the Herald reporter at 2:35 p.m., and they spoke for over 15 minutes. Later that afternoon, Rollins texted the Herald reporter photos of the recusal memorandum, provided him information about the law professor's letter and internal DOJ deliberations, and asked him not to attribute the information to her. We provide below their entire September the 9th text chain. 5:56 p.m., Herald reporter, "Higher. You able to send that?" 41:06:05 p.m., Rollins, "Off the record. Not attributed to me. Prefer you say source within DOJ with information who preferred to stay anonymous for fear of discipline or something like that. Also, you cannot leak the document." Rollins then texted the Herald reporter full-length photos of the first and second pages of the September the 1st recusal memorandum. 6:07 p.m., Rollins, "Would be even better if you could say likely not handled by Rachael or the District of Mass so it may be sent to New England USA office nearby." 6:11 p.m., Herald reporter, "Thank you very much." 6:11 p.m.
We got to
Herald
read this.
reporter,
We got to
"Thank you
read
very
this.
much."
We got to read this.
Later that afternoon, Rollins texted the Herald reporter photos of the recusal memorandum, provided him information about the law professor's letter and internal DOJ deliberations, and asked him not to attribute the information to her. We provide below their entire September the 9th text chain. 5:56 p.m., Herald reporter, "Higher. You able to send that?" 41:06:05 p.m., Rollins, "Off the record. Not attributed to me. Prefer you say source within DOJ with information who preferred to stay anonymous for fear of discipline or something like that. Also, you cannot leak the document." Rollins then texted the Herald reporter full-length photos of the first and second pages of the September the 1st recusal memorandum. 6:07 p.m., Rollins, "Would be even better if you could say likely not handled by Rachael or the District of Mass so it may be sent to New England USA office nearby." 6:11 p.m., Herald reporter, "Thank you very much. Is it okay if I quote directly from this document obtained by the Herald?" 6:14 p.m., Rollins, "As long as you can keep confidential where you got it and will never release it if someone makes a public records request. First paragraph on the second page gives you what you need," says the and first assistant. 6:14 p.m., Rollins, "If not, please no." 6:16 p.m., Herald reporter, "Absolutely. No one needs to know where this came from, and no one can request the newspaper." 6:16 p.m., Rollins, thumbs up emoji. 6:16 p.m., Herald reporter.
No one can request a newspaper. DOJ OIG was like, "Challenge accepted."
Exactly, I'll be looking just to say document says prosecution of and first assistant. 6:17 p.m., Rollins, "Probably better to say investigating and possible prosecution." 6:18 p.m. Herald reporter, "Yes, exactly, that's what I mean to write." As discussed previously and described in more detail in Section 2.G.2, Rollins denied being the Herald reporter's federal law enforcement source during her continued interview on the 6th of December, 2022. Rollins only admitted to being the source during subsequent testimony on the 15th of December, 2022, after she produced the text messages above, which definitively showed that Rollins had indeed been a source for the reporter and had disclosed to him the recusal memorandum quoted in the story. On the 15th of December, Rollins told us that she shared this information with the Herald reporter because the Herald reporter had come to her with what he said was information from another source 41 at around this same time on September 9, at 5:59 p.m. and 6 p.m., respectively. Rollins received 2 encrypted messages from Arroyo. The first consisted of a link to an interview of Kevin Hayden on a local news show. The second stated, "I really need this man to not get away with the harm he's caused." Rollins did not respond to Arroyo's messages. That DOJ was not looking into the possible quid pro quo involving Hayden. According to Rollins, the way the Herald reporter was talking to me, he had information that I was relatively confident was a person from DOJ that he was speaking to. That was not me. He happened to be speaking to me. I'm from DOJ, but he was relating information to me, saying I am going to be writing a story, essentially, with all of this press about this, that DOJ has declined to look into this matter. I told him that is not factual at all, and we had a discussion about that. Ultimately, I don't know whether in that conversation or possibly another one, I don't recall as I sit here today, or whether that was one discussion or more than one discussion, I said I am actually aware of the fact that, I don't know what the outcome is going to be, but I will not be involved because I used to run that office. I don't know Kevin Hayden. We never overlapped. But it's not factually accurate that there isn't going to at least be an inquiry or an investigation. Ultimately, the Herald reporter said, "Is there, you appear to be, like, certain of that." How? I said, "The process is that you get a document. And for me, whether a good decision or not, I said, I have a document that is saying that there is at least, that refutes what you are telling me you are hearing, that somebody is looking into this. It will not be me, but somebody will. I don't know what the outcome will be, but it is not accurate to say the Department of Justice doesn't care about quid pro quos, isn't looking into police misconduct, etc. Potential police misconduct. And those were the circumstances surrounding this." Rollins told us.
She lied to them. Wow, she lied to the OIG. That is not why she was talking to the Herald, to dispel it. She was helping Arroyo out right after the primary. Oh my God, this is brutal.
That she shared this information with the Herald reporter because, as described in more detail in section 2.g.2, she believed it was important for the community and to the department that she correct what she believed was inaccurate information before it was published. When we asked Rollins about the specific statements she made in her text messages to the Herald reporter, she told us that she asked the Herald reporter not to attribute the information in his article to her because, "I didn't need to be quoted about it. It didn't need to be about me. It was more about the department is going to do the right thing and look into it." She said that she suggested the language about the source preferred to stay anonymous for fear of discipline, or something like that to mirror language she had seen in other articles with leaked information, but that she was not in fear of being disciplined at the time. When we asked her why she told the Herald reporter that it was okay to quote from the recusal memorandum but not leak the document, she told us, I think I don't know. I don't have an answer to that."
She was like, well, yeah, you got me.
As described later in section 4. Our investigation found that Rollins had twice before provided non-public DOJ documents to reporters, including the same Herald reporter in one instance. In these 2 other instances, which occurred in May and June 2022, Rollins sent a DOJ document to the reporter in the same manner she sent the recusal memorandum to the Herald reporter on September 9, by texting photos of the physical document from her personal cell phone, rather than by forwarding the document from her work email. At the conclusion of her interview on the 24th of January, 2023, and in the context of these earlier disclosures, we asked Rollins why she would send the reporters photos of the physical documents, rather than forward the documents from her work email. Rollins told us that this method was the most private way of providing the documents.
Wait a minute. So, in May of June of 2022, she was also leaking to the Herald? I didn't even know that before now. I wonder what that was about. They didn't want to get into it. She was leaking shit all the fucking time. This is crazy. She was abusing the fuck out of that office.
We asked Rollins why she did not simply forward the documents to the reporters using her DOJ email account. Rollins replied, well, I guess I could, but it would be retained somewhere and it would be public, right? So, I was trying to send it in a way that was consistent with me asking for it to be confidential. She also stated, if I'm trying to sort of covertly send this to him, I wouldn't overtly send it from my work email. She added, I didn't, if I was trying to hide that I was sending this to him, I wouldn't send it from my work email. That's the reason I chose that. 3 September the 9th, the Herald reporter emails the Suffolk D.S. office for comment about a possible DOJ investigation, citing a federal law enforcement source. Shortly after the 15-minute call between Rollins and the Herald reporter on September the 9th ended at about 2:50 p.m., and before Rollins texted the Herald reporter photos of the recusal memorandum later that day, the Herald reporter contacted the Suffolk D.S. office. The Herald reporter referred to a federal law enforcement source and asked the Suffolk D.S. office for comment about a possible DOJ investigation of Hayden and his first assistant DA. The Herald reporter further noted that he expected to get more specifics about the possible investigation later that day. Specifically, the Herald reporter's 3:17 p.m. email to the Chief of Communications at the Suffolk D.S. office stated, according to a federal law enforcement source, the DOJ is looking into investigating the Suffolk D.S. office around the Transit Police investigation. I'm getting more specifics later today, but I wanted to put this on your radar before it got too late on Friday so you'd have a chance to respond. I believe one of my co-workers put this to you last weekend for a story we ultimately decided to hold. I'm essentially asking about the same thing. Is there anything that wants to say about this? After a follow-up question from the press office, the Herald reporter stated, let me clarify and get back to you. But moving toward investigating the allegations in the Globe piece is most likely the most accurate way of putting it. For the 11th of September, shortly before publishing the article, the Herald reporter seeks additional comment from USAO and the Suffolk D.S. office about a DOJ investigation into the Suffolk D.S. office, and Rollins provides the reporter with additional information on the 11th of September, at 11:35 a.m., shortly before the Herald's publication of the article. The Herald reporter emailed the USAO executive officers seeking comment from the USAO. Got a bit more on how Central DOJ has approved an office-wide recusal on an investigation into the Suffolk this office. I know that you guys can't talk about ongoing investigations, but I'm just covering my bases to see if there's anything else I should know. The executive officer stated that she and the Herald reporter spoke on the phone shortly after this email. Call detail records show that they spoke for over 4 minutes beginning at 12:12 p.m. According to the executive officer, the Herald reporter stated that his source now said there is an investigation and that the USAO is recused from it. The executive officer stated that the Herald reporter then read language directly from the recusal memorandum. The executive officer told us that she did not comment. The executive officer also told us that she did not tell anyone at the USAO about the Herald reporter's call given the USAO's recusal from the matter. The Herald reporter also emailed the Chief of Communications at the Suffolk D.S. office at 11:38 a.m., stating, finally got more info, Central DOJ has approved a recusal of Rollins' office from the investigation and possible prosecution of Suffolk County, Massachusetts District Attorney and First Assistant District Attorney per a memo obtained by the Herald. The quote, this is formal notice that Bradley Wayne Shiema, Associate Deputy Attorney General, ADAG, has approved the recusal of the entire United States Attorney's Office for the District of Massachusetts from the investigation and possible prosecution of Suffolk County, Massachusetts District Attorney and First Assistant District Attorney. Would either Kevin, Hayden, or the First Assistant DA want to comment on this? Obviously, I'll make it clear that investigations often don't lead to charge, that this isn't evidence of wrongdoing or illegal action, etc. In response to a question from the D.S. press office, the Herald reporter clarified at 3:54 p.m. that he was told, the memo issued this past week and he did not know when it was requested, but he was seeking that info. The Herald reporter then contacted Rollins, and the two exchanged the following text messages. 3:43 p.m., Herald reporter, what is the date that memo was issued? 4:12 p.m., Rollins, 9/1/22. At 4:13 p.m., the Herald reporter emailed the D.S. office again stating, correction from me on timing, memo issued, Ep1. The Herald reporter then contacted Rollins again, and the two exchanged the following text messages. 4:13 p.m., Herald reporter, thanks. Do you know offhand when it was requested? 4:16 p.m., Rollins, off the record. Immediately after I read the first Globe article, I reached out to DOJ. Then I received a letter from a law professor demanding that I conduct an investigation into Kevin Hayden and his first assistant. I think DOJ was fearful of weighing in and impacting the election. And of course, it would have and did. 4:44.
You mean, look at Rollins manipulating this reporter. Come on, reporter. Like, Rollins was the one who was trying to take out Hayden, and then when the Globe wouldn't run it, and neither would the Herald, and then Arroyo lost. This was Rollins going nuclear on Hayden. Rollins did this to Hayden. Imagine what she did to Morrissey. The only difference with the Morrissey thing was that they found the Birchmore thing. That's it. I got this whole thing. I got it down pat.
PM, Herald reporter, gotcha. Thanks. Rollins told us that she did not recall why she gave the Herald reporter this additional information about her conversations.
By the way, for those of you who are wondering, why can't Hank get this kind of stuff done? Why can't we get an investigation into what Levy and Arca did? I mean, we probably can. Because Levy sued President Trump. So in order to get all you need to do to get Josh Levy investigated for what they did, like if the O'Keefes or whatever want, what you really have to do is get in the room with somebody who's close to President Trump. And then you got to say to President Trump, like, Josh Levy is suing you. He used to be the U.S. attorney for the District of Massachusetts. He's suing you, and he did some fucked up shit. And by the way, Rachael Rollins, that, like, I would, if I were talking to President Trump, I would maybe call her like that crazy liberal woman to ingratiate myself. But I respectfully, if I were not with President Trump, I would say something like, you know, the very progressive prosecutor, Rachael Rollins, they did some crazy stuff. I would say some crazy shit to President Trump. You got to look into that shit. It's crazy, Mr. President. You don't understand. Like, these liberals were running a fucking muck up there, and they were fucking with each other, and they hated cops. Like, first and foremost, this all centers around how they hated fucking cops, and they hate moderates, and they just wanted to burn them down with federal investigations that, although in some cases led to some shit. I'm going to have to explain to him the Sandra Birchmore thing. I think the president's going to be a little overwhelmed with the Sandra Birchmore thing. But, the rest of this shit is just liberals going fucking crazy with each other. Just absolutely ridiculous. Abusing the government and playing politics with the DOJ. There's some of the craziest stuff I've ever seen in my entire life. And they were manipulating the Herald and the Globe. The Globe, what's interesting is, like, the Globe and the Herald before the election wouldn't run this shit about Hayden, because I think both the Globe and the Herald wanted Arroyo to lose. And so even after the election, I think the Globe, like, they were going with Hayden, and the Herald was like, fuck it. He's a Democrat. So the Herald wanted it, but the Globe didn't. And then you could tell Rollins went over the Globe reporter's head. She tried to go to the associate editor, and he killed it. Which means John Henry probably killed this, frankly. I bet John Henry wanted fucking Hayden over Arroyo. It all comes down to, like, who owns the paper, what do they want, why do they want it. It's kind of like, yeah, but see, I wouldn't do that because I'm a public information service. But it's all very fucking political. It's like, what does the reporter want? What does the editor want? You both might want the same thing, but if it, like, doesn't work for the politics of it all, like, a story can get killed. That's why I don't play that game. I don't like that shit.
With DOJ and the law professor's letter in response to the Herald reporter's question about the date she sought recusal. She told us, however, that she believed the information she gave him showed, when we read something that happens, we take it seriously, and we move quickly. Rollins said that her last sentence to the Herald reporter about DOJ being fearful of impacting the election and that it would have and did was speculation on her part as to why it took weeks for the recusal memorandum to be issued. She said that by stating it would have and did, she meant that the story did not come out before the primary election, and Hayden won by as much as he did.
The DOJ slow-walked the recusal because they were slow-walking you, Rachael Rollins. They knew, like, the whole apparatus knew what you were doing. You were trying to manipulate people, Rachael, I think, and you got caught, clearly.
The 11th of September, the Herald publishes an article about a possible DOJ investigation of Hayden, cites to a federal law enforcement source, and quotes from the EA's recusal memorandum on the 11th of September at 7:32 p.m. The Boston Herald published its article by the Herald reporter entitled, Rachael Rollins recused as Feds I Suffolk the Kevin Hayden in MBTA Transit Police Case. 42 The article stated in its entirety. 42 Rachael Rollins request as Feds I Suffolk the Kevin Hayden in MBTA Transit Police Case Boston Herald, the 11th of September, 2022, bostonherald.com/2022/09/11/ Rachael Rollins request as Feds I Suffolk Day Kevin Hayden into Transit Police Case / accessed the 2nd of March, 2023. U.S. Attorney Rachael Rollins' office has sought and received a recusal from a possible federal review of Suffolk the Kevin Hayden's actions and those of his top deputy in a case involving MBTA Transit Police, according to a memo obtained by the Herald. This is formal notice that Bradley Wayne Schiemer, Associate Deputy Attorney General, ADAG, has approved the recusal of the entire United States Attorney's Office for the District of Massachusetts from the investigation and possible prosecution of Suffolk County, Massachusetts District Attorney and First Assistant District Attorney. The Central Office of the Department of Justice wrote in a memo disseminated September 1. A federal law enforcement source said this centers around the Boston Globe story that made claims and suggestions that Hayden and his top deputy broomed an investigation into allegedly false reports written by MBTA Transit Police officers. We have received no information whatsoever regarding any external inquiry into this investigation, Hayden's office said in a short statement Sunday night. Hayden has repeatedly insisted he and his office did not act inappropriately, and that they continue to investigate the incident in question. The memo approves Rollins, who was Hayden's predecessor as Suffolk the before she was appointed U.S. Attorney for Massachusetts, to recuse herself, and to recuse the whole office. A nearby U.S. Attorney's office is likely to handle the case completely. A spokeswoman for Rollins' office declined to comment. It's DOJ policy never to confirm or deny the existence of an investigation. The Globe story on Hayden dropped last month amid the final days of a nasty primary race. Hayden has insisted nothing untoward happened and that he continues to investigate the allegations, which the Transit Police Department itself sought prosecution for. This issue became somewhat overshadowed in the waning days of this race when the Globe ran another piece on old sexual assault investigations against Hayden's opponent, City Councillor Ricardo Arroyo, who himself maintained he'd done nothing wrong and tried to lay the leak of the protected documents at Hayden's feet. Hayden won last week's primary and is not facing an opponent in the general election. The law professor, who focuses on prosecutorial misconduct, sent a letter to Rollins' office shortly after the Globe report on the transit police situation dropped, calling for the feds to look into it. He wrote in the 16th of August letter to Rollins, which a source said is part of what initiated these moves toward a review, that these allegations strike me as matters of grave public concern. I kindly request that you conduct an appropriate investigation into these and related actions. The law professor, on Sunday told the Herald, no one should be above the law, including prosecutors. No one knows where this will lead, but I'm glad they are taking a look.
Okay, so can I just say, if the Herald reporter actually knew what was going on, do you see how different that piece would have been? He would have wrote like Medved, who was his source for the freaking article. Like, this was a fucking hit piece. You want to talk about a fucking hit piece? Medved, the professor, the article would have actually been Rollins agrees to attend Medved book signing in exchange for letters sent to DOJ to justify Rollins' pretextual probe of Hayden. You see what I mean? Like, fuck around, find all the way the fuck out. No wonder why the Boston Herald hid this shit. Everybody fucking hid this report because no wonder no one's ever heard this report in full. Because nobody wants any of this out there. It makes the Globe look stupid as fuck and petty and political. It makes the Herald look fucking political. It makes the DOJ look like a clusterfuck of fucking high schoolers who are all in the honor society who shouldn't have access to prosecutorial discretion, not to mention on the federal level. Oh my God, someone write a book.
As we described earlier and in greater detail below, when we first asked Rollins during an ORG interview on the 6th of December, 2022, whether she was the federal law enforcement source for this Herald article, she denied that was the case. However, during the ORG's continuation of the interview on the 15th of December, 2022, after Rollins produced the text messages she exchanged with the Herald reporter, Rollins testified that she believed that she is the federal law enforcement source referenced in the article and that, while the story did not quote her exact words, she conveyed to the Herald reporter that the recusal memorandum centers around the information in the Globe about Hayden and his first assistant DA not pursuing the case against the former transit officer and another transit officer in exchange for $225 in campaign donations. She testified that she also conveyed to the Herald reporter that the law professor's letter initiated these moves towards a review. The Ma USAO criminal chief and Public Corruption Unit chief told us that they were shocked when they read the DOJ information that had been made public in the Herald article. In particular, the criminal chief stated, "It was obvious from the text of the article that someone within DOJ had provided the recusal notice to someone outside of DOJ. And it's obvious, an internal and confidential document. I would be shocked if any similar notice were leaked, but here, where we had the leak concerning a candidate for public office, who by that point, the primary had passed, and frankly, there was no mystery who was going to win the general. But nevertheless, the fact that it dealt with a candidate for public office made it even more disturbing and shocking." The criminal chief added, "It hurts the integrity of our office and the Department of Justice, and law enforcement generally. I think anyone reading this article in the Herald could assume, that somebody at DOJ is leaking confidential information and that hurts our integrity, and b, that they are doing it for a partisan purpose and that hurts our integrity even more."
All right, hold on. I gotta jump in. Who was the criminal chief of the DOJ? Hold on, this is actually incredibly important. All right. Who was the criminal chief of the Boston DOJ in 2022? No, not Boston DOF. The Boston DOF is not a thing. I said the Boston Department of Justice. This is fascinating. Hold on. No, yeah, but who was the head of the criminal division? Who was the head of the criminal division? Who was the criminal chief of the Boston, of the U.S. Attorney's Office for the District of Massachusetts in 2022? This is going to be tough. No, I know. But who was actually... Right, who was the head of the criminal section? All right, hold on. U.S. Attorney's Office announces new unit chiefs. We need the criminal chief from roughly like 2022. All right, criminal chief. Criminal. No. Who's the No, I got... Yes, it's Mass Lawyers Weekly. I got it. But who's the criminal chief? Do you got the criminal chief? No. Hold on. One more time. No, I need to... if anyone could help me... is this like a specific... Is it the criminal section? Like, what is the criminal chief? I don't know a lot about this part of it. Hold on. I need to know who was the criminal chief of the... And it's very hard to find this stuff out. So if anyone is able to help out with this, we're doing a late night stream, and I'm trying to figure out who was the criminal chief of the DOJ in Boston in 2022. It was not Dustin Chao, but this person is important because they have like a central role, I think, in some regard in what was going on here. They might have been one of the people who exposed Rollins, so hold on. List of criminal... Chief of the Criminal Section, U.S. Attorney's Office, District, Massachusetts. I bet we can find out who it is now, but I need to know who their predecessor was. Wait. It's the current one. So Attorney Leah Foley is both, but who was the chief? Bill Abley? Was it Bill Abley? Is Bill Abley? I wonder if it's Bill Abley. Hold on. Bill Abley, Chief Criminal Section, U.S. DOJ, Rachael Rollins. Not saying that this is 100% right, but I'm just trying to figure out who was the person that actually like put a stop to this. I mean, somebody did. Somebody figured it out. The question is who. And so I'm going to try to figure out who this chief of the criminal section was. I can't tell. Hold on. Okay, wait, hold on. Yes, it's Abley. I found it. William F. Abley. I was able to confirm it because I found a document here from the U.S. Look at this. Look how I found it. Look how good I am at this. So I found this DOJ release from January 26th of 2022. And then if you scroll down in it, you can see that it mentions the chief of the criminal section, and it says U.S. Attorney Rachael Rollins, Frederick J. Regan, Agent Special in Charge, Boston Field Office. And then hold on, we're going to find it right here. Attorney William F. Abley, Chief of Rollins' Criminal Division, is prosecuting the case. So it's Bill Abley. It was Bill Abley, and it looks like Bill Abley was like a very responsible person, clearly. Look at how he's talking about what Rollins was doing. And then it looks like Chao was responsible, like a responsible adult, and Levy was. But it also looks like they wanted Rollins out. And then it looks like Medved, with the professor from Northeastern, was pissed that Abley and Chao and Levy took Rollins out and cooperated with the OIG, and so Chao suffered for it. But the question still is, why'd they go after the Norfolk DA even after Rollins was gone? And I think the answer is either Levy and Karen might have had some kind of connection. I don't even want to ask. But then the other thing is, it's also very possible that Chao was still around, and even though Chao gave up Rollins on the Hayden thing, Chao was then like, oh, well, I still hate the Norfolk DA. Let's do the same shit to him. See, what I read this DOJ OIG report is like, they had to throw Rollins to the wolves, but the reality is they all would have gone along with this if she didn't get caught. It's just like how they do business, or were doing business. That's my read of this. That's why I think the OIG was freaking pissed, because the OIG would see this and be like, what are you all doing down there?
The criminal chief told us that the leak was a cause of great stress because it was obvious from the text of the article that someone within DOJ had provided the recusal notice to someone outside of DOJ. And it's obvious, an internal and confidential document. I would be shocked if any similar notice were leaked, but here, where we had the leak concerning a candidate for public office, who by that point, the primary had passed, and frankly, there was no mystery who was going to win the general. But nevertheless, the fact that it dealt with a candidate for public office made it even more disturbing and shocking. The criminal chief added, "It hurts the integrity of our office and the Department of Justice, and law enforcement generally. I think anyone reading this article in the Herald could assume, that somebody at DOJ is leaking confidential information and that hurts our integrity, and b, that they are doing it for a partisan purpose and that hurts our integrity even more." The criminal chief told us that the leak was a cause of great stress because it was a huge deal and nearly everyone in his division knew about it, and he was not certain at the time how to handle it from a management perspective. 6. The 11th of September, Rollins texts USAO leadership a link to the article and adds WTF, and how are they quoting things? Rollins does not inform them she was the source of the information within minutes of the Herald article first appearing online on the evening of the 11th of September. Rollins sent
tried to gaslight her own staff. No wonder they took her out.
A link to the article. Arroyo responded. The 11th of September, 8:13 p.m., Arroyo, thrilled. The 11th of September, 8:13 p.m., Arroyo, absolutely thrilled. We asked Rollins why she sent the Herald article to Arroyo. Rollins stated, "It's a matter of public record at that point. It had been written about, and I am released from it, but that somebody is going to do an investigation into what I believe, whether Ricardo, Arroyo, was a friend of mine or not, a quid pro quo happened, and I believed that it needed to be looked into. But I didn't give him, any information beyond what was reported in the Herald article." Also within minutes, Rollins sent a text message from her personal phone to the USAO first assistant, the executive officer, and another staff member with a link to the Herald article and the questions, WTF, and when was the office contacted about this? And why wasn't I called? How are they quoting things? At 8:31 p.m. that evening, the first assistant and Rollins spoke on the phone for over 12 minutes. According to the first assistant, Rollins was upset with the executive officer and asked the first assistant why she, Rollins, had not been told that the USAO had been asked for comment about the Herald article.
So it definitely, the executive officer, the criminal chief, the public integrity chief, and Levy all cooperated against Rollins. For sure, because the Rollins then called the executive officer and gaslit the executive officer, even though Rollins was the source of the leak.
The first assistant stated that he told Rollins that it was because she was ricust from the matter. According to the first assistant, Rollins responded that she was not ricust from things. Wait, no, this isn't the
executive officer. This is Rollins calling Levy. This is Rollins calling Josh Levy. We got to listen to this one again.
At 8:31 p.m. that evening, the first assistant and Rollins spoke on the phone for over 12 minutes. According to the first assistant, Rollins was upset with the executive officer and asked the first assistant why she, Rollins, had not been told that the USAO had been asked for comment about the Herald article. The first assistant stated that he told Rollins that it was because she was ricust from the matter. According to the first assistant, Rollins responded that she was not ricust from things that were in the public record and that public commentary about the office was different than knowing the details of an ongoing case. The first assistant told us that in his discussion with Rollins about the Herald article, Rollins never mentioned that she had communicated with the Herald reporter about the article before it was published. During her ORG interview, Rollins told us that she did not recall this conversation with the first assistant and she offered no explanation for why she did not tell her leadership team that she was the Herald reporter source for the article. ORG attorney, did you tell any of those three individuals or anyone else in your office that you had spoken to, the Herald reporter, about the recusal memo and this investigation? MS Rollins, I don't believe I had told them about that, no. ORG attorney, and why did you not tell them about it? MS Rollins, I just didn't. ORG attorney, all right. And then after this came out, I mean, did you tell them after the fact, oh, yeah, I talked to the Herald reporter on this? Like, I gave him the memo. MS Rollins, I didn't. No. ORG attorney, why not? MS Rollins, I just didn't. ORG attorney, did we see that you talked to the first assistant? So, he texts you back at 8:20 and says, call when you can. At 8:31 p.m., you all speak for about 12.5 minutes. Do you recall that conversation at all? MS Rollins, I don't recall the specifics of it, no. ORG attorney, did you tell him in that conversation that you gave the memo to the Herald reporter? MS Rollins, I didn't, no. ORG attorney, and why not? MS Rollins, I just didn't. Rollins told us that she did not believe that she needed to tell her team about off-the-record conversations she had with reporters. She also said she could see how implying that she did not know how the Herald reporter had quoted statements from the recusal memorandum could easily be looked at as being disingenuous with her team. Rollins further stated, I can admit that the fourth sentence in this text message, that was me not wanting anyone to know that I had had the conversation, and that's the statement I will give.
Yeah, busted.
G. Rollins's explanations for her contacts with the Globe and Herald, including her explanation for disclosing sensitive, non-public DOJ information to the Herald and for initially denying during her ORG testimony under oath that she had done so in this section, we describe Rollins's explanation for her contacts with reporters at the Globe and the Herald. This section includes Rollins's acknowledgement during her ORG interviews on the 15th of December, 2022, and the 24th of January, 2023, that she provided background information to the Globe reporter on both Hayden and the Transit Police misconduct investigation, despite her the 6th of December, 2022 ORG testimony that suggested she first learned about the Globe's interest in the Transit Police misconduct investigation from media reporting. We also discuss in greater detail her ORG testimony on the 15th of December and the 24th of January, when Rollins admitted that she was the federal law enforcement source referenced in the 11th of September Herald story and how she shared non-public department information with the Herald reporter. We also include Rollins's explanation for why, when the ORG first questioned her under oath on these topics on December the 6th, she denied being the Herald reporter source for his the 11th of September article, stated that she did not know or have any suspicion about who the source was, and declined to answer whether she gave the Herald reporter the recusal memorandum. 1. Rollins's explanation for her contacts with the Boston Globe and for her ORG testimony suggesting she did not know about the Globe's interest in the Transit Police misconduct matter prior to the articles. Publication on the 15th of December, 2022, Rollins testified that she spoke to the Globe reporter on background for his August the 6th, 8, and 10, 2022 articles because I don't want to be, sort of, quoted on this, because I can't be quoted any longer as Rachael, right? Like, I don't want to be looked at as the US Attorney, arguing with Kevin Hayden to say, like, are you kidding me? So, I sat on these cases, or you didn't get a case file or something like that. We asked Rollins if she had any concerns about talking to a reporter, within 5 or 6 weeks of the election, on background about someone running for elected office. Rollins replied, I didn't, and honestly, it was my office, right? It would be one thing if I was sticking my big nose into something, like, I'm from a different state and demanding to look into something happening in another state, hypothetically, right?
Oh, come on. Like Norfolk County. Like you stuck your nose in there for no reason, other than you hated Michael Morrissey. You got justice for Sandra. But at what cost, Rachel?
But no. There is no one that could speak more to what the policies were of the Suffolk D.S. office than me because I ran for the office, and I had implemented many of the policies, so honestly, it's about truth, right? Like, I don't care what the outcome is, but don't say you didn't have files or, like, imply that somehow we were ripping up documents or taking them with us. That, to me, I won't make a comment about that as the U.S. Attorney, but I want to make sure the story is accurate. We also spoke at length with Rollins on multiple dates about when she first became aware, 1, that the Globe was looking into Hayden's handling of the investigation of the former transit officer, the officer involved in the allegedly unconstitutional stop that was a focus of the August 6 article, and 2, the possible quid pro quo fact pattern involving Hayden and his first assistant DA that was detailed in the August 6 article. We initially asked Rollins on December 6 if she could provide an overview of the steps that led to the MAR USAO's recusal from a potential Hayden investigation, noting that it appeared that the issue first arose after the Globe published some articles in early August. At that time, the OIG had obtained the call detail records of Rollins's personal cell phone showing the calls, described above, between Rollins and the Globe associate editor and between Rollins and the Globe reporter, but we were not aware at the time of Rollins's text messages with the Globe reporter, or Arroyo. 43 Rollins responded on December 6 by suggesting that she did not know that a Globe article about the transit police misconduct matter was forthcoming. For sure. And so, without, knowing exact dates, so, every morning, I wake up and read the Globe and the Herald and several other articles, but absolutely the Globe and the Herald. When I started seeing something about an incident, a questionable stop by a transit police officer, I immediately said, I remember that stop. Or being told about that when I was the DA. That's number one. But it was public in either Herald or the Globe, that had been writing about it. I think it was the Globe article. We were unable to ask Rollins additional questions on December 6 about her contacts with the Globe reporter and the Boston Globe because Rollins declined to answer any further question on that topic until she had the opportunity to review her records. In a continuation of that interview on the 15th of December, we began by highlighting Rollins's phone calls with the Globe reporter prior to the August 6 article being published. As noted above in section 2.b.1 and b.2, Rollins stated that she and the Globe reporter discussed a number of matters relating to her tenure as DA. We asked Rollins if she spoke to the Globe reporter about the transit police misconduct matter. At that time, Rollins had not yet provided the OIG with her text messages with the Globe reporter. Rollins replied, I may have, but as I sit here today, I think I learned that we, the Suffolk D.S. office under her tenure, had issued a search warrant in that case, from the Globe, right? So, I didn't have any independent knowledge, and I think I may have remembered, but only from the Globe, being sort of jarred as a result of, or, reminded from reading that about, I had a vague recollection of some interaction, with some officer that was troubling, that maybe, my first assistant as DA had mentioned something about AT investigation. But I think when I spoke to the Globe reporter, it was more about, well, if according to the Globe, we had a search warrant issued, did we present anything to the grand jury? He had more information than I did, but I said these are the type of questions you should be asking, if you're asking for documents. That's how you get the information you need. I didn't have the information, but I was able to explain to him. I don't think the Globe reporter is a lawyer, hey, there is, when you go before the grand jury, you have to get a slot of time. You don't just walk in. 43 On the 15th of December, 2022, Rollins produced relevant text messages on her personal cell phone to the OIG with respect to the Herald reporter only. Rollins produced other relevant text and encrypted messages on her personal cell phone, including those with the Globe reporter, Arroyo, and others, to the OIG on January 21st and 23rd, 2023.
She was hiding stuff from
there and say, I have 3 witnesses.
She was hiding stuff from the OIG. Imagine what they were hiding from Hank. Oh my God, that office was a mess. Leah Foley is probably still cleaning it up. Wow. Kudos, Leah Foley. Kudos.
I'm going in. You have to request the time. Maybe if you ask, did Hayden's administration request any grand jury time? If he did, then he is telling the truth. If he didn't, maybe he isn't. I don't know. The OIG interview of Rollins on the 15th of December was also truncated because of Rollins's and her attorney's schedules. Prior to the continuation of Rollins's interview on the 24th of January, 2023, Rollins reviewed and produced to the OIG her text messages with the Globe reporter. As noted above, these messages showed that Rollins and the Globe reporter had discussed the Transit Police misconduct investigation prior to the August 6 article being published. On the 24th of January, Rollins stated, I speak to the Globe reporter, who is talking to me about, I think, like, historical things about the D.S. office. I did not have a clear memory about the allegedly unconstitutional stop. That happened while I was DA but didn't really percolate up to me, and I think he was giving me information about that. We also asked Rollins on the 24th of January when she first learned that the Globe was looking into the Transit Police misconduct investigation, including whether she brought the Transit Police misconduct matter to the Globe reporter's attention or whether the Globe reporter raised it with her first. Rollins told us that she did not bring the Transit Police misconduct matter to the Globe reporter's attention and that she had a vague recollection of him raising it with her over the phone. Rollins stated, it was brought to my attention by the Globe. And if I inartfully said an article, I meant the Globe reporter, which I associate with the article because he had to do a lot of research before he wrote it. Rollins later added if she said she didn't know about it until the Globe told her, it could be the Globe reporter calling her and asking her. It could be an email or it could be reading an article. Finally, Rollins told us on December the 6th, and reaffirmed on the 15th of December, that she did not learn about the possible quid pro quo involving Hayden until she read the Globe articles. Because a text message she received from Arroyo on August the 2nd, described previously, about her impending call with the Globe reporter the next day stated, in part, that this feels like pay for play and corruption cover-up. As we speak, we asked Rollins on the 24th of January whether this was a reference to the possible quid pro quo involving Hayden before it was reported in the Globe on August the 6th. Rollins told us that she did not remember seeing Arroyo's pay-to-play reference in his text and did not respond to it. She told us that she believed the cover-up noted by Arroyo was a reference to the Transit Police officer's alleged cover-up. She also said, again, that she recalled learning about the quid pro quo when she read the Globe article. To Rollins's explanations for disclosing sensitive, non-public DOJ information to the Herald and for initially denying during her OIG testimony under oath that she had done so during her OIG testimony on the 15th of December, 2022, and the 24th of January, 2023, Rollins told us that she shared non-public department information with the Herald reporter because the Herald reporter had come to her with inaccurate information from another source that DOJ was not looking into the possible quid pro quo involving Hayden. Rollins told us that in sharing the information with the Herald reporter, she was trying to prevent the publication of a news story that she believed would have been detrimental to DOJ. According to Rollins, I felt like making sure that there was not a story, that there was nobody that was ever going to look into this, and this is well reported in the Globe about the alleged quid pro quo and the payment and the affidavit, and these aren't just, like, random questions. These are, like, documents that were filed in court. So, it seemed pretty potentially egregious, and I didn't want there to be an article out there, just left to say, the Department of Justice isn't looking, has decided not to look into this, and my experience to that date had been that would have been the last discussion because even if it did go to the New England USAO, and she opted, the New England U.S. Attorney, opted not to prosecute, the New England U.S. Attorney would never issue something saying that, or I didn't have control over the New England U.S. Attorney, nor would I ever try to. Rollins further told us, the Department of Justice makes no statement about whether or not they are investigating something, let's say, hypothetically. They investigate it thoroughly. They decide not to prosecute it. They then don't confirm or deny when they get a call. They don't say, oh, we investigated it and we didn't find anything. So, there is just silence.
Oh my God. Oh my God. Oh my God. Oh my God. That shows how rare the statement from Leah Foley was through the local police. Leah Foley had to find a way to, in line with DOJ policy. Rollins just laid out why she did that to Morrissey. That's crazy. And remember, this is Rollins' interview with the OIG. No one probably ever thought this would see the light of day. Like, they only do this and release it if, like, you fight it till the end. Oh, my God. Rollins just laid out right there how you weaponize a federal probe. Oh, my God. Oh, it's so scary.
But when we investigate things like color of law, he Department of Justice makes no statement about whether or not they are investigating something, let's say, hypothetically. They investigate it thoroughly. They decide not to prosecute it. They then don't confirm or deny when they get a call. They don't say, oh, we investigated it and we didn't find anything. So, there is just silence. But, when we investigate things like color of law violations and determine not to go forward, I think it's important that we say to the community, we did look into this. That was where I was coming from when this was happening. Although she acknowledged that she was referring, above, to sharing information with the community months down the line, after an investigation was done she said that she had these thoughts in mind when she spoke with the Herald reporter. With respect to why she sent the Herald reporter photos of the recusal memorandum itself, Rollins told us on the 15th of December that she believed the Herald reporter had two competing sources, someone telling him that the department was not investigating the possible quid pro quo and her telling him that that information was not true, and she sent him documentation of the recusal to prove to the Herald reporter that there was going to be at least an inquiry. OIG attorney, you were breaking the tie between two sources by giving him documentation? Ms. Rollins, that is a better way to characterize it. Whether right or wrong, that's what I was thinking when it happened, and my intent was truly that we would have looked, we being the Department of Justice, I think terrible in an article that was going to come out, and at least here, the public knows we are looking into it. The public does not know what we are going to find, but it is not going to be an article that says, DOJ sources determined no investigation, which is what I believed, when
She was misleading them. Oh, wow. Wow.
I spoke to, the Herald reporter, was going to happen. She further stated that in correcting the information the Herald reporter said he had from another source, what I was hopeful for was that there would be a story that said, at least the Department of Justice is potentially looking into the allegations raised by the Globe. As described previously, despite the office-wide recusal on what the recusal memorandum referred to as the investigation and possible prosecution of Hayden and his first assistant DA, the MAUSAO did not have an investigation open at the time, and the Public Corruption Unit was not taking steps towards opening any such investigation. Rollins told us on the 15th of December that when she made her disclosures to the Herald reporter, she did not know whether the MAUSAO Public Corruption Unit was looking into this or not, but she said that she knew that she had initiated a potential DOJ inquiry by reaching out to the EAR's general counsel right after the Globe story broke. We asked Rollins on the 15th of December and the 24th of January whether, when she made her disclosures to the Herald reporter, she considered department policy that protects the confidentiality of non-public, sensitive information. Although she agreed that the fact that DOJ was inquiring might not have been public, she said that she did not think about that fact when she made her disclosures, and she did not believe at the time that she was violating department policy. She further stated that the MAUSAO press office...
Wait, that's exactly how, that's what happened with Morrissey in the leak about the Reed case. You didn't know that was a violation of policy? Yeah, right.
Is in, near constant communication and giving documents to the press all the time on background and etc. So, she didn't see it as...
What? The press office is in constant communication and giving documents to the press all the time on background? Oh. I gotta ask for comment on that. I had no idea. That's exceptional. Give me some documents on background.
The problem. However, Rollins also told us, I was sure it was something that I didn't want to talk about publicly, right? So, I think that clearly means that I knew that there was likely something not, positive about me doing this. Further, as noted previously, part of her explanation for why she made her disclosures to the Herald reporter was that she knew the department would not make a statement about whether they were investigating Hayden or, later, if they opted not to prosecute, that they had investigated him. During her testimony on the 15th of December and the 24th of January, Rollins also asserted that the information she shared with the Herald...
You see what it's showing? Rollins knew, like, if you want to smear someone and you just leak that it might be happening, the DOJ will never deny it, and that's how you can ruin someone forever. Oh, this is the most dirty form of dirty politics.
Reporter was not, in her view. She further stated that the MAR USA... During her testimony on the 15th of December and the 24th of January, she further stated that the MAR USAO press office is in, near constant communication and giving documents to the press all the time on background and etc., so she didn't see it as a problem. However, Rollins also told us, I was sure it was something that I didn't want to talk about publicly, right? So, I think that clearly means that I knew that there was likely something not, positive about me doing this. Further, as noted previously, part of her explanation for why she made her disclosures to the Herald reporter was that she knew the department would not make a statement about whether they were investigating Hayden or, later, if they opted not to prosecute, that they had investigated him. During her testimony on the 15th of December and the 24th of January, Rollins also asserted that the information she shared with the Herald reporter was not, in her view, particularly extraordinary or sensitive. Ms. Rollins, but, I also do want to say that when an article comes out, claiming that you engaged in a quid pro quo, I don't think it's extraordinary to find out that there is an investigation happening, right? That is how all of our investigations occur, through...
Wait. Are you fucking kidding me? This is exactly where the game plan came from with Yannetti or whoever. Just write an article. Get to, no, the Globe won't do it, Gretchen won't do it, but Turtle Boy will. That's enough to start the pretextual probe. Oh my God, this got way out of hand. The DOJ, listen. The DOJ is responsible for what happened last week. Not this new DOJ, but I don't know. Somebody's got to intervene. We fucked up the state court justice system, and it was all because of Rachael Rollins being a petty little... I'm going to not use that. I almost used the B word. I'm not going to do it. But literally, this is the most petty shit I've ever seen. And it fucked up. It spiraled the fuck out of control, and you compromised a fucking murder case of a police officer. And what do you care, right, Rachel? Just a dead cop. That makes me so upset.
The Attorney General, or the U.S. Attorney's Office. Like you just said, public integrity is reading the Globe, and they open investigations all the time.
Wait a minute.
OIG attorney, but it is kind of extraordinary.
That is how all the DOJ's investigations occur. All I have to do is write an article? No wonder why it's so powerful. Not that I've ever caused anything like that to ever be open.
Oh, Ms. Rollins, but, I also do want to say that when an article comes out, claiming that you engaged in a quid pro quo, I don't think it's extraordinary to find out that there is an investigation happening, right? That is how all of our investigations occur, through the Attorney General, or the U.S. Attorney's Office. Like you just said, public integrity is reading the Globe, and they open investigations all the time. OIG attorney, but it is kind of extraordinary to have that investigation confirmed by a federal law enforcement official in the newspaper, isn't it? Ms. Rollins, I don't necessarily believe that. It happens all the time. Literally, all the time. So, I don't think it's usual, but I don't think it's extraordinary. Rollins also stated that because the recusal memorandum did not have a classification or law enforcement sensitive marking or some other notation protecting it from disclosure, she thought sharing it with the Herald reporter was not a significant issue at the time. However, Rollins stopped short of stating that the absence of markings excused her disclosure of non-public case information. OIG attorney, are you saying that your case documents anything in the U.S. Attorney's Office right now relating to a covert case, that if it doesn't have a marking, then it's free game to make public? Ms. Rollins, I'm not saying that. What I'm saying is this document itself is not top secret, there is no demarcation whatsoever. This is an email that I received about me that is recusing me and saying there is going to be an inquiry into something. That is what I'm saying. I'm not saying I would do it again. I'm simply saying this is not There is no demarcation on this that turning it over in any way, shape, or form is, on its face, precluded. That's what I'm saying. And that if it is sensitive or law enforcement sensitive, or any, privileged, confidential, top secret, I have to be in a secure location.
Hold on, she didn't say the word secure location. They changed that. She definitely said a skiff, a secure compartmentalized information facility, a skiff. And they don't want the word skiff out there clearly, but skiff, it's a specific term, skiff. And it's like a metal box. It's like a shipping container. It's like a Faraday cage that has communication. That's a very rudimentary way of explaining a skiff. But she was like, "What do you mean? I didn't know I couldn't just turn over documents." Like, oh, she's bad. This is bad. Come on, this is exactly what they did to Morrissey with the Reed case. It's literally this. She's just basically explaining how you would have done it to Morrissey, and they did it to him. You know what? And what's crazy is I've now put it all together. Rollins was on her way out in November of 2022. She fucking knew the DOJ OIG was about to interview her in December. She was like, "I'm fucked. What's the last thing I want to do on my way out? Well, I fucking hate Michael Morrissey. Fuck him."
When I read it, there is nothing indicating that whatsoever. I'm not saying it was right. Please do not hear me as fighting for that. I'm simply saying, this is not a defiant act of marked as something and who cares, I'm doing this. This is a document about me that I turned over, and foolishly or not, to defend that we were actually doing something, when I was told and lied to or not, that there were sources saying we were doing nothing.
That's not why you did it, Rachel.
And that is what DOJ does, is we don't comment on investigations, confirm or deny, and if we don't do anything, we are just silent, and we never do anything, or we pop up 3 years later and say, we were looking into this the whole time, as we are being disparaged and accused of doing nothing by certain communities. That is what this was about for me. When we asked Rollins on the 15th of December why she would disclose information about a potential investigation from which she had been recused, Rollins stated that she did not think the information she shared was law enforcement sensitive or confidential or privileged, and that she did not believe that being recused meant that she could not acknowledge that she was recused. When we asked her whether she advised the New England U.S. Attorney of her disclosures, Rollins told us, "I don't think I did." Rollins said that she did not think she needed to alert the New England USAO because the Herald article didn't break the case. She said, "I think the Globe broke the case about the quid pro quo that I had no idea about, until after I saw it published in the Globe article."
You literally planted the Globe article so that you could launch a federal probe. It's all so recursive and murky, but it's all here, black and white. It's hidden. You really got to take the time to and understand what you're reading. But this is great. Somebody make me a congressman. I'm ready. Congressman Towel.
When we asked her whether she considered at the time that her disclosures could impede any future investigation by the New England USAO, Rollins said, "I wasn't thinking about that, and maybe I should have been." Rollins said that she thought she was helping by making clear that, in fact, somebody was looking into the possible quid pro quo. Given that Hayden was a candidate in the upcoming election for Suffolk DA at the time of her disclosures, we asked Rollins whether she considered that fact when she made her disclosures to the Herald reporter. As discussed later in our analysis, on the 25th of May and the 8th of August, 2022, Rollins received DOJ-wide reminders of the department's policy requiring that DOJ officials be mindful of election year sensitivities when making public statements or taking other actions near the time of a primary or general election.
This is exactly what they were so worried about. She literally engaged in election interference. She should have been prosecuted. She could still be prosecuted. I'm of the opinion she should be prosecuted.
And to consult with the Public Integrity Section of the Criminal Division, PIN, when such issues exist. 44 Rollins told us during her 15th of December testimony that because her conversation and text messages with the Herald reporter on September the 9th took place after the primary election, in her mind the election was over because Hayden was running uncontested in the general election. She said she did not consider at the time whether public disclosure of a DOJ investigation could place pressure on Hayden to withdraw his candidacy.
That's, of course. Oh my God, it was election interference during the primary, the general. This is some crazy shit. She skated. How'd you get away with this? How are you so connected that you can just do this and then move on?
4544 The PIN chief told the OIG that Rollins did not consult with PIN regarding the information she provided to the Herald during August and September 2022. As discussed in our analysis, department policy also prohibits federal prosecutors from timing any action, including investigative steps, criminal charges, or statements, for the purpose of affecting any election, or for the purpose of giving advantage or disadvantage to any candidate or political party. Justice Manual 9-85.500. 45 After the primary election and before the general election, Rollins continued to provide Globe reporters with information about Hayden. On the 14th of September, 2000...
Hold on, and by the way, just so folks understand, the DOJ OIG technically works like for itself, it's independent, but it really answers to the Oversight Committee, the Government Oversight and Accountability Committee. Put me on that committee. Then I can call the OIG before Congress with the consent of my fellow Congress people, and then I can be like, okay, I read your whole report. I want to interview you about it, and I get to just sit there and ask them questions. You don't understand. We need to put Towel in public office. I'm ready for this, ladies and gentlemen.
And 22, Rollins sent a text message that was off the record, emphasis in original, to the Globe reporter that stated, in part, if Kevin Hayden is allowed to just say, we never stopped looking into any of the cases the Rollins opened and you guys take his word as gospel, where are the indictments in these two cases? What is the status? Can't have it both ways. On, can D. When we asked Rollins about her first call with the Herald reporter on September 2, an off-the-record conversation she requested and which took place before the primary election, Rollins testified on the 15th of December that she did not recall whether they spoke about a potential DOJ investigation on that call and that she wanted to review what else may have been in the news at that time to figure out what they may have discussed. She said that they could have talked about a university of common interest between them, but that they likely also talked about something work-related, and it very well may have been about this. During subsequent OIG testimony on the 24th of January, 2023, Rollins stated that she did not believe she told the Herald reporter about a potential DOJ investigation of Hayden before the primary election. OIG attorney, no, our question to you is whether, before you had that conversation with the Herald reporter, about him telling you, I have a source that says you're not investigating, our question to you was that conversation with the Herald reporter, preceded by an earlier conversation with the Herald reporter, where you told him that you were, that DOJ was either investigating or may investigate. Ms. Rollins, I don't believe that is the sequence of events, right? I don't know what we talked about on this day, September the 2nd, and I can tell you, my recollection is the reason I sent him something, and it was after the election, right, as because I was told by him, whether I was lied to or not, I sent it, because I wanted him to know that DOJ is at least inquiring into this thing. And for me, none of that happened before the election. I would not want to feel as if I was turning something over or saying there is an investigation. People can speculate or not. The law professor can send his letter, but I was not speaking or telling the press or giving them a document about an investigation before the election, which was the 6th of September, I believe. The 21st of September, 2022, Rollins sent another off-the-record, emphasis in original, text message to the Globe reporter informing him that the head of Conviction Integrity Unit at Suffolk just tendered her resignation today and stating that Rollins had created that unit. On the 27th of September, 2022, Rollins spoke on the phone for almost 36...
So people from the DA's office who were holdovers from Rollins but didn't like Hayden would then leak stuff about Hayden's office to Rollins, who would leak it to the Globe. Oh, she was a power player.
Minutes with a different Globe reporter. Later the same day, Rollins texted the reporter links to the 11th of September article in the Herald about the potential DOJ investigation of Hayden and an article in the Globe the next day reporting the same information. Rollins told us that she did not recall her phone conversation with this reporter or why she sent the reporter links to these articles. On the 6th of October, 2022, the Globe published a story authored by this reporter that questioned whether Hayden would keep his campaign promises. See a series of mixed signals after...
All right, who wrote this article? Come on, let's find it out together. Who was Rachel Rollins talking to? Spin the wheel. Pick your Boston reporter. It was Ivy Scott. Ivy Scott. There you go. Spin the wheel. Pick your Boston reporter.
Rollins, progressives question News commitment. The Boston Globe, the 6th of October, 2022, bostonglobe.com/2022/10/06/metro/series mixed signals after Rollins progressives question News commitment / accessed the 6th of April, 2023. Based on her text messages with Arroyo, we asked Rollins whether her disclosures to the Herald reporter that DOJ was looking into the possible quid pro quo was retribution for the wrongs she believed Hayden had committed before the primary election. Rollins testified on the 24th of January that political payback was not her intention and stated further. I'm saying is I believed when I read things that I had nothing to do with a quid pro quo, I did what I thought was right. I notified the as a general counsel immediately. I then had conversations with him again when I got the law professor's letter, and the reason, right or wrong, that I gave the recusal memorandum to the Herald reporter, I'm telling you, the Herald reporter told me that he had a source that said we weren't doing anything, and I didn't think that was positive for DOJ.
That's not what happened.
Rollins also testified on the 15th of December, all I wanted was the truth to come out. I don't know or care what the outcome of an inquiry is going to be about Kevin Hayden. Finally, we asked
But Rollins just said that type of stuff, it doesn't matter if the inquiry goes anywhere. Just the fact that the rumors about it are enough. That's the whole point.
When the OIG first questioned her under oath on these topics on the 6th of December, 2022, she denied being the Herald reporter source for his the 11th of September article, stated that she did not know or have any suspicion about who the source was, and declined to answer whether she gave the Herald reporter the recusal memorandum. 46 specifically, on December the 6th, Rollins testified as follows. OIG attorney, yeah. Any communications with the Herald reporter about this article before it was published? MS Rollins, I don't believe so. *****OIG attorney, and, it's after the notice of recusal and says, a federal law enforcement source suggests this came up because of the Globe stories. Were you that federal law enforcement source that the Herald reporter cites? MS Rollins, no. And for me, there are leaks that have happened in our office many times that I have spoken to regarding the MAR USAO executive officer regarding this investigation, that we got a call, for example, from the Associated Press, that said federal sources, law enforcement sources, but I have definitely talked to the Herald 46 on the 30th of November, 1 week prior to her continued interview on December the 6th. The OIG informed Rollins's counsel that the OIG intended to question Rollins about the 11th of September article in the Herald on December the 6th, and the OIG provided Rollins's counsel with a copy of the 11th of September article and access to the recusal memorandum. We also stated at the start of the continued interview that we planned to cover these topics.
She still said she needed time.
Reporter, about many matters as DA, and possibly even about this, as well. OIG attorney, about the recusal. MS Rollins, about, after an article. OIG attorney, okay. MS Rollins, might have appeared, I could have potentially, or the Herald reporter might call or text me about certain things. There are times where I am non-responsive at all. OIG attorney, yeah. MS Rollins, and other times I might say, no, I have absolutely no comment. OIG attorney, do you know or have any suspicion about who the source was for this article? MS Rollins, I don't have any. After these questions and answers, we described the call detail records we obtained and asked Rollins about the voicemail the Herald reporter left for her on September the 1st and the phone conversations they had on September the 2nd for approximately 17 minutes and again on September the 9th for approximately 15 minutes. In response, Rollins testified that she did not recall what the Herald reporter said in his voicemail or what they discussed over the phone. She then provided the following testimony. OIG attorney, can you answer for us, did you tell the Herald reporter that DOJ was moving towards a review or investigation of the Hayden allegations? MS Rollins, I did not do anything that would result in me feeling like I violated this at all. Now, whether the Herald reporter had, I will go back and look through my material, but I would want to make sure I was aware of what was happening around this time before I speak any more about the 17 and 15-minute calls. I want to know what day a family event occurred. I don't know whether that could account for some of these calls, and I also want to see what speaking events that I had, so I can better tell you whether I spoke about generally this, because I don't think this precludes me from talking. I apologize. OIG attorney, the recusal memo. MS Rollins, this was the recusal memo that I was given. Sorry. The 1st of September. MS Rollins, I was going to say, so, there are often times where, for example, if I am recused from something, that doesn't mean I can never talk about the D.S office again, right? Or that I can never talk about the transit police again. Or that I can't say I actually have a specific recollection of this incident in and of itself, because... OIG attorney, that wasn't my question. My question was whether you can tell us whether you did or did not talk to the Herald reporter about DOJ moving towards an investigation or review of the Hayden allegations. Not, that's separate from what I heard you talk about before, about process, that the can't investigate itself. What I'm asking is specific about DOJ and DOJ moving towards an investigation or review of the Hayden allegations. Did or did you not discuss that with the Herald reporter? Ms. Rollins, not, I don't believe that I did, and certainly not from me, and I want to make sure I'm looking at one or two other things before I answer any questions to you, but it would be, let's take it away from this. I get calls all the time from the media, saying, we are being told the following. Do you have any comment on that? Or if somebody is telling us this, is that something that DOJ would do, or is that consistent with what you have seen in the 9 months that you have been the U.S. attorney, right? I don't see that. I want to look at what was happening in this time before I answer anything else about the Herald reporter, but for me, well, let me say that, before I answer anything else. A few moments later, when we asked Rollins whether she provided the Herald reporter with a copy of the recusal memorandum, Rollins asked for a break from the interview and, after the break, declined to answer further questions about the Herald leak and related topics until she had the opportunity to review her records. As discussed previously, when the interview resumed on the 15th of December, 2022, Rollins acknowledged being the federal law enforcement source for the Herald article. She further testified that she had denied being the Herald source on December the 6th, and had declined to answer the question whether she gave the Herald reporter the recusal memorandum, because she was not fully prepared to answer our questions on December the 6th, and she had difficulty recalling her conversations with the Herald reporter.
Someone up the chain told her she was going to prison because she basically admitted to perjury.
The OIG had advised Rollins's attorney on the 30th of November that we planned to ask Rollins questions on December the 6th about the recusal memorandum that had been shared with the Herald, and the OIG provided Rollins's counsel with a copy of the 11th of September Herald article and access to the recusal memorandum. We also stated at the beginning of her December the 6th interview that we planned to ask Rollins questions about Ma USAO's recusal from any investigation into Hayden and the recusal memorandum shared with the Herald. Rollins told us on the 15th of December that she was nevertheless surprised when, on December the 6th, we asked her questions about the Herald article and her communications with the Herald reporter. The first time I heard about the Herald reporter, or these articles, was when you mentioned it in the middle of, a several-hour interview. So, rather than stopping you then, which I should have, and said, what? I was trying to think throughout because this was sort of out of left field for me. That is not an excuse. I'm just saying I was trying to think of all of my interactions with the Herald reporter, and I didn't know that was something we were going to be talking about during the interview. So, moving forward, if that happens again, I will stop and not say anything, and then, I apologize for not doing that. OIG analysis based upon the facts described above, the OIG concluded that U.S. Attorney Rachael Rollins used her position as U.S. Attorney in an effort to influence the outcome of a partisan political election, namely the 6th of September, 2022 Democratic primary election that would select her likely successor as Suffolk DA. We further found that Rollins took an active part in Ricardo Arroyo's primary campaign for the Suffolk DA position in an effort to help Arroyo defeat interim DA Kevin Hayden. We concluded that, despite her assertion otherwise, Rollins was very much trying to put her finger on the scale in the race for DA, a race that certain local media reports suggested was a referendum on the policies and programs Rollins instituted during her own tenure as Suffolk D. with Arroyo being seen as someone who was more supportive of, and likely to continue, her policies than Hayden. Even Arroyo, moments after he lost the primary election to Hayden, sent a message to Rollins stating that her legacy work deserved better. Additionally, we determined that days after Hayden prevailed in the September the 6th primary election, Rollins sought to damage Hayden's reputation by leaking to the Herald reporter non-public and sensitive DOJ information that suggested the possibility of a federal criminal investigation into Hayden, a matter from which Rollins was recused. Finally, we concluded that Rollins lacked candor during her OIG interview when discussing her communications with the Globe reporter and with the Herald reporter, and falsely testified under oath when she initially denied that she was the federal law enforcement source who provided non-public, sensitive DOJ information to the Herald reporter about a possible Hayden criminal investigation. Rollins only admitted to being the source during subsequent testimony after Rollins produced, in response to the OIG's requests, relevant text messages, which definitively showed that Rollins had indeed been a source for the reporter. Documentary evidence demonstrated extensive campaign-related communications between Rollins and Arroyo in the weeks leading up to the primary election on September 6. The evidence shows that Rollins worked to advance Arroyo's candidacy by giving him advice and direction on actions he should take and statements he should make to promote himself or damage Hayden. For example, before the Globe published a story on the 23rd of August reporting that Arroyo had twice been accused of serious crimes in 2005 and 2007, Rollins assisted Arroyo in his attempts to address questions from the Globe, told Arroyo to have the Globe reporter call her, and then, shortly after the story published, substantively edited Arroyo's draft public statement about the allegations. However, the evidence reflected that Rollins did far more than provide campaign advice and direction to Arroyo. In the weeks before the primary election, Rollins secretly fed negative information about Hayden to the Globe, some of which the Globe featured in the 6th of August, 2022 article critical of Hayden's handling of a MBTA Transit Police misconduct case that began under Rollins's tenure as DA and the understaffing of a special unit that was responsible for handling police misconduct cases. Among other things, Rollins also encouraged the Globe reporter to keep digging for negative information about Hayden's management of the Suffolk D.S. office and suggested where he could look to potentially find it. Further, the evidence shows that before and after the Globe articles about Hayden in early August, Rollins and Arroyo updated each other about separate conversations they were having with the Globe. The evidence demonstrated that by the middle of August, Rollins brought her efforts to advance Arroyo's candidacy to the USAO, when she used her position as U.S. Attorney, and information available to her as U.S. Attorney, in an ultimately unsuccessful effort to create the impression publicly, before the primary election, that DOJ was or would be investigating Hayden for public corruption. The evidence shows that, the same day Rollins received from the law professor his 16th of August letter requesting that the USAO investigate the information in the August 6th Globe article, suggesting that Hayden and his first assistant DA may have closed down the transit police misconduct case in exchange for $225 in campaign donations, Rollins went to IRSA to obtain an office-wide recusal from the matter and then pushed her first assistant U.S. attorney to send the law professor an acknowledgement letter that would have disclosed her recusal from the matter and created the impression that DOJ was investigating Hayden. We believe her effort to convince...
that's it, right? She was that subversive. And I think the only reason Levy went forward with the Morrissey probe is because I think Levy probably figured out wicked early into this that it was really Birchmore. And he just strung Karen along. Why tell her that it can't go to trial in the fall of 2023? That might have been personal, because it did go to trial. But that is the whole playbook right there. And the DOJ OIG's in their analysis now, which means this is going to get even better. Thanks for sticking with me. This is more an academic exercise for me. I would have been doing this tonight anyway, because I'm so thrilled I'm getting to read this. So thanks for listening to it with me, this DOJ OIG report. Almost midnight here. It's about to turn over to 6:24, our first time we've ever streamed across the midnight barrier. So if you're just tuning in, my name's Grant Smith Ellis. Late night towel stream, more an archive and an academic exercise for me to listen to this DOJ OIG report into Rachael Rollins. But I got another coffee. I'm still awake. I'll get some sleep soon. We'll do a later start on the stream tomorrow. And then I don't know how far we're going to get into this. I'll see how I'm feeling. But I'm going to then review this tomorrow. I'm not going to do the whole thing again, but I'm going to tell people what I learned. Well, here it is. If you're still listening, celebrate the moment, ladies and gentlemen. You have made it, at least in the Eastern time zone, in 10, should be just over 5 seconds now, about 6 seconds. You have made it to Tuesday, June 24th. Congratulations. It is now midnight. My name's Grant Smith Ellis. Let's continue with this fascinating DOJ OIG report.
Her first assistant to send such a letter is likely what Rollins was referring to when she told the Globe reporter on the 19th of August that the USAO may be issuing a brief statement in the coming... We believe her effort to convince her first assistant to send such a letter is likely what Rollins was referring to when she told the Globe reporter on the 19th of August that the USAO may be issuing a brief statement in the coming week about such an investigation. It was also likely at least one of the things she was referring to when she told Arroyo on the 22nd of August that she was working on something. Indeed, among her suggested edits to Arroyo's draft statement in response to the Globe's 23rd of August story about the serious criminal allegations against Arroyo, Rollins told Arroyo to assert that Hayden was likely under investigation for likely criminal behavior. After the first assistant U.S. attorney backburner, Ed, her idea for an acknowledgement letter, Rollins took a more direct route toward publicizing a potential DOJ investigation of Hayden by disclosing non-public DOJ information directly to the Herald reporter. Rollins's first disclosure of information to the Herald occurred on the 2nd of September, 2022, 4 days before...
The first assistant was Levy. It was a battle between Levy and Rollins. Levy did the right thing on this one, but I don't know why he did the wrong thing, at least as to the John O'Keefe probe. Like, I don't know. It can't just be Birchmore. It has to be Levy liking Karen or something.
The primary election and nearly contemporaneously with her receipt of the recusal memorandum. Although Rollins has testified that she did not recall why she texted the Herald reporter on the 31st of August, the same day that several public... Although Rollins has testified that she did not recall why she texted the Herald reporter on the 31st of August, although Rollins's DOJ investigation of Hayden by disclosing non-public DOJ information directly to the Herald reporter. Rollins's first disclosure of information to the Herald occurred on the 2nd of September, 2022, 4 days before the primary election and nearly contemporaneously with her receipt of the recusal memorandum. Although Rollins has testified that she did not recall why she texted the Herald...
She needed that recusal memorandum before the primary. And she got it on September 2nd. She got it right before the primary, but it wasn't enough to save Arroyo. So what happened was, the series of events was, Globe runs the MBTA story in like August. But then right after, Globe runs the story about Arroyo. So I think Rollins, I'm now wondering if Rollins got tipped off that these SA allegations were coming against Arroyo. So Rollins got ahead of that by getting the article in the Globe about the MBTA stuff. Now what's weird is that MBTA shit with the transit police went down, like that stop happened while Rollins was DA. But it seems like, and what's weird is that Rollins was more friendly with the MBTA than Hayden. The MBTA, I think, was the only police officer union that endorsed her. So I'm kind of wondering, like, was them trying to blame Hayden for it, or what was this whole effort to blame Hayden for it? Did it have two purposes? Well, was the primary purpose to get ahead of the Globe, because you got to think of the timeline here. It's like August of 2022. Rollins knows that there's an October surprise coming about Arroyo, so she tries to create an October surprise about Hayden. She begins by just putting the article in the Globe about Hayden, but that doesn't do enough to save Arroyo, because Arroyo gets hit with the Globe article. So then in response, Rollins has to move quick because she only has until September, whatever it is, 6th for the primary. So she has to get a recusal memo between when like the Arroyo articles like drop, which was it's even more complicated because the Arroyo's articles drop like August 27, 28, 29th. She has to get a recusal memo because Levy won't let her respond to Medved's email, because remember, if Levy had just let her respond to Medved's email, he would have leaked it to the Herald or the Globe right away, and that they wouldn't have needed to wait for the recusal memo. But Levy wouldn't do it even after Rollins pressured her. So Rollins had to then do the next best option. It was her nuclear option. Make sure the recusal memo comes in before September 6th. I can't believe, because it was just that one attorney who works on the recusals, and she just got him to think it was like routine, like, okay, just get it done in the next few weeks. And I think she used an intermediary. So it got done, and it got processed, and it came in like with 4 days to spare. She had to have timed it, and she leaked it because she had no other option, because Levy wouldn't let her respond to Medved's email, and she had no other option. She was cornered because Arroyo had been hit with that SA article, and so her only option was to go to the Herald. But the Herald must have realized that this was election interference, and they must have realized it was that must have been a great discussion in the Herald's editorial room, because they had to make a real-time call that it was a nothing burger. It's true, it didn't go anywhere. There was no probe of Hayden. This was Rollins making something up out of thin air, but it was coming from the U.S. attorney, so it had a lot of gravitas. And it played out in exactly that format, and it didn't work. And then you can see even afterwards, like the people who stopped Rollins, Levy, Chao, and then that one other guy, Bill Abley. It makes so much more sense now, because that's why Medved, the professor who was working with Rollins on this strange scheme where she was going to like go to his book signing event. He's like a hardcore progressive apparently, so he supports her unconditionally. That's why when it all went to shit, he was like, all right, fine, Chao's going to pay for it, and he signed on to the ethics complaint. That's my theory of all this. This is a story and a half. The Globe's never going to tell it. Herald's never going to tell it. ProPublica should tell it. Or the AP, somebody should tell this story. This is a fucking story.
Reporter on the 31st of August, the same day that several public officials withdrew their endorsements of Arroyo, and, again, on September the 1st requesting a discussion off the record or what they talked about when... Although Rollins's DOJ investigation of Hayden by disclosing non-public DOJ information directly to the Herald reporter. Rollins's first disclosure of information to the Herald occurred on the 2nd of September, 2022, 4 days before the primary election and nearly contemporaneously with her receipt of the recusal memorandum. Although Rollins testified that she did not recall why she texted the Herald reporter on the 31st of August, the same day that several public officials withdrew their endorsements of Arroyo, and, again, on September the 1st requesting a discussion off the record or what they talked about when they ultimately spoke on September the 2nd, the evidence demonstrated that she conveyed to the Herald reporter that DOJ was, or potentially would be, investigating Hayden concerning the possible quid pro quo reported in The Globe, and that the law professor had contacted her office about the matter. We drew this conclusion for several reasons. Within 40 minutes of Rollins's phone conversation with the Herald reporter on the evening of September the 2nd, the Herald reporter contacted the law professor, the two of whom, according to the law professor, had never had any prior contact, and told the law professor that he, the Herald reporter, was aware that the law professor reached out to DOJ about the Hayden /Transit issue and that he had heard that there might be some movement on that. Additionally, the next day, September the 3rd, the Herald reached out to USAO and the Suffolk D.S. office for comment on the existence of an investigation. Advising the D.S. office that the Herald had information that there will be an investigation into the decision not to prosecute the transit police officers, and advising the USAO executive officer that it had a law enforcement source who said that DOJ was investigating Hayden. Rollins admitted to the ORG that she was the federal law enforcement source for the Herald article on the 11th of September, which discussed a possible DOJ investigation into Hayden. Both the Suffolk D.S. office and USAO, in their pre-primary election communications with the Herald, encouraged the Herald to consider the motives of a source who was leaking information just days before an election, and the Herald ultimately did not run a story prior to the primary election about a possible DOJ investigation into Hayden.
Yep, so the Herald, when the USAO's like leadership, even though Rollins is telling you something, when the USAO itself is contradicting the boss, and the Suffolk DA saying, like, think about the motives here, that's why the Herald held it. Beautiful. Great job by the Herald. I mean, they still fucked around and found out a little bit, but good job there. They held it till after the primary. That's fucking ethical journalism. Talk all the shit you want about the fucking Boston Herald and some of the shit they run. Look at that. That's ethical journalism. Give them you can't give them a Pulitzer for not doing something, and they ended up running it anyway and getting a little baited for the clicks. But the Herald holding that story for 8 days or 6 days in September of 2022, I mean, they deserve more credit for that. No one's ever going to applaud them for that except for me right now, but that's real journalism.
On election night, following Hayden's defeat of Arroyo, Rollins sent an encrypted. Both the Suffolk D.S. office and USAO, in their pre-primary election communications with the Herald, encouraged the Herald to consider the motives of a source who was leaking information just days before an election, and the Herald ultimately did not run a story prior to the primary election about a possible DOJ investigation into Hayden. On election night, following Hayden's defeat of Arroyo, Rollins sent an encrypted message to Arroyo that ominously concluded, "They are not above the law. He will regret the day he did this to you. Watch." 3 days later, on September the 9th, Rollins was contacted by the Herald reporter and later that same day texted the Herald reporter photos of the September the 1st recusal memorandum itself as evidence that DOJ was indeed looking into this. She also disclosed to the Herald reporter that she had reached out to DOJ immediately after reading the August the 6th Globe article. that a letter from the law professor demanding an investigation into Hayden and his first assistant DA initiated the moves toward a review, and that DOJ was fearful of weighing in and impacting the election. Rollins told us that she took these actions and made these statements because the Herald reporter had said to her that he had a source stating that DOJ had declined to look into this matter, and she believed it was important for the department to correct inaccurate information before it was published. Although Rollins tried during her OIG interviews to minimize the significance of her active support for Arroyo's campaign and her disclosures to the Globe and the Herald of derogatory information about Arroyo's opponent in close proximity to the election, including non-public information about a potential DOJ investigation of him, her actions were extraordinary for any DOJ employee to have taken, let alone a U.S. attorney. Indeed, as we describe below, we concluded that Rollins's conduct not only violated numerous DOJ policies but also was fundamentally inconsistent with the standards of ethical conduct for employees of the executive branch. Moreover, the evidence clearly shows that Rollins knew at the time of her disclosures that what she was doing was wrong. For example, after texting the Herald reporter the recusal memorandum, Rollins asked the Herald reporter to say in the story that the source preferred to stay anonymous for fear of discipline or something like that. Additionally, Rollins admitted during her OIG interview that her practice of sending documents to reporters by text message on her personal phone, as opposed to sending the documents from her DOJ email account, was because she wanted to hide the fact that she was doing so. Further, Rollins told us that one of the reasons she shared non-public DOJ information with the Herald reporter was that she knew that the department generally does not make public statements that they are investigating a matter or advise the public afterward that an investigation was conducted, unless public charges are brought. We did not find credible Rollins's explanation that she disclosed non-public information to the Herald to serve the department's and the general community's interests. Rollins secretly provided the information to a reporter, requesting assurance that she would not be identified as the source, without consulting the U.S. Attorney's Office responsible for the matter, and then misled her own staff about the disclosures. It is hard to imagine how the interests of either the department or the public could have been served in this manner. And, in any case, Rollins was recused from the matter and, therefore, not authorized to decide what was good for the department or the public. Indeed, given Rollins's clear conflict of interest and political motivation for her actions, had she told the Herald that it could name her as the source of the information, the department's and MAUSAO's credibility would have been seriously harmed, not advanced. We found instead that Rollins's communications with Arroyo and with reporters overwhelmingly demonstrate that Rollins's actions were motivated by her desire, well documented in her own text and encrypted messages, to help Arroyo defeat Hayden in the primary election and preserve her own legacy as DA, and, when that effort failed, damage Hayden's reputation. Indeed, within minutes of the Herald article first appearing online on the evening of the 11th of September, Rollins sent Arroyo a link to the article, and Arroyo responded that he was, absolutely thrilled that a U.S. attorney would release sensitive, non-public DOJ information and in other ways use her position to harm a candidate in a local election, amounted to a serious violation of public trust. The fact that Rollins did not appear to grasp the seriousness of her actions during her OIG interview and, in particular, asserted that her disclosures to the Herald were not extraordinary or a significant issue were equally concerning and was a view not shared by career prosecutors in the MAUSAO. Moreover, as described below, we concluded that Rollins knowingly and willfully made a false statement of material fact under oath when she testified on December 6 that she was not the federal law enforcement source cited in the Herald article and that she did know who the source was. We further concluded that she lacked candor when she answered questions during her OIG interview about her communications with the Herald reporter before the primary election and when she described how she first learned of the Globe's interest in the transit police misconduct case. In the sections that follow, we analyze Rollins's conduct in the context of applicable government ethics rules, department policy, and law. Based upon the foregoing, we determined that Rollins, 1, used her position as U.S. Attorney, and used non-public DOJ information available to her by virtue of her position as U.S. Attorney, in an effort to influence the outcome of an election, in violation of Sections 2635.702 and 2635.703 of the Standards of Ethical Conduct for Employees of the Executive Branch, as well as department policy and the obligations under the ethics agreement she signed after her nomination as U.S. Attorney. 2. Knowingly and willfully made a false statement of material fact during her OIG interview, in violation of 18 U.S.C. 1001, 3, lacked candor during her OIG interview, in violation of 28 CFR 45.13. And 4, actively participated in a partisan political campaign, in violation of department policy that further restricts the political activity of non-career officials, including U.S. attorneys. Furthermore, we believe that Rollins's actions fell far short of the standards of professionalism, judgment, and impartiality that the department should expect of a U.S. attorney. 1. Rollins used her position as U.S. Attorney, and non-public DOJ information available to her as U.S. Attorney, in an attempt to influence the Suffolk DA election in violation of government ethics standards, department policy, and the terms of her ethics agreement. A government ethics standards violations the standards of ethical conduct for employees of the executive branch. Standards of ethical conduct recognize that public service is a public trust and require that executive branch employees place loyalty to the Constitution, laws, and ethical principles above private gain. C5 CFR 2635.101. Section 2635.702 specifically states that executive branch employees shall not use their public office for their own private gain or for the gain of friends, relatives, or persons with whom they are affiliated in a non-governmental capacity. This prohibition includes, but is not limited to, an employee using her government position in a manner that is intended to induce another person, including a subordinate, to provide a benefit to the employee, her friends, relatives, or persons with whom she is affiliated in a non-governmental capacity. 5 CFR 2635.702, A. Section 2635.703 prohibits employees from allowing the improper use of non-public information to further their own private interest or that of another, whether through advice or recommendation, or by knowing and authorized disclosure. This section defines non-public information.
Hey, Josh Levy, did you hear that? What is it? Section 2635.703 prohibits employees from allowing the improper use of non-public information to further their own private interests or that of another, whether through advice or recommendation or by knowing unauthorized disclosure.
As information that the employee gains by reason of federal employment and that she knows or reasonably should know has not been made available to the general public, including information the employee knows or reasonably should know, h, has not actually been disseminated to the general public and is not authorized to be made available to the public on request. 5 CFR 2635.703, b. These provisions, as with all standards of ethical conduct, are intended to help ensure public confidence in the integrity of the federal government. C5 CFR.
Okay, so now I think I'm starting to see why, if we go over to this series of photos, and we go to, no, not the ethics complaint. Hold on. There is, it's not the Dustin Chao ethics complaint. Hold on. It's this one. So if we go to this series of photos, right? And we go to the last, by the way, this is a research project I'm doing in real time. But if we go to this series of photos, right, which is Exhibit O from, I think it's Lindsay Gattani's cell phone. So this is a message from Aidan Kearney to, I think it's Lindsay. And this is crazy because, and this is why I think so many people, including maybe even the feds, wanted, like the old feds, wanted to smear Lindsay. It's because Aidan, on 11/28/2023, said to Lindsay, I found out some information on the way home about the feds that I will not be making public. Questions been asked. And then I think, so that was from Aidan to Lindsay. And Lindsay says, really? Good or bad? And then Aidan says, yes. They requested a conference call. So they, the feds, requested a conference call over the weekend. Josh Levy himself asking, and remember, this has to be coming from Karen, asking questions like, is there any chance the trial date could be delayed? Only one reason to ask that. Asking for all communications with DA office. Asking for Jen McCabe's cell phone records be sent to them as soon as they can get them. Keep in mind, feds likely have Jen's phone records already, so they may want to see them because they suspect whoever hands them over to the defense will delete things that won't match up with their records. The mere fact that they are the ones seeking out Karen's lawyers tells you that this is far from over and they want more info for this case. Levy asked them, if, quote, if you are contacted by media in the next coming days or weeks, we would appreciate if you did not mention us working together. Why would he ask that unless he knew something was going to happen and they were contacted for comment on it? That's what I'm saying. Like, Levy said we would appreciate if you did not mention us, that DOJ, the old DOJ, and Reed's team working together. I'm telling you, Levy and Karen talk directly. Like, this is some shit. People got to realize what little towel's onto. It's 1 a.m. I don't care. I'm doing research, and you're coming along for the ride. Welcome to Towel Stream. Thank you for flying your towel. This is clearly the red eye.
2635.101a. For the reasons described above, we concluded that Rollins used her position as U.S. Attorney and non-public DOJ information available to her as U.S. Attorney to further Arroyo's private interest in winning the primary election and her own private interest in preserving her legacy as DA through Hayden's defeat, in violation of Sections 2635.702 and 2635.703. She did so by, among other things, disclosing to a news reporter non-public DOJ information she possessed by virtue of her position as U.S. Attorney in order to disadvantage Hayden, Arroyo's opponent in the primary election, and damage Hayden's reputation, in violation of Section 2635.703. Rollins also used her position as U.S. Attorney for her own personal gain and the gain of Arroyo, in violation of Section 2635.702, by using the DOJ recusal process to create the impression that DOJ was or would be investigating Hayden. Although seeking recusal in a matter involving her former office was warranted, we found that Rollins's attempt to use the recusal in a response letter to the law professor and her later disclosure of the recusal memorandum to the Herald indicates that Rollins used the recusal as a basis to say that DOJ was initiating steps towards an investigation. Further, even though Rollins was ultimately unsuccessful in convincing the first assistant U.S. attorney to issue a revealing letter before the primary election, we concluded that Rollins nevertheless used her position as U.S. attorney to advocate for the letter with the intent of inducing her subordinate to provide a benefit to Arroyo and herself, within the meaning of Section 2635.702a.
Do you realize that means that Josh Levy is a material fact witness to a crime committed by Rachael Rollins? What the fuck? If this were prosecuted, all these fucking people would be witnesses. That's why they didn't fucking prosecute it. Who the fuck prosecutes who is supposed to prosecute this? Like, tell me, how the fuck do you prosecute this? And all these people? And, like, how do you call these people as witnesses unless you're the DOJ? And you're not going to prosecute. Like, this should have been prosecuted. The only reason this wasn't prosecuted is who the fuck is going to subpoena the chief of the criminal division, the head of the public integrity unit, the executive officer of the district, the U.S. DOJ. Probably have to bring in the New England DOJ. It's a fucking clusterfuck. And so somebody was like, just resign and go away quietly. Then Rachael Rollins shows up on June 18th, makes a single tweet about fucking Turtle Boy. That maybe she didn't realize I've been looking into this for 3 years. And open this whole fucking can of worms. What the fuck? This is ridiculous. How was this not prosecuted? This is fucking absurd. Like, I get the OIG didn't call the reporters as, like, witnesses. You can tell they were a little sensitive about that. But fuck. These were serious crimes. And Josh Levy was a fucking fact witness. Oh my God.
Accordingly, we concluded that Rollins used her position as U.S. Attorney and used non-public DOJ information available to her by virtue of her position as U.S. Attorney in an effort to influence the outcome of an election for her benefit and that of Arroyo's, in violation of Sections 2635.702 and 2635.703. B. Department policy violations. We concluded that Rollins's improper use of DOJ information also violated department policy in 2 respects. First, Rollins did not comply with the department's admonishment that law enforcement officers and prosecutors must not time any action in any matter for the purpose of affecting an election. Justice Manual 9-85.500, entitled Actions That May Have an Impact on an Election, specifically provides: federal prosecutors and agents may never select the timing of any action, including investigative steps, criminal charge, or statements, for the purpose of affecting any election, or for the purpose of giving an advantage or disadvantage to any candidate or political party. Such a purpose is inconsistent with the department's mission and with the principles of federal prosecution. See 9-27.260. Any action likely to raise an issue or the perception of an issue under this provision requires consultation with the Public Integrity Section, and such action shall not be taken if the Public Integrity Section advises that further consultation is required with the Deputy Attorney General or Attorney General. 47. As discussed previously, we found that Rollins made her initial disclosures of DOJ.
All right, so Henry Blue, you know how you called it the Public Corruption Unit? That's like the JV. Well, it's not the JV term, but like the real big leagues is the Public Integrity Section. I kept saying it, the Public Integrity Section. That's the big leagues. I would know. I'm not in the government. I'm just some guy. I swear I'm just some random guy. I have no connection to the government. I'm just very interested in all of this.
Information to the Herald on September the 2nd to disadvantage Hayden in the primary election. 47. As discussed previously, we found that Rollins made her initial disclosures of DOJ information to the Herald on September the 2nd to disadvantage Hayden in the primary election. Her additional disclosures to the Herald on September the 9th to damage Hayden's reputation occurred while he was a candidate for DA in the general election. We concluded this conduct violated Justice Manual 9-85.500. Second, Rollins violated department policy that instructs employees to presume that non-public, sensitive information obtained in connection with work is protected from disclosure and cautions that disclosure of such information to anyone is prohibited and could lead to disciplinary action. Justice Manual 1-7.100. This policy exists because much of DOJ's work involves non-public, sensitive matters. Disseminating non-public, sensitive information about DOJ matters could violate federal laws, employee non-disclosure agreements, and individual privacy rights, put a witness or law enforcement officer in danger, jeopardize an investigation or case, prejudice the rights of a defendant, or unfairly damage the reputation of a person. 48. Further, the department's long-standing policy and practice is not to confirm or deny the existence of an ongoing investigation, except in very limited circumstances, or imply that the receipt of a request or referral will lead to an investigation. See Justice Manual 147. It has been the department's practice, during election years, to have the Attorney General issue an election year sensitivities memorandum to all DOJ employees. See, for example, Merrick Garland, Memorandum for all Department of Justice employees, Election Year Sensitivities, the 25th of May, 2022, William Barr, Attorney General, Memorandum for all Department of Justice employees, Election Year Sensitivities, the 15th of May, 2020, Loretta Lynch, Attorney General, Memorandum to all Department employees, Election Year Sensitivities, the 11th of April, 2016, Eric Holder, Attorney General, Memorandum to all Department employees, Election Year Sensitivities, the 9th of March, 2012, Michael Mukasey, Attorney General, Memorandum to all Department employees, Election Year Sensitivities, the 5th of March, 2008. These memoranda contain the same admonition as in Justice Manual 985.500 that law enforcement officers and prosecutors must not time any action in any matter for the purpose of affecting an election. Rollins received Attorney General Garland's Election Year Sensitivities Memorandum on the 25th of May, 2022, and an update from ESA about the memorandum on the 8th of August, 2022. 48. Justice Manual 1-7.100. 7.400 and 1-7.410. 49. Moreover, because she was recused from the matter, Rollins was not authorized to make an exception to the department's policy and practice. As described previously, we found that Rollins intentionally disclosed sensitive, non-public DOJ information to a reporter, including texting the reporter photos of the September 1st recusal memorandum from the Office of the Deputy Attorney General, to create the impression that Hayden was or would be under DOJ investigation. The information she disclosed was particularly sensitive given that the matter involved a candidate in a primary and general election. However, even without this added sensitivity, we believe the importance of protecting the department's internal discussions and actions before deciding whether to open a public corruption investigation of a sitting district attorney and his first assistant was without question. Accordingly, we concluded that Rollins violated department policy, codified in Justice Manual 1-7.100, by disclosing non-public, sensitive information to a reporter without authorization. See Ethics Agreement violation. We also concluded that Rollins's use of DOJ information in a matter involving the Suffolk D.S. office during her communications with the Herald reporter violated her obligations under the Ethics Agreement she signed on the 6th of August, 2021, after she was nominated to serve as the U.S. Attorney for the District of Massachusetts. Rollins's Ethics Agreement contained the following provision. Upon confirmation, Miss Rollins will resign from her position as Suffolk County District Attorney. For a period of 1 year after her resignation, she will have a covered relationship under the impartiality regulation at 5 CFR 2635.502 with the Suffolk County District Attorney's Office. 50. Pursuant to 5 CFR 2635.502, d. Miss Rollins will seek written authorization to participate in particular matters involving specific parties in which she knows the Suffolk County District Attorney's Office is a party or represents a party. However, during her appointment to the position of United States Attorney, Miss Rollins 49, the department's policies on confidentiality were covered during new U.S. Attorney orientation, which Rollins attended in March 2022. 50. In interpreting Section 2635.502, the Office of Government Ethics has stated that this regulation establishes a mechanism for an employee to determine whether appearances require his disqualification from an assignment and to seek authorization from an agency designee before he does participate. See U.S. Office of Government Ethics, Opinion 97X8, Letter to a United States Senator dated the 22nd of April, 1997. Section 2635.502a covers a situation where an appearance of impartiality may exist due to a personal relationship between the employee and a specific party involved in a particular matter. Particular matter involving specific parties is defined to include any judicial or other proceeding, application, request for a ruling or other determination, contract, claim, controversy, investigation, charge, accusation, arrest or other particular matter involving a specific party or parties. C5 CFR 2640.102, L. This definition also states, the term typically involves a specific proceeding affecting the legal rights of the parties, or an isolatable transaction or related set of transactions between identified parties. ID. Will not participate personally and substantially in any particular matter involving specific parties in which she previously participated in her capacity as Suffolk County District Attorney. After being confirmed,
That's it. You don't understand. Rachael Rollins. Holy fuck. Holy fuck. Oh my God. In December of 2023, the Norfolk County District Attorney's Office. Oh, it was it was for a period of 1 year. Until January of 2020. It started in November of 2022. Oh my God! I got it! Oh my God, I got it. Someone's going to tell the Norfolk DA. This is incredible. Listen to me. Because the Norfolk DA moved as an amicus curiae in the fucking case where Rollins was Suffolk DA and was pushing in a specific case to avoid giving a life term to a youthful offender under 25, I think the Suffolk DA actually intervened as an amicus curiae. Okay, now listen to where this goes. Where I'm gonna have to talk about this tomorrow. This is fucking incredible. That means that he was technically a party. He was a specific party, the district attorney himself, in a previous proceeding. When Rollins was Suffolk DA, that means pursuant to the terms of her ethics agreement, she was precluded from being involved in any investigation of the Norfolk DA until January of 2023. And she was not recused when fucking Reed and Jackson and Unetti went into his office, in Levy's office, in fucking November of 2022. Thank you. Oh, that has monumental implications. fuck? All those witnesses, the grand jury might have been invalid. Though that, oh my God. Oh, fuck. Some people are going to get fucked. I think I can break that right now. And it's even more fucking explosive because they, the Norfolk DA tried to get the DOJ to recuse itself in 2023. I mean, by then, it obviously, Rollins was gone. You were talking like November of 2023 or something. Oh, whoa. Oh my God. Oh my God. I wonder when that actual recusal went in, but the point is, the federal probe of John O'Keefe's death started because Karen Reed walked into, with David Yannetti and Alan Jackson, Josh Levy's office in November of 2022, which was a covered period. I mean, it's just explosive. No wonder why I stayed up. I wonder if anyone actually stayed up to see me find that. Good for you if you did. Well worth it. Well worth it. All right, so I got to put this together. Boom. Wow. That's just, it's fucking incredible. How did nobody catch this? What the fuck? How did, I mean, I guess it's kind of hard to find. It's kind of a little bit esoteric, but like, come on. Nobody caught this the whole time? That's a fucking story. Come on. No other fucking outlet put this together. That's just unfair. Why is it all got to fall the little towel at 12:30 in the morning after I've been up all day? It was fated. Ladies and gentlemen, it was fated. If you stayed up this long with little towel, you saw a fucking moment and a half right there. Some of you would be like, Grant, I went to bed like 4 hours ago. What are you doing? You have been up all day. Well, you know what? It was fated. It was fated because I'm a fucking towel. I knew it. I knew it. That is the greatest thing. Somebody give me a fucking medal. I want a medal for that one. This is non-negotiable. I want a medal. I just made so many of your... I just changed a lot of people's fucking lives. I don't care. They might not realize it for a little bit. You have no idea, some of you, perhaps if you're still listening, what this means. This is fucking incredible. It's absolutely incredible. It's like the greatest thing. I cannot believe I was able to put that all together. I mean, this is absolutely incredible. I mean, this is great. This is the greatest thing I've ever seen in my entire life. So I just have to take this through for you all again. The 5 of you who are awake at whatever time, ungodly time it is. I don't know if you really appreciate the impact of what just came down here, but what you, and sorry if the chat has not been working, that might have been actually my fault. I froze it a long time ago. I'm really sorry, chat. That was entirely my doing. I mean, I don't even know if I appreciate the extent of what has just happened. I felt so guilty. I was like, oh, people aren't really chatting. And then I was just so into what I was doing that I was not noticing that the chat froze. So I'm really sorry about that. I'm going to fix it for you right now. I feel like a silly little towel. I was like, oh, they're just not talking, you know? Like, I know the chat works for you, but it wasn't showing up on my screen. It was literally frozen. So if all of you have been like, Grant, no, we're here listening to you. This is incredible. I'm sorry. I thought you were all bored. Oh, no. Someone sent a super chat and I missed it because the chat was frozen. Oh, hello, Harvard Yard. Hello. I'm still awake. I am a towel. Good morning. Good morning. I am a towel, and I think I just figured out the federal probe of John's death was invalid. I am a towel. God bless you for being with me. I'm so sorry. I am so sorry. I swear I thought you were all just not talking because the chat froze. So I was just sitting there being like, oh, they really don't like this. I'm so sorry. I don't understand why you aren't chatting. But I didn't have time to stop and think that it might be frozen because I was enthralled like a little towel. You don't understand. I have just been going and going. Taterbug was here. I feel so bad that I miss people going to bed. Hello, I am a super towel. I'm just here being my little towel self. I just discovered that the federal probe of John's death was invalid. Now listen, I think I am perhaps the only person in the entire world that could have put this together. Although I'm sitting there like, what the fuck? What do you mean you didn't put this together, world? Listen. The federal probe of John's death was invalid because Rachael Rollins signed an ethics agreement when she became U.S. attorney saying she couldn't be involved in any matters with any parties from when she was Suffolk DA until January of 2023. And the Suffolk DA filed a fucking amicus curiae motion, which makes, I don't know if it makes you a party, but it at least it brought him involved in a case. It creates an appearance of impropriety. He was in the orbit of the case. He filed a court document. He entered an appearance. He filed an amicus, which is a friend of the court brief, which is extending the notion of party. But the point is the same. There's no way that recusal request from the Norfolk DA to have that whole office recuse itself from the probe of John's death should have been denied when at the very least Rollins' ethics agreement prohibited her from engaging with any cases that touched on people who were parties to cases when she was Suffolk DA. And you can argue that an amicus curiae is a little bit outside the scope of the definition of the word party, but you know what? It's an appearance of impropriety, and the whole thing, and the fact that the Reed walked into Levy's office in November of 2022, while the ethics agreement was still in place, it's enough. It's enough, and I am a towel. Good morning. I'm sorry if I woke you up by switching from us listening to that document being read to me just yelling things. But you know what? I figured it out, and I'm sticking to it. Well, that's what happens when I have a Red Bull and a Skittles energy drink. But it wasn't really about, and I had a coffee actually at about like 11. It's not really about that. It's more the content. If I didn't have something that was this interesting, like this is the most interesting document I have ever read. I wanted to spend my life. First of all, it is so well done. This is what our government should be. This OIG document. If every court document, if everything I read all the time was like this, I would be the smartest man on the face of the planet. This is the best thing I've ever read. It is just so well written. There's not a single fucking typo. Even the fucking formatting of the complex federal statutes and codes is perfect. This is the greatest thing I have ever read in my life. I am sorry that I had this in front of my eyes for years and didn't take the time to appreciate its resonant beauty. But now, at 1 a.m, live, doing this as an academic exercise, thinking none of you were watching because the chat was frozen, I'm having the time of my life. Now, I realize for some of you, it is not 1 a.m, but I'm in Boston, and that's just how it's going to go. So, you got to give me a second to write this up. Hold on. See, I'm an old-timey reporter towel. Got to get my cigar, got to get my keyboard. I must perplex the world, ladies and gentlemen. I must perplex the world. Well, this is interesting. former U.S. Attorney for the District of Massachusetts, Rachael. No, I think that's how it is. Rachael. Rachael Rollins was prohibited from being involved in any federal investigations involving this is hard to frame. Former U.S. Attorney for the District of Massachusetts, Rachael Rollins, was prohibited from being involved in any federal investigations involving parties in the orbit of her cases as Suffolk DA until January of 2023. Yet somehow Rollins did not recuse herself when Karen Reed, Josh Levy, and David Yannetti walked into Josh Levy's office in November of 2022 requesting a probe of the Norfolk DA. Now, here's where it all comes to a head. The Norfolk DA, when Rollins was Suffolk DA, why does the word DA have to have two periods? It is very hard to use punctuation with two periods. Moved to intervene in a case Rollins was prosecuting, yet for some reason the DOJ denied a recusal request from the Norfolk DA. In the context of John O'Keefe's death. The Norfolk DA, when Rollins was Suffolk DA, moved to intervene in a case Rollins was prosecuting, yet for some reason the DOJ denied a recusal request from the Norfolk DA. Later in 2023. If this means that the now confirmed as closed federal probe into John's death was launched in violation of, hold on, so what happens if you violate a ethics agreement? Hold on, what's the section of, I'm sure they're going to cite it, hold on. So it just says she violates her ethics agreement, but what happens if you do that? Oh yeah, okay, hold on. It's in violation of 5 CFR section 2635.502. And I want to include a second one. 5 CFR section 2635.502D, which prohibited, which should have prohibited Rollins from hold on, I got to double check the last paragraph, in which she previously participated. And so I got to get this exact quote. So Ms. Rollins, hold on, I got to go from page to page. So Ms. Rollins will not participate personally and substantively in any particular matter involving specific parties in which she previously participated in her capacity as Suffolk County DA. Reads the relevant part of Rollins's ethics agreement, which is, what's it called? The immunity something? Which defines a covered relationship under the immunity regulations, which defines covered relationships under relevant immunity, under relevant impartiality regulations, which are laws. Well, all right, so here's how I have it written. Well, this is interesting. Former U.S. Attorney for the District of Massachusetts, Rachael Rollins, was prohibited from being involved in any federal investigations, I can't say involved twice, related to, was prohibited from overseeing, participation in. Former U.S. Attorney for the District of Massachusetts, Rachael Rollins, was prohibited from participation in any federal investigations involving parties in the orbit of her cases, in the orbit of her cases, in the orbit of cases from her time as Suffolk DA. Orbit of cases from her time as Suffolk DA. Until January of 2023. Yet somehow Rollins did not recuse herself when Karen Reed, Josh Levy, and David Yannetti walked into Josh Levy's office in November of 2022 requesting a probe of the Norfolk DA in the context of John O'Keefe's death. All right, so hold on. Walked into Rollins's then first assistant is capitalized. Josh Levy's office in November 2022 requesting and obtaining a probe of the Norfolk DA. The Norfolk DA, when Rollins was Suffolk DA, moved to intervene in a case Rollins was prosecuting was prosecuting and became a amicus curiae. I think it's amicus C-U-R-A-I, amicus curiae. Nope, it's C-U-R-I-A-E, C-U-R-I-A-E, and became an amicus curiae, C-U-R-I-A-E, and became an amicus curiae during those proceedings. Yet, for some reason, the DOJ denied a recusal request from the Norfolk DA later in 2023, despite the fact that Rollins did not recuse herself throughout between November of 2022 and January of 2023 as required by her ethics agreement. From the orbit of that probe between, if this means the now confirmed is closed federal probe into John's death was launched in violation of 5 CFR Section 20 and 5 CFR Section, which should have prohibited Rollins from being involved in any way with a former with a participant in a prior proceeding from her Rollins's time as Suffolk DA until, at the earliest, January 11th, 2023. My God. My word, ladies and gentlemen. My word. My word. Just my word. just when you think you can't find more, I'm sorry I've been reading your comments, but you saw it live. Super towels. I'm so glad Harvard Yard is here. And I am, if you're following page by page, I am on page 82 out of 161. Let me get you a link to the document if you haven't found it. This is the document. Hello, Beach Nance. Been on this a long time. Oh yeah, this is very interesting stuff, and I can't believe I just may have proven that the probe of John's death, I mean, I don't interpret these regulations, but I think the probe of John's death was invalid from the start. Yep. So I have to keep summing this up. Hold on. In May of 2023, Rollins was forced out of office by the DOJ OIG after the OIG uncovered Rollins attempting to abuse the office of U.S. Attorney to manipulate the primary election between Kevin Hayden and Ricardo Arroyo for Rollins's old seat as Suffolk DA. Then, when Rollins failed to knock Hayden out at the primary stage, the OIG found that Rollins pushed the DOJ to issue a recusal letter related to a non-existent probe of Hayden, non-existent probe of Hayden, such that Rollins could leak that recusal letter to the Herald and the Globe in order to smear Hayden's reputation in retaliation for Arroyo's loss. I mean, that's a complex sentence. Unless you really follow Boston politics, that's a complex sentence. In retaliation for Arroyo's loss. All right. And I mean, like, that's not even the half of it. Interestingly, I really do believe I'm right about this. Interestingly, Josh Levy, Dustin Chao, and Bill, what's his name? Bill Abley? What was that dude's name? Hold on. I think it was Bill Abley or something. It was yesterday, right? Wait a minute. Bill Abley. William Abley is his name. William F. Abley, but he goes by Bill, apparently. Dustin Chao and Bill Abley may have cooperated with the DOJ OIG's investigation that culminated in Rollins's departure from office. And then how do I explain this? Rollins attempted to pressure Levy. Rollins attempted to pressure Levy into responding to an email from a local law professor demanding an investigation into Hayden. Although it seems likely that Rollins herself asked for that email to be sent in exchange for going to a book signing for that professor, who is very progressive and wanted to see Arroyo and wanted to see Rollins' legacy preserved, apparently, by way of Hayden beating Arroyo beating Hayden. Because beating Hayden. Hayden was not. Arroyo was willing to continue Rollins's soft on crime approach to prosecution, coupled with her distrust of police, while Hayden was a more conventional, moderate figure in the race. So let's see. I mean, that is a very complex sentence. I'm going to use a double parenthesis. I don't even care. All right, interesting. Josh Levy, Dustin, Chao, and Bill Abley, all high-ranking staffers under Rollins in the DOJ, may have cooperated with the DOJ's OIG's investigation. And then the best part is, I have to include the thing about Medved. Then, after Rollins left office and the professor in question was forced to cooperate with the OIG against Rollins, the professor filed an ethics complaint against Dustin Chao. What a strange world in which we live, my dear friends. I don't even know. I'm literally ending the article there by saying, what a strange world in which we live, my friends. Now, I have to actually get the Rollins OIG report, so let me link to that. Where is it? Read that report. Here. There we go. I think I should tag the Congress. Somebody call me an adult. Somebody get me a member of Congress. I need help. I'm just a little towel. You can't just sit around and be like, oh, he'll figure it out. Grant will save the country. Don't worry. We don't have to have checks and balances in government. We could just call Grant. He'll go and he'll fix the state regulatory apparatus, and he'll go deal with that problem and that problem. We'll just leave it to Grant. What could go wrong? It won't force him to stay up for hours and days on end. He'll be just fine. Look, yes, and then when we have issues with people stealing our ballistic missile secrets, we'll go to Grant. We need to break up regulatory oligopolies, we'll go to Grant. If we just go to Grant, we won't have to think about anything. I don't know if that is a good way to govern. Okay? I just don't know if that's going to work. God help us all, ladies and gentlemen. God help us all. I gotta get this ethics complaint against Dustin Chao. Hold on. I'm a little bit just blown away. Just blown away. I'll never understand it. Well, I will understand it. I am an old-timey towel cigar smoking reporter. You see what I'm saying? I am a reporter. And I treat myself like I pretend like it's the 1920s, and I'm Ida Tarbell. You know, I'm just writing about Standard Oil and all the other crazy things that go on in the world. You see me with my cigar? That's how I think of myself. I am an old-timey towel reporter. Read that ethics complaint here. You know what, ladies and gentlemen? Have you ever wondered if I am a towel reporter? Well, the answer is yes. I clearly was born to deliver the news. That's why I have a backwards hat on and a cigar in my mouth, and that's why it's 1 in the morning, and I am discovering ridiculous things buried in DOJ documents at 81 pages in. I'm pretty sure I've listened to about 100,000 words today. It was a very interesting document. We're not done with it. I just got to publish this article first. You don't understand. I have an obligation to the wider world, ladies and gentlemen. I am a towel. And now a lot of you are going to say, we are well aware of that, although you haven't told us that a lot today. I am a towel. And if you're tuning in and wondering, why is this man analyzing court documents at 1 in the morning with a cigar in his mouth? Well, I can't really answer that question. I am a towel. My primary objective right now is to continue to repeat that until I get through writing up this document. Oh, we might start a little late tomorrow. Let's just say that. But it was worth it because we got to spend time together and people could just watch the replay as they're waiting. They're like, why was Grant up until 4 in the morning? What were they doing? And what did I miss? He never does this. He just didn't stop. He just kept going. Who gave this man a microphone, a computer, and the ability to do live journalism? He is creating a new discipline. I'm not sure if this is good for America. What are you talking about? This is wonderful for America. I am a towel. So yeah, I'll show you the wonderful article I wrote up. Give me a second. All right, ready for it? There you go. How'd I do? I wrote a towel article. You want to hear it? I'll read it for you. Why not? I'm a towel. All right, so, I'm sorry. I think the comments are working. Very good. All right, so, yeah, it's a little past towel bedtime. It's okay. Now, here's the article I wrote. It says, here's how it reads. Well, this is interesting. Former U.S. Attorney for the District of Massachusetts, Rachael Rollins, was prohibited from participation in any federal investigation involving parties in the orbit of cases from her time as Suffolk DA until January of 2023. Yet, somehow, Rollins did not recuse herself when Karen Reed, Josh Levy, and David Unetti walked into Rollins' then first assistant Josh Levy's office in November of 2022 requesting and obtaining a probe of the Norfolk DA in the context of John O'Keefe's death. The Norfolk DA, when Rollins was Suffolk DA, moved to intervene in a case Rollins was prosecuting and became an amicus curiae during those proceedings. Yet, for some reason, the DOJ denied a recusal request from the Norfolk DA later in 2023, despite the fact that Rollins did not recuse herself from the orbit of the probe between November of 2022 and January of 2023 as required by her ethics agreement and federal law. Well, ethics agreement's fine. If this means that the now confirmed disclosed federal probe into John's death was launched in violation of 5 CFR section 25, section 2635-502 and 5 CFR section 2635-502D, which should have prohibited Rollins from being involved in any way with a participant in a prior proceeding from Rollins' time as Suffolk DA until at the earliest January 2023 is unclear. So hold on, I do have to actually edit this. Is unclear. All right. And then up here, and federal law. Because federal regulations are technically federal law. All right. So let me download that again. Hold on, little towels. Hold on. Had to make some edits. All right. Quote, Ms. Rollins will not participate personally and substantially in any particular matter involving specific parties in which she previously participated in her capacity as Suffolk County DA. Reads the relevant part of Rollins' ethics agreement, which defines a covered relationship under relevant impartiality regulations, which are federal laws. Which, under relevant federal impartiality regulations. I'm going to have to download that again. In May of 2023, Rollins was forced out of office by the DOJ OIG after the OIG uncovered Rollins attempting to abuse the office of U.S. Attorney to manipulate the primary election between Kevin Hayden and Ricardo Arroyo for Rollins' old seat as Suffolk DA. Then, when Rollins failed to knock Hayden out at the primary stage, the OIG found that Rollins pushed the DOJ to issue a recusal letter to related to a non-existent probe of Hayden, such that Rollins could leak that recusal letter to the Herald and the Globe in order to smear Hayden's reputation in retaliation for Arroyo's loss. Read that report here. Interestingly, Josh Levy, Dustin, Chao, and Bill Abley, all high-ranking staffers under Rollins in the DOJ, may have cooperated with the DOJ OIG's investigation that culminated in Rollins' departure from the office. Rollins attempted to pressure Levy into responding to an email from a local law professor demanding an investigation into Hayden, although it seems likely that Rollins herself asked for that email to be sent in exchange for going to a book signing for that professor, who is very progressive and wanted to see Rollins' legacy preserved, apparently by way of Arroyo beating Hayden. Arroyo was willing to continue Rollins' soft-on-crime approach to prosecution, coupled with her distrust of police, while Hayden was a more conventional, moderate figure in the race. Then, after Rollins left office and the professor in question was forced to cooperate with the OIG against Rollins, the professor filed an ethics complaint against Dustin Chao. Read that ethics complaint here. What a strange world in which we live, my dear friends. What do you think? What do you think? I did it. I did it, ladies and gentlemen. I put it all together, and I made a good, cohesive towel argument for why I'm right. And the best part is that I might have actually found a potential hook for why the investigation, as it started, was a violation of federal law. That's wonderful. It's wonderful. Somebody give me a medal. Harvard Yard did give me a medal. I forgot. I already got my medal. I'm a super towel. All right, let me push it. I'll publish it. Give me a second. I must be a towel. Boston Globe, I understand why you're not covering this, but come on. Come on. Why's Little Towel got to be the one to find all of this stuff? Can someone just come along and be like, it's okay, Little Towel. We will help you. Don't worry. Well, you do in the comments. That's true. And I'm not even looking at the comments. I just know that's something you do. But me sitting around being a little towel, discovering this stuff, it does blow my mind sometimes, I will tell you. And then I just stand around and say, how did I find this? I'm a towel. All right, we're not done with that Rollins document, though. Hold on. Definitely a long day, though. Worth it, though. I'm not tired. I think it's because I know we don't have to get up tomorrow. I'll start the stream a little bit later. I do have to get my car, the oil change done, though. And yes, if you've been trying to contact me, I'm sorry. I definitely put my phone on vibrate, and I did not pay attention to anything for a little bit there, so not your fault. I'll try to look at the A-B-E-L-Y. Don't tell me I spelled his name wrong. A-B-E-L-Y. Damn it, I spelled his name wrong. Nope, I will not have this, friends. I must go back now. I spelled his name wrong. It is A-B-E-L-Y. It is not A-B-L-E-Y. A-B-E-L-Y. I will not disrespect that man. He served our country. He clearly put a stop to what Rachael Rollins was doing. So I shall spell his name correctly. If I spell your name correctly, it normally means either I did it by accident or I passively aggressively don't like you. One of those two things. Someone one time, I think it was like Sue, she was like, Grant, like, at least you spelled the names right this time. And I was like, wait, like you don't realize I spell people's name wrong, like if I don't like them? Come on, Sue, that's half the fun. Are you not an artiste? All right. I spelled the man's name right. A-B-E-L-Y. Let me double check that. A-B-E-L-Y. I am a towel. I am a towel. I am a towel. I think it's crazy how they don't identify them in the document. If you read that document 40 years from now, you could never in a million years figure out who those people are. Towel could, though. All right, let me see. Everybody like the article? I don't know if I can... Yeah, I don't know if Karen can be charged, but Josh Levy might have broken. I mean, I don't. Listen, you know what I'm saying? You know what I'm saying? That, like, somebody did some shit. Oh, that's the thing. I want to include that document from November of 2023. Yes, indeed. Let me see if I can just link right to it. All right, very good. Interestingly, in the fall of 2023, after Rollins had left office, it appears that Josh Levy himself may have leaked non-public information to Karen Reed and her legal team that in turn Reed leaked to Aidan Kearney, who then revealed the conversations to Lindsay Gazzani. Oh my God. Oh my God. No wonder why nobody can understand any of this. I sound like literally, if you didn't actually watch me do this, if you didn't know what I'm talking about, if you didn't know all these people, this would sound absurd. But like when I actually talk to serious people about this, and I have, I've got approached by some pretty serious people who would like to tell this story. I don't know. They're like, most of their reactions are like, first of all, how do you know all of this? Like, first of all, not only how do you know it, but like, how do you have it to, like, the day, the timestamp? Like, how is this possible? And how are you doing this across all these different stories? And then, like, I don't know. I close my eyes and it's all just there. It's easier when I, like, read it, like, 10 minutes ago. But once I hear it, it's there forever. I'm never going to forget anything that I just listened to. I'm going to remember that document for the rest of my life. I'm going to listen to it, like, 50 times before I pass away, I hope. But my point is, I remember everything we just listened to. And I remember almost everything I read and hear. So it's very easy for me to go into these conversations. But I think for most people, it's not normal. So they just look at me befuddled. And I'm like, why are you befuddled? Like, I don't have time for you to be befuddled. Do you want to, like, talk about this and get shit done? And they're, like, furiously scribbling. And I'm like, I don't have time for you to do that. Like, we got to talk, you know? But they'll be like, Grant, like, slow down. I wouldn't say that. They'll be like, okay, Grant, like, let's narrow in on the 17 different things you're talking about and try to take them one by one. A good interviewer will do this. Let's take them one by one, and then let me find out, like, the key details I need from what you're telling me based on my own experience and what I already know, and let me piece it together in a puzzle. That's who I like to talk to. Anyone who's just like, I'm trying to understand, I love doing that. But if we're meeting one-on-one and you're like, I'm trying to understand, I'm going to be like, well, I don't know if I can work with you. I need you to already understand so we can have complex theoretical schematic conversations about how to solve all of these problems. Not that trying to understand isn't good either. Like, you have a didactic experience requires learning. But, you know, let's see. Said Kearney to Lindsay, relaying what he had been told by Karen's team. I found out some information on the way home about the feds that I will not be making public. Really? Lindsay replied, good, period. Good or bad? Hold on. Let me see. On or around 11. This is why he tried to discredit Lindsay, in my opinion. Well, for a number of reasons, but this was the big one. He fucked up. You can't say this shit. You exposed Josh Levy to some serious shit by telling Lindsay this. That's where he really fucked up. He didn't really fuck Karen over. Who gives a fuck Karen's not a fucking DOJ employee. She's just some fucking Fall River chick. In her words. Chick with a Fall River accent. Oh, no, that was one of the troopers talking about her. I'm sure what does she refer to herself as? The weed whacker? Oh, the wife of a Boston cop. That's right. I didn't see their marriage certificate. I must have missed it. All right, I got to type this up. Let's see. The feds have requested a conference call over the weekend. Josh Levy himself asking questions like, quote, is there any chance the state trial date could be delayed? Question mark. Only one reason to ask that. The feds are asking for all communications with DAs, he's not good at texting. All communications with the DA's office. I cleaned this up for him a little bit. His text is sloppy, to put it lightly. It is not very good syntax. I give you no style points. 3 out of 10 aided. Let's see. The feds are asking for Jen McCabe's, not capitalized. Come on, do you have no respect for the English language? This is blue-blooded murder of the English tongue. I am offended. You don't even capitalize people's names. You don't even use apostrophes. Oh my goodness, I am offended. If you are going to text, especially if you're going to text an intelligent woman, at least fucking use appropriate fucking syntax. What the fuck is wrong with you? This is why gentility is dying. Alright. And they're asking for Jen McCabe's cell phone records to, not be sent over, to. This is like editing a child's writing. Record. They are asking Jen McCabe for. They are asking for Jen McCabe's cell phone records to. Let's see. Be sent to them as soon as they get them. Keep in mind the feds likely, that went nowhere, have Jen's phone records already, so they may want to see them because the feds suspect whoever hands them over to the defense will delete things that won't match up with their records. The mere fact that they are the ones seeking out Karen's lawyers tells you that this is far from over and that the feds want more information for this case. And then he says something really weird. Josh Levy asked Karen Reed's defense, as Karen Reed's team, if Josh Levy asked them, it's not an ask, it's he told them, and this part's really shocking. If you are contacted by media in the next coming days or weeks, we would appreciate if you did not mention us working together. Why would Levy ask that unless he knew something was going to happen and they were contacted for comment on it. Yeah, I know the answer, Aiden. It's because they wanted to preserve the integrity of the Birchmore probe, which started in August of 2023, and which you probably weren't allowed to know about because you, Aiden, were probably adjudged by the feds to be the type of person who would have told Lindsay Catani about it. And if you had told Lindsay Catani might have told the state police. So therefore, you weren't allowed to know either. And in reality, Levy was telling Karen's lawyers to shut the fuck up because if they talked too fucking much, somebody was going to figure out while the Farwell probe was ongoing, which, by the way, touches on the state police and all type of shit, that it was active. So that's why you couldn't figure it out, Aiden, because somebody wasn't telling you everything, and someone may not have even been telling Karen everything. And also unrelated to all of this, Kevin Reddington's a boss, but he kind of intimidates me. I watched him do a whole federal trial once down in, it was in Boston, it was at Moakley. It was the Giselle Correa case. I live tweeted that whole case. That was really, that was a good case. But anyway, the whole federal apparatus just, I know I understand it and I would like to do oversight of it, but it fucking terrifies me, and that's putting it lightly. And you're seeing a peek inside it, by the way. You just saw me type up, like, the fact that Josh Levy was talking to Karen Reed's defense lawyers, who were then bragging about it to Aiden, or Karen might have been bragging about it to Aiden. Like, what the fuck? It's supposed to be the federal government treating it like it's like a glorified version of high school. No, I'm the popular kid. No, don't you understand? I'm the popular kid. No. I'm the U.S. attorney. Well, hold on. I'm the, like, whatever the fuck. I'm the OIG. But the OIG is very serious. I think they don't play popularity contests. You see what I mean? It's like these children. And then you have some adults in the room, but it's just a lot of, like, petty political shit. And it really, like, freaks me out because I'm going to guess this is, like, the norm. And she wasn't kidding, Rollins, in some of her answers. This is the fucking norm. And she was like, well, why are you getting so mad at me? Everybody does it. Like, Is that, like, and to, what my response is going to be? Okay, so that's why everyone does it, because none of you give a fuck. Like, literally, all of you care about just self-preservation, so of course the system's fucked. Makes me very upset. An incredulous little towel. Even Josh Levy, I could tell, like, yes, he had to get pushed to his very limit. And I can't tell if it's, like, loyalty or, like, if he just was, like, waiting to pounce, but he had to get pushed to his limit before Rollins basically forced him to do something. When he wouldn't do it, Rollins, like, and mind you, it's a little weird. I think it's because she was recused. Like, it's a little, because she's his boss, technically. But, like, she forced him to do something. He wouldn't do it. Respond to Medvedev. I got to check the spelling. Wouldn't respond to him. And then Rollins just goes and leaks it. So Levy had to have been thinking, so she not only disrespects me, she disrespects the DOJ. That had to be his red line. But then that makes you wonder, all right, so you get her position and then you immediately go do that same shit? Don't even get me started on the Cannabis Control Commission shit. You're all just... It's all just very political. And I'm somewhat of the opinion we shouldn't even have our judges be politically appointed at this point in this godforsaken state. You don't understand. I'm literally getting more and more concerned by the day that this whole system is just rotten because of politics. Not politics in the traditional sense, like liberal, conservative. No. Just who you know. It is pervasive. It is so pervasive, it's threatening the institutional integrity of our system. And this case study, like I don't know how this hit him. I know how it hit in plain sight because it makes the fucking Globe and the Herald look bad. Nah, we can't have that on fucking page one, kid. Nah. And it can't have the fucking Globe look bad. The Globe doesn't do anything bad. The Globe writes the Spotlight series. The Globe. Now, there's a lot of good people at the Globe, but you can't have the fucking narrative that the fucking Globe was running them, like being a fucking. The reality is the Globe and the Herald pick sides in that fucking primary, and they fucked Rollins over. And Rollins was pissed. She was like, what about liberal solidarity? And they were like, yeah, I don't think your anti-broken window philosophy is working, Rachael Rollins. Oh, no, I forgot the link. Oh, goodness. And that's what I'm going to guess happened. It just all came down to that. It's kind of like with Mayor Wu right now. I think the Globe will turn on her. It's just pure economics. Read more background about that communication exhibit O here. All right. I forgot to include the primary source link. That is a travesty, a sham, and a mockery. All right, so we're going to go back to the Rachael Rollins document because I've done what I needed to do, little towels. Well, I actually didn't. I have to add one more thing. We can't just not include the link to Exhibit O. Exhibit O is the most important part of the whole thing. That is the core of the reporting. Well, I wouldn't say it's the core of the reporting, but it's definitely like the core of what shows that Levy was willing to do what Rollins was doing in the Hayden situation, in the Morrissey situation. Like, so, you know, and this office was willing to do that. I think the only reason I want to figure out who like caught her, like, did they all have a meeting and they were like, you know, it's time, you know, like, let's go, let's move on her. Because I've always heard it said, you know, like that Professor X or that Mr. X scene in the JFK movie. I've always heard it said that that's what like it's like when you're involved in these worlds. Like, it's faceless, it's nameless, and then before you know what's happening, you're in front of the OIG. Okay, well, I see how that happened to Rollins here, but it's also like, if it was really about the principle of it all, then how did it happen again with the John O'Keefe case? I don't know. All right, we're going to go back to a little bit more of this. I finished what I wanted to finish. So hold on, let me post it. God knows how people are going to react to this. There's so many journalists hunting down so many different things that I am posting. I feel some days that I'm overloading them, but then I'm like, you know what? You have entire news organizations. You can handle it. I am a single towel who stays up far later than he should because we don't have to start until a little bit later than normal tomorrow, but I'm still tired. All right, we're going to get through this, though. I'm very interested in this. Come on now. All right. Where is it? And then I'll get back to your comments. I feel very bad for missing out on them. All right, here we go. And let's get back to where we were.
As U.S. Attorney on the 10th of January, 2022, Rollins was prohibited, pursuant to this agreement, from participating in particular matters involving specific parties in which the Suffolk D.S. office was a party until at least the 11th of January, 2023, and she agreed to take the measures necessary to resolve any actual or potential conflicts in such matters, including abiding by a recusal. Rollins acknowledged this limitation in her testimony to the OIG when she stated that she contacted IRSA about a recusal because she expected to be recused from any investigation of Hayden, and she did not want to taint any such investigation. However, after the department formally recused Rollins from any potential investigation into Hayden and his first assistant DA, Rollins did not abide by that recusal. Instead, Rollins chose to communicate with and provide sensitive, non-public DOJ information concerning a potential Hayden investigation to the Herald reporter in early September 2022, as detailed above. The potential investigation from which Rollins was recused clearly falls within the terms of her ethics agreement, as it involved an accusation of illegality against Hayden and his first assistant DA. We, therefore, concluded that Rollins violated the ethical obligations she agreed to abide by in her ethics agreement. 2. Rollins violated 18 U.S.C. 1001 by knowingly and willfully making false statements to the OIG Section 1001 of Title 18 prohibits anyone from knowingly and willfully making a material false statement in any matter within the jurisdiction of the executive, or legislative or judicial, branch of the federal government. 18 U.S.C. 1001 This prohibition requires that the false statement be made knowingly and willfully. An act is done knowingly if it is done purposely and voluntarily, as opposed to mistakenly or accidentally. 51. In other words, The person knew he or she made a false statement. 52. An act done willfully requires proof that the defendant acted not merely voluntarily but with a bad purpose. That is, with knowledge that his conduct was, in some general sense, unlawful. 53-51 United States v. Hlab, 355 F.3d 155, 159, 2d Sir 2004. 52 C. United States v. Smith, 831 F.3d 1207, 1222 N.27, 9th Sir 2017, listing elements, Brian v. United States, 524 U.S. 184, 193 1998, noting that the term knowing in requires proof of factual knowledge as distinguished from knowledge of the law. Quoting Voice Motorlines v. United States, 342 U.S. 337, 345, Jackson, J., dissenting. 53 United States v. Stance, 583 F.3d 196, 210, 3d Sir 2009, citations omitted, see also Hlab, 355 F.3d at 160, finding no plain error in the district court's failure to require more specific knowledge of illegality than that the defendant was aware of the generally unlawful nature of his actions. United States v. Moore, 612 F.3d 698, 703-04, D.C. Sir 2010, Kavanaugh, J., concurring, expressing that willfully under Section 1001 require, s, proof that the defendant was aware that the conduct was unlawful. The prohibition also requires that a false statement be material. A false statement is material if the statement has a natural tendency to influence, or is capable of influencing, a discrete decision or any other function of the agency to which it is addressed. 54 The statute is viewed as seeking to protect both the operation and the integrity of the government, and covers all matters confided to the authority of an agency or department. 55 It is irrelevant if the government was not actually deceived or influenced by the false statement or did not suffer any loss or impairment to its operations. 56 As noted previously, Rollins admitted during her 15 December 2022 OIG interview that she sent the recusal memorandum to the Herald reporter and was the federal law enforcement source cited in the Herald reporter's 11 September article. This testimony directly contradicted Rollins's 6 December 2022 OIG testimony, under oath, in which she denied being the federal law enforcement source. As described in Section 2.G.2 above, 1 week before the December 6 interview, on the 30th of November, the OIG advised Rollins's attorney that we planned to ask Rollins questions on December 6 about the recusal memorandum shared with the Herald and, at her attorney's request, we provided him with a copy of the 11th of September Herald article and access to review the recusal memorandum. We also stated at the beginning of her December 6 interview that we planned to ask Rollins questions about Ma USAO's recusal from any investigation into Hayden and the recusal memorandum shared with the Herald. On December 6, Rollins testified as follows regarding the Herald article, her contacts with the Herald reporter, and the disclosure of the recusal memorandum. OIG attorney, any communications with the Herald reporter about this article before it was published? MS Rollins, I don't believe so. And then shortly thereafter. OIG attorney, after the notice of recusal, the Boston Herald article, says a federal law enforcement source suggests this came up because of the Globe stories. Were you that federal law enforcement source that the Herald reporter cites? MS Rollins, no. And for me, there are leaks that have happened in our office many times that I have spoken to regarding the Ma USAO executive officer regarding this investigation, that we got a call, for example, from the Associated Press, that said federal sources, law enforcement sources, but I have definitely talked to the Herald. 54 C United States v. Godan, 515 U.S. 506, 509, 1995, Moore, 612 F.3d at 701. 55 United States v. Rogers, 466 U.S. 475, 479, 1984. 56 C United States v. Notar Antonio, 758 F.2d 777, 787, 1st Sir 1985. Reporter, about many matters as DA, and possibly even about this, as well. OIG attorney, about the recusal? MS Rollins, about, after an article. OIG attorney, okay. Ms. Rollins might have appeared, I could have potentially, or the Herald reporter might call or text me about certain things. There are times where I am non-responsive at all. OIG attorney, yeah. Ms. Rollins, and other times I might say, no, I have absolutely no comment. OIG attorney, do you know or have any suspicion about who the source was for this article? Ms. Rollins, I don't have any. Emphasis added. After this exchange, we described to Rollins the call detail records of Rollins's personal cell phone showing that she had phone conversations with the Herald reporter on September the 2nd for approximately 17 minutes and again on September the 9th for approximately 15 minutes. 57 In response, Rollins testified that she did not recall what she and the Herald reporter discussed over the phone. This response led to the following exchange. OIG attorney, my question was whether you can tell us whether you did or did not talk to the Herald reporter about DOJ moving towards an investigation or review of the Hayden allegations. Not, that's separate from what I heard you talk about before, about process, that the can't investigate itself. What I'm asking is specific about DOJ and DOJ moving towards an investigation or review of the Hayden allegations. Did or did you not discuss that with the Herald reporter? Ms. Rollins, not, I don't believe that I did, and certainly not from me, and I want to make sure I'm looking at one or two other things before I answer any questions to you, but it would be, let's take it away from this. I get calls all the time from the media, saying, we are being told the following. Do you have any comment on that? Or if somebody is telling us this, is that something that DOJ would do, or is that consistent with what you have seen in the 9 months that you have been the U.S. attorney, right? 57 When the OIG interviewed Rollins on December the 6th, we did not have, and were not aware of, Rollins's text messages with the Herald reporter, described previously. I don't see that, I want to look at what was happening in this time, before I answer anything else about the Herald reporter, but for me, well, let me say that, before I answer anything else. Emphasis added. A few moments later, when we asked Rollins whether she provided the Herald reporter with a copy of the recusal memorandum, Rollins asked for a break from the interview and, after the break, declined to answer further questions about the Herald leak and related topics until she had the opportunity to review her records. Prior to the resumption of Rollins's interview on the 15th of December, 2022, Rollins responded to the OIG's request for relevant communications stored on her personal cell phone by providing the OIG with text messages showing her communications with the Herald reporter in advance of the Herald reporter's the 11th of September article and showing that Rollins had provided the recusal memorandum to the Herald reporter. During the 15th of December interview, Rollins admitted being the federal law enforcement source referenced in the 11th of September article. She further testified that she denied being the Herald source on December the 6th, and declined to answer the question whether she gave the Herald reporter the recusal memorandum, because she was not fully prepared to answer our questions on December the 6th, and she had difficulty recalling her conversations with the Herald reporter and whether she had shown or sent him the recusal memorandum. According to Rollins's the 15th of December testimony, he first time I heard about the Herald reporter, or these articles, was when you mentioned it in the middle of, a several-hour interview. So, I, rather than stopping you then, which I should have, and said, what? I was trying to think throughout, because this was sort of out of left field for me. That is not an excuse. I'm just saying I was trying to think of all of my interactions with the Herald reporter, and I didn't know that was something we were going to be talking about during the interview. So, moving forward, if that happens again, I will stop and not say anything, and then, I apologize for not doing that. The OIG found that Rollins violated Section 1001A by making false statements under oath when, during her 6 December 2022 OIG interview, she asserted that she was not the federal law enforcement source referenced in the Herald reporter's the 11th of September article and had no suspicions about who was the source for the article. 58 First, these statements were false. Rollins admitted during her 15th of December OIG interview that she was the source. Second, this information was material to the OIG investigation because one of the allegations we investigated was whether Rollins was the source of the unauthorized disclosures to the Herald, in violation of department policy and her ethical 58 on the 16th of December, 2022, pursuant to the Inspector General Act, 5 U.S.C. 404, d. The OIG referred the false statements allegation to the department for a prosecutive decision. On the 6th of January, 2023, the department informed the OIG that it declined prosecution.
That's disgusting.
Obligations. Investigating violations.
That's disgusting. I mean, they should have the Biden DOJ was like, nah, we're not going to prosecute her. And they made the decision within weeks. They were going to, wow, oh my God. So the OIG, I think, only wrote this report because the DOJ didn't want to prosecute. I bet Biden was involved. How much do you want to bet Biden told the DOJ not to prosecute her? Come on. It took them December 16th. Literally, wait a minute. They referred her for perjury right away. Literally, and then they had more interviews with her after she was cleared on the perjury charge. Oh, come on. That's so gross. I bet the OIG was pissed about that. There was no senator, no representative, no one would do anything about this. I would have had hearings. Give me a gavel. I will be Congressman Towel.
Of department policy and ethical rules is a core part of the OIG's mission and, as described previously, Rollins's disclosures to the Herald reporter violated multiple DOJ policies, the government ethics standards, and her ethics agreement. Rollins's denials would, therefore, be capable of influencing the OIG's investigation into a matter confided to the authority of the OIG. Lastly, we find that Rollins knowingly and willfully made these false statements. In her 15th of December OIG interview, Rollins claimed that she was surprised when the OIG raised the topic of her communications with the Herald reporter and, therefore, during the interview she was trying to think of all of her interactions with the Herald reporter. Notwithstanding her level of surprise, we do not credit Rollins's testimony about the reasons for her answers on December 6th. We did not find credible that Rollins could have forgotten that she was the Herald reporter source and had no suspicion as to who the Herald reporter source was. The OIG interview with Rollins was voluntary, and Rollins was free to decline to answer any question, as evidenced by her decision to decline to answer further questions about the Herald leak and related topics until she had the opportunity to review her records. Instead of declining to answer the question, Rollins chose to knowingly deny she was the federal law enforcement source. Moreover, Rollins's contemporaneous text messages with the Herald reporter show that she knew that her communications with the Herald reporter were inappropriate and wrong. Specifically, in one text message on September 9th, Rollins requested that the Herald reporter source the information she provided to someone within DOJ with information who preferred to stay anonymous for fear of discipline or something like that. In addition, as noted previously, Rollins told us that her practice of sending documents to reporters by text message on her personal phone, as opposed to sending the documents from her DOJ email account, was because she wanted to hide that she was doing so. Given that Rollins clearly recognized the impropriety of providing this information to the Herald reporter, we found that she willfully made the false denial to the OIG for the purpose of concealing her actions. Ultimately, we found that Rollins violated Section 1001A by knowingly and willfully making materially false statements to the OIG. 3. Rollins lacked candor during her OIG interview concerning her communications with two reporters. In addition to the specific false statements to the OIG described in the preceding section, we found that Rollins lacked candor during her interview with the OIG concerning her communications with two reporters. Department policy states that department employees have a duty to, and shall, cooperate fully with the Office of the Inspector General. 59. A fundamental component of cooperating fully is testifying truthfully and completely when interviewed by OIG investigators. Although the department, unlike many 5928 CFR 45.13, see also Justice Manual 1-4.200, all department employees have an obligation to cooperate with OIG misconduct investigations in accordance with 28 CFR 45.13. Of the department's law enforcement components, does not have standards of conduct or a policy that defines lack of candor. The Merit Systems Protection Board, MSPB, in comparing lack of candor to the separate and distinct charge of falsification, has defined lack of candor as follows. Falsification involves an affirmative misrepresentation, and requires intent to deceive. Rachael v. Deputy of Transp. 782 F.2d 975, 977, Fed. Sir. 1986, lack of candor, however, is a broader and more flexible concept whose contours and elements depend upon the particular context and conduct involved. It may involve a failure to disclose something that, in the circumstances, should have been disclosed in order to make the given statement accurate and complete. It would be comparable to the distinction in the federal securities laws governing securities registration statements between an untrue statement of a material fact and the failure to state a material fact, necessary to make the statements therein not misleading. 60. In another case, the MSPB has stated that 2 elements are necessary to prove a lack of candor charge: 1, that the employee gave incorrect or incomplete information, and 2, that he did so knowingly. 61. We found that Rollins's testimony to the OIG was often incomplete and misleading, and sometimes contradicted by other evidence. We detail below Rollins's lack of candor when describing her communications with 2 reporters about matters relating to Suffolk DA Kevin Hayden. A. Rollins lacked candor when describing her communications with a Boston Globe reporter. We found that Rollins lacked candor during her OIG interview when she described how she learned of the Boston Globe's interest in the Transit Police misconduct investigation. We also found that she lacked candor when we subsequently asked her about her communications with the Globe reporter.
Okay. Having found a very interesting number of things, I'm officially willing to declare that we're going to resume this tomorrow. Do you realize how many pages we have to go? We have a lot to go. There is no way we are going to finish this tonight. We have literally probably 8 hours to go. We are going to pick this up tomorrow. I don't know how we're going to pick it up because we're not just going to start in the middle. I'm going to have to do a recap and then bring people in and then we'll finish. But this is fascinating. I hope you've learned a lot today. We can't do our traditional outro because it is literally like 2 in the morning and I'm very tired. What I do want to do, though, is say thank you to Harvard Yard and Chastity. Some of you actually stayed this entire time. I hear ice cracking is still here. Ladies and gentlemen, you don't know how impressive it is that despite the fact that it is 2 in the morning Eastern, I know it's 11 a.m. for some of you, it might be 11 p.m. for some of you. We have towel friends all around the world. You are still here. So Chastity, Sunken Grave, Beach Nance, Cookie Ramlol. I know 65 CJ5 was here. God bless you, dear friends. I really hope it gets pushed indeed. God bless you, Cookie Ramlol. Tell your local news. Tell the people in South Africa, or wherever you are, I will do interviews with your news stations. I will zoom in. It will be amazing. Leafly was here. God bless you. God bless you. Harvard Yard, you're a super towel. Oh, so many of you were hanging out for us. Oh, thank you again. Here is a medal of super chats. Awesome work, Grant. LMM, my fucking ass off. Epic of epicness. Love to all chowls. Cheers to those here 16 hours and rolling. Super chats can be had by air. Yes, thank you for flying air towel. Talk to the media, Grant. I will. Hello, Callie, Trish from earlier, Natalie B, Sunken Grave. Oh, my dear friend, Truth Over Bias. I will try to do a recap for you tomorrow, Truth Over Bias, as soon as I see you. God bless you, Harvard Yard, for supporting this stream. Christine, it was great to see you. Troy, oh yes, it has a lot to do with it, dear friend. It has a lot to do with it. Got a secret, you can keep it. I hope you have a great time. Not a great time. I hope you get through your doctor's appointment. I hope you had a great time with us. God bless you, friend. Stacy Gardner, it was great to see you pop in, my dear friend. Great to see you. Quite great interview the other day for what happened the day after, my dear friend. Quite a series of events indeed. All right. Yes, I agree, Chastity. I agree. Hank Brennan and I should get on some kind of adventure together to expose what really went down here. Oh goodness, Sunken Grave. He's still the chief of the criminal division. Well, he's a career prosecutor, so. Taterbug was here earlier. Oh, thank you for coming through, my friend. You know I appreciate it. Kerry Gold was here. Oh, ladies and gentlemen, I like this chat because I can actually go back to the beginning. Leafly JI5 stopped by. Diana Natale was here before bed. D Nice was here. I'll try to be live. I might not be with you for the dentist. It depends if I get my oil change done in time. Oh, Ann Mulcahy was here. It's so good to see you, dear friend. Oh, ladies and gentlemen, so Truth Over Bias, Leafly, Chastity, I'm so glad that you got your laundry done. Oh, Mandy Strong was in the chat. I missed a super lemon towel emoji because I was just working my little towel butt off. I just want to let you know that's like, so to see the little super towel lemon emoji like bouncing off his little butt to do a high five, I was working my butt off. I'm so sorry I missed that super towel spouse, Mandy Strong. Do you realize you're a super towel? Now, oh, thank you, Cookie Ramlaw. But did you know I can do this, ladies and gentlemen? I didn't used to be able to do this, but I can actually go through the super chats on the screen now because I am a super towel. So take a look at that. I want to say super towel thank you to Harvard Yard. Hold on, I'm going to get rid of this from the screen for a second. I want to say a super towel thank you to Harvard Yard. Maybe I'll start doing this more often to say hello to everyone who says thank you. Oh, this is really cool. All right, so really appreciate it, Harvard Yard. Here's a medal of super chats. Awesome work, Grant. Hell of my effing ass off. Epic of epicness. Love to all towels. Cheers to those here 16 hours enrolling. Super chats can be had by ear. Harvard Yard, good effing morning from 35,000 feet. Thanks for the late stream. Riveting. You are priceless and a gift to the MF world. Towel Ellis. Baptist Library proud. Loved all. Oh, Baps Library proud. Loved all tenacious towels. What the flying F. Damn straight. Thank you again. I hope you're sleeping, Harvard Yard. Mandy Strong. Look at that super towel emoji. Look at him. Look at him. He's jumping up and down. He's a super towel. Look at him. I'm giving him little head pats. Oh, it's 2 a.m. and I'm still having a day. Look at that little super towel. God bless you, Mandy Strong. I love it. I appreciate your super towels, honorary super towel spouse. And I love that little super towel lemon emoji. He's adorable. Just me. God bless you, dear friend. God bless you. Appreciate you so much. I appreciate that little olive emoji, too, or a grape. He's giving a high five. I'll give you a high five, little super towel lemon emoji. I'm going to miss you. You're both adorable. Oh, just me. I appreciate you so much. Jesus, Mary, Joseph, please start the X stream as you wish. Yes, we got it started. Please recap many joining X. I was happy to do multiple recaps. I'll do more of them tomorrow. Ladies and gentlemen, you are all super towels in so many ways, and Towel loves all of you very much. We're not doing our traditional ending because it's 2 a.m, but we are going to do this ending because you know I would be remiss. PK! You're an insomniac. Oh, I've been PK. I never stopped. We literally went one stream to the other. So this was almost 24 hours in a row. I think it was 18 hours or so. So one of our longest streams. Actually, ladies and gentlemen, we have to keep going for about, I'd say like 3 more minutes. Okay. Because if we do that, if we get to 3 more minutes, that will be 18 hours on the X. Okay. I think that's some kind of a record. That was fun. All right, so you know what I'm going to say, though. If you really benefited from this stream, if you learned something, if you thought learning about these Rachael Rollins documents was helpful, if you met some friends here today, if you got through a tough day, if your good day was better because you were here, you know exactly what I'm going to say, ladies and gentlemen, and fellow towels and towelettes and washcloths and soap dispensers and flannels and electric hand dryers and washcloths and towelettes. I think I said those already. And beach towels and hemp towels and microfiber towels. Look for reasons to do small acts of service, ladies and gentlemen. Look for reasons to pay forward what you experienced here. Look for reasons to show unconditional love to those around you. Yes, look for reasons to donate to homeless veterans, ladies and gentlemen. Look for reasons to donate to animal shelters run by veterans or animal shelters in general. Look for reasons to say hello to someone on the street. Look for reasons to call a family member or a friend you have not seen in a while, my dear friends. Look for reasons to be a guiding light, a beacon of hope in a world defined by self-interest and despair. I believe it's possible. Look for reasons to donate 200 tomato plants and have them designated honorary towels like Francis Rachael did one time. Look for reasons, ladies and gentlemen, to be a helper. I believe it's possible because of you all. Every single day, I try to come here and help you learn something. Even if my physical body is failing, I'm here with you. My mind is strong. And as long as I can sit, hopefully I'll be okay. So oh, PK. That is exactly what Little Towel would love to see. Look at that. First of all, Super Towel hugs to you, PK. I'm so glad you came in. I was happy to just see you pop up in the chat. And now I get a Super Towel lemon emoji shaking maracas. You don't understand. I could shake some maracas right now. I'm a towel. He's a little super lemon emoji. Oh my goodness, you don't understand. Did you want to make Towel giggle? That's exactly what we needed because guess what? He's going to be with us on screen, PK, to celebrate as we, for the first time ever, hit 18 hours on the Towel X. And technically, it's across 2 videos on the Towel YouTube. Yes, ladies and gentlemen, it may even be more than that. I'm not exactly I think we started at 8 a.m. yesterday. So yes, 18 hours, ladies and gentlemen, within 10 seconds. Are you ready for the moment? 10, 9, 8, 7, 6, 5, 4, 3, 2, 1. 18 hours. Congratulations, ladies and gentlemen. 18 hours. New towel stream record. Congratulations. I am a towel. God bless you for being here, PK, with me. God bless that little lemon towel emoji. That's exactly what I wanted on the screen as I broke the 18-hour mark. That was wonderful. That was a moment in history you don't understand. So I work for a division of Pepsi. Gatorade is one of our products, and we actually have a Gatorade towel. Every time I see it, I think of you. PK, I love that. You don't understand. I want people to see towels and just smile and be like, because towels are ubiquitous. That's a towel that makes me happy. I love it. Oh, Harvard Yard's still here. That makes me so happy. Oh, super towel hugs to every single one of you still listening. You know, Towel Friends on the X. We'll say goodbye to you a little bit earlier. I think I should lay down. I got to go get my oil changed in the morning. Towel loves you very much. God bless you. Be safe. Get some rest. It's longer than we normally go, but it was quite a night, and it means a lot to me that you were here. It means so much to so many of the Towel Friends, and I'm going to give you a super towel hug, Towel Friends on the X. Be well, be safe, God bless. My name's Grant Smith Ellis. See you sometime tomorrow morning. Let's say late morning, all right? I got to get some stuff done. Maybe I'll get a haircut. We will see each other tomorrow. We'll finish this Rachael Rollins analysis. Who knows what the hell else is going to happen between now and tomorrow? But I'll be with you, ladies and gentlemen. Maybe the super towel lemon emoji will be there with us to shake the maracas, and I will continue in my indefatigable state. But I got to go say hi to the Towel Friends on the YouTube for now, though, because they get a few extra minutes, because Towel Friends on the X, hello, PK again, because Towel Friends on the X, I clicked the wrong button. Towel Friends on the X get a few minutes in the beginning. All right, talk to you tomorrow, Towel Friends on the X. Towel Friends on the YouTube. All right, that was a long day. That was one of our longest streams we've ever done. You have a great night's rest if you can get it, PK. Same thing with you, Harvard Yard. If you're still on the plane, I hope we got you through your trip. All of you who are still watching, Leafly, super towel hugs to you, my dear friend. Leafy, I mean, we have had, I used to say Leafly a lot. It was a website that I used to read. Leafly, wonderful to see you, my dear towel friend. All of you get some rest. We earned it today. We did a very long stream. We learned a lot. We monitored. We had a lot of ups and downs. And now Towel's going to get some rest. You know how much it means. Like, I'm going to go lay down because I'm very tired. But I promise you, I'm invigorated because of how much we are able to cover together, how much time we get to spend together. It makes me feel less lonely. It gives me purpose in life. And I hope you found some friends here. And I hope you found some meaning here, because I certainly have. So know that you're special because you are you, Towel Friends, and I hope you feel special because you found this community. I certainly feel special because you're in my life. So, yes, good night. Chastity, super towel hugs to you. Thank you for staying to the end. See you bright and early tomorrow morning, friends, and by that I mean sometime late morning. I'll schedule the stream when I wake up, so you won't actually see a chat now. Let's take a little time off. I will schedule the stream when I wake up sometime after 5 or 6. Let's plan to go live in the late morning, early afternoon, unless all hell breaks loose, which it could. My name's Grant Smith Ellis. I love all of you very, very, very much. You are very special to me. Please be safe. God bless you. And until we see each other again in a few hours, be well.